Okay, we'll call the meeting to order at 4:06 p.m. Please call the roll.
Matthew Kate, absent. Lila Hood,
Present.
Vice Chair Josh Wolf, absent. Rishi Chopra, absent. Luam Tesfaye,
Present.
Luam Tesfaye, present. Chair Wolf,
Present.
Chair Wolf, present. Rodman Martin,
Present.
Rodman Martin, present. Frank Canada,
Present.
Frank Canada, present. Chris Hyland, absent. Matthew Yankee,
Present.
Matthew Yankee, present. And Fiona, 1, 2, 3, 4, absent, arriving late. We have a quorum. And agenda changes?
Yeah.
Agenda changes. I received word from Mark Sullivan at about 2 o'clock this afternoon. He emailed me to say that he got into an accident and was unable to make it to today's hearing. So I emailed him back asking if we could postpone his matters till August. I have not heard back, but that is my plan.
I closed my agenda by accident. Okay, any other changes or adjustments to the agenda?
Not to my knowledge.
Okay, how about members? We're going to take a 15-minute recess right after public comment, whenever that comes up. Okay.
Next item.
Yes, please call next time.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force June 5, 2019 meeting.
Any changes or adjustments to the, or comments on the agenda, members?
I have a couple little minor edits on the minutes. For item number 3, the ayes are missing a number.
Yeah.
Then for item number 4, first motion, the ayes are missing a number. Second motion, you have me listed twice as voting under the ayes.
Item number 3.
So item number 3, yeah, to start with, item number 3, the numbers are missed. The number of ayes is missing.
Oh, I see.
Yep. Under the fourth one, the first motion, number of ayes are missing. Second motion, you have my name listed twice.
Okay.
All right.
Thank you for
Thank
those
you for that.
comments. Should we vote on that?
Well, I would move to approve, Ned.
Okay.
Sure, second.
Okay, is there any public comment on the minutes or the changes to the minutes? Seeing none, can we take it by acclamation? Okay, seeing no objection, item is approved. Let's call next item. Well, it's not 5 o'clock yet, so public comments will wait till 5 o'clock.
All right, so call item number 4.
Item number 4.
Item number 4, file number 19017, complaint filed by Alika Vafi, American Asians Advancing Justice, Asian Law Caucus, Jeffrey Wang, Council on American Islamist Relations, San Francisco Bay Area, Alan Schlosser, Northern California American Civil Liberties Union of Northern California, against Catherine Whalen, Police Department, for allegedly violating Administrative Code Section 6721 by failing to respond to a public records in a timely and/or complete manner.
Okay. We don't have legal counsel here, but before we begin, because I had asked them to make an oral presentation about this, but it did get communication from them, and I'll read it verbatim. It was dated Monday, July 8th at 9:28 a.m. It's from DCA Peter Thoreen. Dear Bruce, I'm following up on your voicemail about the Attorney General's appeal regarding peace officer records. The Attorney General's appellate brief took the position that the appeal was premature because the trial court had not yet expressly required the disclosure of any records. Rather, the Attorney General argued the relevant trial court order only made certain findings and required the parties to meet and confer regarding pending matters. It appears that the Court of Appeal has agreed. There is a relevant docket which was entered on July 5th. Quote, the petition for writ of mandate and related request for a stay are denied without prejudice to refiling in compliance with Government Code Section 6259, paragraph C, after the Superior Court issues a writ of mandate or order directing petitioners to disclose documents, unquote. In other words, it appears that the appeal has been dismissed pending further order of the trial court. Please feel free to give me a call if you have any questions. Peter. So that means as it stands right now, there's, from what I gather, as it stands right now, the release of the records are as is, as was approved by the legislature, and there's no restriction on the release of those records. So it's important information because it will determine how we will make our determination or not, because any case law would certainly have relevance if we will go through this whole thing. When we get to the point of coming to make a motion, if we're still unclear, if our legal counsel is still not here by that time, then we'll make a decision as to how to move forward with this or not. Okay? All right. So since this is this came through which committee? This came through the complaint committee. So, Member Martin, do you have a opening statement for this?
Just brief background. It's a couple of organizations. They're seeking I think it's almost like a white paper or white document from the SFPD, who's been working with the FBI. And there's a crossover interest perhaps that the FBI has, and the SFPD is simply taking the position that they're not going to turn over the paper, and hence we're here. So
Okay.
I think that's if I misspoke, I'm sure they'll tell me. So.
Okay. All right. Well, let's get to it. We're going to hear from the petitioner, the complainant first. The way the process works, for those who don't know it, we will hear from the petitioner first for 5 minutes. If there are any, then I'll ask for any persons or witnesses to provide any facts or evidence on behalf of this first party, and then it'll switch to the respondent's side. Same process. The task force, the item will then be in the hands of the task force. Task force will be doing what we call discovery. We will be asking questions. We will be looking for clarification, make sure that we fully understand what is being asked for and requested and what the violation is, and also be responding to any responses from the respondent as to the reasons why there should not be a violation. After that, we will hear rebuttals. There'll be 3 minutes for each party. The respondent will go first, and the petitioner will have the last word. After that, the task force will then deliberate on a motion, and if a motion arises, we'll have public comment on the motion and then vote. And that's our complaint process. So we'll begin. Please state your name for the record.
Speak into the microphone.
Good evening, and thank you, task force members. My name is
The clock. Hold on.
Yeah, go ahead.
Javeria Jamil, and I'm with the Asian Law Caucus. Before I begin, I just wanted to say that the letter that Chairman Wolf just read out is not part of our records. So I'm wondering if perhaps there's a mix-up between our case and another case.
I don't think so. Let me just, can you stop the clock for a second?
What are you missing?
No, what I had just read was not in the file. So and based upon what I had iterated, she feels that it's not applicable to right?
Yes.
It's not applicable, right, okay. All right. Perhaps.
Okay.
Okay, it was what I had asked. I asked because of the condition that we're in nowadays regarding this, and had not seen the details of your case at the time.
Okay.
It just triggered me to let me ask, just to cover all the bases, so everybody knows. So whether it's applicable or not, everybody now knows.
Okay.
Okay.
Will we be getting a copy of that, or is that just for task force purposes?
We can forward. Yeah, it's absolutely public information.
Okay.
We can make it part of. It should have been part of the record, but
Okay.
it probably was my oversight.
Okay.
So,
Thank you.
okay. Yes, and we're going to continue.
Okay. So our organizations represent the Arab, Middle Eastern, Muslim, and South Asian communities that work and reside in San Francisco. I'll start by providing some brief context about why we're seeking this document, explain why SFPD's refusal to release the document violates the Sunshine Ordinance, and then address SFPD's claimed exemptions under the Sunshine Ordinance and state law. So, for context, there's a long history of the FBI and the Joint Terrorism Task Force unjustly surveilling and profiling our communities. For decades, we've worked with SFPD and the city to ensure that our communities are protected from the FBI's racial and religious profiling whenever SFPD works with the JTTF, which is the Joint Terrorism Task Force. A history of this can be found on pages 50 and 77 through 79 of your packet. The document that we are seeking is essential to our understanding of the relationship between the FBI's Joint Terrorism Task Force and SFPD. So in 2018, as a result of a general public records request, we learned of the document at issue here. We filed requests with SFPD to disclose this document under both the Sunshine Ordinance and the CPRA. But to date, 10 months after our initial request, SFPD has chosen to not disclose the document or even provide a redacted version. Instead, at the committee hearing on April 23rd, SFPD stated that the federal government would not allow the disclosure of the document. They did not provide any facts to support any of their assertions either. SFPD's refusal to disclose the document or provide any facts as a basis for their withholding violates the Sunshine Ordinance, which sharply limits the local use of state exemptions to withhold the documents like the one we're requesting. It is also in direct violation of the CPRA, so state law. Now to address SFPD's claimed exemptions, in their written response to the task force, SFPD relied on discretionary exemptions in state law to withhold the document. As a preliminary matter, these state law exemptions do not apply to the document we're seeking, and I'm happy to go into detail about this if you'd like. But more importantly, under the Sunshine Ordinance, these state law exemptions are either sharply limited or cannot be used at all. So first, SFPD has relied on CPRA 6254F as a reason for withholding the document. However, under the Sunshine Ordinance, SFPD must engage in a balancing test and has the burden of proving that the public interest in keeping the document secret is somehow greater than the public interest in keeping our communities safe from racial and religious profiling. And SFPD has failed to do so thus far. SFPD has also relied on the official information privilege in Evidence Code 1040. However, the privilege itself requires SFPD to prove that the document was acquired in confidence and to engage in a balancing test. Again, things that the SFPD haven't done yet. But more importantly, again, under the Sunshine Ordinance, this kind of balancing is not allowed as the sole basis for withholding a document. At the complaint committee hearing, for the first time, SFPD cited to Sunshine Ordinance Section 6727A and B as a reason for withholding. Before this, SFPD had not addressed the Sunshine Ordinance in any of their written replies, but these claimed exemptions also don't apply to the document we're seeking. So first, 6727A allows withholding of a document under a permissive state law exemption as long as the use of the permissive exemption is not forbidden by the ordinance itself. However, as I've already stated, the discretionary exemptions used by SFPD are not allowed under the Sunshine Ordinance. And 6727B doesn't apply at all because it allows withholding of documents only if disclosure is prohibited by law, and SFPD has not cited to any mandatory state or local laws that prohibit the disclosure of the document we seek. So for these reasons, we respectfully request that you find that SFPD violated the Sunshine Ordinance and compel SFPD to release the document to us. We also ask that SFPD comply with their burden under the Sunshine Ordinance and state law, and 1, describe the document at issue, 2, explain with facts which enumerated category under 6254F they're claiming as the basis for the exemption, 3, support with facts their assertion that the document was acquired in confidence, and support with facts their assertion that the public interest weighs in favor of non-disclosure of the document. Thank you for your time.
Is that it?
Yeah.
Okay, thank you very much. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent? 5 minutes. Recognize member Kate at 4:21.
Good evening,
Hang on,
Lieutenant.
hang on.
Okay. Lieutenant Catherine Walland with the San Francisco Police Department. I just wanted to address what the petitioner had brought up regarding the litigation surrounding this matter. They have a current court case which will be heard in the Superior Court on August 20th. So we are requesting that this matter be held over until we have a court order or a court decision in place. And I will restate our withholding sections. And I don't know if you want for the record the Superior Court number. It's 19-516706.
Repeat that again, please.
19-516706. So admin code 6727A states that a withholding under a specific permissive exemption in the California Public Records Act or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority, 6727B, and states that a withholding on the basis of disclosures prohibited by law shall cite the specific statutory authority in the Public Records Act or elsewhere. California Government Code 6254F allows SFPD to withhold records of intelligence or security procedures of a local police agency or any investigatory or security files compiled by local agency for law enforcement purposes. California Government Code 6254K exempts records, the disclosure of which is exempted or prohibited pursuant to federal or state law, including but not limited to provisions of the Evidence Code relating to privilege. Evidence Code 1040 provides SFPD with a privilege to not disclose information that is official information, which is information acquired in confidence by a public employee in the course of his or her duty and not open or officially disclosed to the public prior to the time the claim of privilege is made. It is a clear understanding between SFPD and the federal government that the document would only be shared if it was confidential. It was acquired in confidence. The federal government will not allow the public disclosure of that particular document. And just in closing, I request that it be put over until after August 20th to allow the court a chance to review their filing.
I haven't decided whether to continue it yet or not. Okay. Is that it?
Yep.
Okay, thank you. Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none. Members? Member Martin?
I have a question about the case that's, is there a hearing or what's going on August 20th?
What do you want to ask that point?
Probably Lieutenant. Sorry, I know you walked all the way back there.
Might be easier if you just sit up front. So.
That's
I don't know if anyone from the ACLU has information. I don't know. I don't speak for them, but I just confirmed with our counsel that there's going to be a hearing where the arguments will be made and
On this-
scheduled for, yes.
On this point,
matter.
exactly.
On this point,
The same
exactly.
facts?
The same facts.
The same documents at issue.
They have filed a writ in Superior Court regarding this issue.
So it's the same parties and the same documents at issue?
Same parties, same
Okay.
documents. So that's why I'm requesting that we allow the court to go through its process, and then if needed, we could come back, or
And that's in Superior Court in California. Do you know where?
I believe it's
Down the street?
this one, yeah.
Nope.
Yeah, the Superior Court, County of San Francisco.
Okay, thank you.
Member testify.
Member Martin, I mean, my concern would be that the Superior Court would say that the parties need to come to us to look at this issue. And so I would, at this time, prefer that we act in some way in order to give, whether it's a yes or a no, at least the petitioner will have some kind of an answer that from us, so that the Superior Court doesn't say to them, oh, you have to go to the Sunshine Ordinance first and get a final decision, then we'll weigh in. So I think it's important for us to act in some way in order to then have the Superior Court be able to take some kind of action, depending on how, which way we go.
I get that. So the Superior Court will essentially know what we've done.
Right, because I'm concerned they'll say you need to exhaust your other avenues to
okay.
get this document, including before us.
Yeah, this is not the first time that's happened. They will defer. They will first defer to a quote unquote lower court, so to speak, or a local process, because this comes up as a sunshine issue, including our authority for CPRA. They will first ask if there a local process. If there isn't a local process, then they'll take it up. So, yeah, Member LaHood.
Yeah, so it seems that the main document that we're talking about is a memorandum of understanding and an explanation of that. That would imply that there's some discussion of how these two entities will be working together. We don't know if there's information specifically about evidence or names that would need to be redacted, but it seems like that there would be information in here that could be presented even if other pieces of it need to be redacted because of investigations or evidence. And in the past, we have erred on the side of disclosure for whatever can be disclosed and not withholding the whole document.
Would you like to ask the respondent that question?
Yes, I'd like to ask the respondent that question. Would it be possible, I'll wait till she returns. Would it be possible to provide a document with sensitive information redacted?
No, the nature of the document and the manner in which it was provided prohibits us from disclosing it to any other parties.
So, are you seeking to exercise to withhold the document itself, or withhold certain information that's in the document?
The document says it's not to be disclosed.
That's not the same. It's what the law says first, not what the document says.
Well, the law that we're referencing is what I read earlier, and it's basically everything I have.
So you cited 6727A, and did you cite B? And B. Well, they both kind of apply to each other, don't they? I think. And did you cite another section? I think you cited another section.
6727A, 6727B, 6254F, 6254K, Evidence Code 1040.
Okay, thank you. Oh, yeah, Member Kate.
Are you saying that the memorandum of understanding is what I understand to believe one of the documents at issue? Are you saying that no MOU with any local agency in the United States is actually out there as a public record?
I am not saying anything about this document or what it contains. I'm saying that there's a document that was given to us. I'm not saying that it's an MOU. I just said that there was a document that was provided to us that we were not to share.
And this document that you're not allowed to share, does it say, so it says in the document that it's supposed to be confidential?
Correct. And so the last time I was here, you asked me to determine if the document did indeed have language on it that says that, and it does. I confirmed it.
What about in terms of weighing and the CPRA provisions you talked about in the public interest? What about 6724I of the ordinance that prohibits that kind of weighing test for city documents under this ordinance, where it says that no document can be withheld based on this balance of public interest versus other factors?
I don't believe that we're using the balancing. I don't think that the evidence code and the balancing are the same.
I thought I saw reference to balancing in the, but
The petitioner had mentioned the balancing test. So under, hold on, let me just get this out here for a second.
what specifically, if I may, about this document at issue implicates 6254F? I mean, or which provision of 624F are you specifically referring to with regard to this document?
We're referring to the fact that it allows us to withhold records of intelligence or security procedures of a local police agency or any investigatory or security files compiled by local agency for law enforcement purposes.
So specifically both intelligence information and security procedures.
That is the section that we have cited for the record, yes.
But that's the section you say applies to this particular
Yeah, everything
document.
everything I've read to you is what we are putting forth as our exemptions for this case.
Have you exercised 6727D as required?
Everything that I have, I've stated. Because we do have active litigation regarding this, so I'm not going to go outside of the statement that I've given regarding this.
But this is just, it's a matter of process.
Yes.
I mean, the process is...
We don't have a city attorney present. This is the information that I have.
The city attorney has provided us with their memorandum. I mean, we're going to go off of that. Generally, that they're sitting here, lots of times we don't ask them any questions because it's what they provided is enough. So, but 6727D is specifically just purely procedural. And what I'm focusing on is the suggesting alternative sources for the information if requested if available. Have you done that? Did the department do that?
I don't have information regarding that. The information I have is the information that I presented.
Okay, thank you very much.
If I may.
Go ahead.
Evidence Code 1040, I thought there was a reason why I was thinking about the balancing test. 1040 B2 specifically talks about weighing the public interest against the preservation of confidentiality. And so, I mean, I do think that that Ordinance 6724I is applicable here, because to use Evidence Code 1040, you've got to make that weighing. Is that not the way the department reads 1040?
I don't have any other things to present to you other than this. I don't have a code book with me. This is the information that was provided to me to present regarding this.
One more, are you aware of any act of Congress or other, that prohibits the disclosure of this document at issue? Any federal statute that prohibits it?
The only information I have is the information that so I'm not aware if there is or is not.
Let me ask, who would, in the department, who would have that information?
I don't know.
Come on.
The city attorney. I mean, that's who if we have a disclosure, that's who we go to evaluate. This is information that's been provided to me in consultation with our legal counsel, and that's the information that I'm presenting here today.
Okay. Any other questions for the respondent right now? Okay, thank you. Member Martin.
Yeah, I wanted to know if the action in Superior Court is, and I wouldn't imagine they are, but is the federal government is a party to that action in
I do not know.
Superior Court?
Know if they're aware of the Superior Court action?
I don't have any information. I just found out what the hearing date was today so that I can make you aware of it.
So is it, just one last thing, is it fair to assert that there's no way this document's going to be released by the SFPD unless there's a court order telling you to do so?
That's fair.
Okay.
Yeah.
Can we ask the complainant about the court? Do you have specifics on this court action that's happening in August? Could
Thank you, Lieutenant Waller.
Could you come up and you want to do?
So the court action that we filed against SFPD. The federal government is not a named party, and because the action is under state and local law, CPR and the Sunshine Ordinance, we're not required to name anyone except SFPD.
Thank you.
I have a question for you. So the respondent is not going to state what the document is, what type of document it is, whether it exists or not. How do you know that it exists?
So we filed a general public records request in September of 2018.
Is this a California under CPRA, under Sunshine?
Under the CPRA and
or
this...
Or FOIA?
No, it was a CPRA request. Okay. We have not used FOIA for any of this information because we're not required to use the FOIA. Okay. And that request is actually on page 52 of your packet. So as part of that request, we got some documents back. And then as part of the response, they refused to disclose the record that is in question right now. And that, SFPD response is on page 58 of your packet. And as part of the documents that we got back, one of the documents that we got was an email from Craig Fair, the assistant, the ASAC, FBI ASAC here in SFPD, saying that attached to this email is this white paper which provides clarification and understanding of the JTTF SFPD MOU, the Safe Cities Ordinance, and SFPD General Bureau Order. And that email is on page 88 of your packet if you want to look at it. So that email itself was given to us, but SFPD chose to withhold the actual attachment, which is what we're looking for now.
Member Kate.
And sorry if you said this in your initial presentation, but I was referencing earlier other MOUs, for example. Like I'm looking at the attachments on that email you just referenced, at 88 of our packet. There's an SFPD JTTF. Is that, in your understanding of the MOU, that?
Yeah, so we already have the MOU, the SFPD JTTF MOU, which SFPD had signed when they were part of the JTTF, is already actually public record. So that's not in dispute right now.
So
We're-
which one of these, or is it one of these attachments that you're still seeking, or is it some other document that's not in these attachments?
It is the one attachment that that SFPD withheld. So the email references just one attachment, and it describes what we think the attachment is, right? It says it's a white paper which provides clarification and understanding of these three documents: the MOU, which we already have, the Safe Cities Ordinance, which is already public knowledge, and the SFPD General and Bureau Order, which is also public knowledge. So those three are already public knowledge. This white paper purports to provide clarification and understanding of those three documents together. And that's the only thing that we're seeking.
And you've not been told, and I don't think I've seen it in our materials, that the white paper would be somehow attorney-client privileged or common interest privilege or anything like that as between
No.
the two agencies?
No.
Well, let's ask this question. What was their response to you when you requested this white paper?
So SFPD has been making the same claim that they made a few minutes ago, which is that it's exempt under 6254F and 1040A. And I'm happy to go into why those don't apply, but they don't. The state law exemptions don't apply as a preliminary matter, but even under the Sunshine Ordinance, even if they were to apply, the Sunshine Ordinance overrides those anyway. So.
Member Martin?
So that essentially, and correct me if I'm wrong, you think there's a document explaining the federal government's interpretation of these documents?
That's what
Correct?
we think it is, right?
Okay, and you don't know if the federal government or the FBI drafted the document in question?
No, we don't know any other information apart from what's in front of you.
Okay.
But I think the point is, right, like even if they did draft the document, because SFPD now has it, under law, like they're the custodians, they own the document, and so they are allowed to disclose it.
Yeah.
You're all looking at me. Okay.
I don't have any more questions. I don't know if-
Okay, thank you.
Okay. All right. Thank you. All right. Any other questions for clarification? Anything like that? Should we move to rebuttals? Okay. So Lieutenant Walland, you're up first for rebuttal. You have 3 minutes.
We don't have anything additional to add to what we've previously stated.
Thank you. Petitioner, you have 3 minutes rebuttal.
She knows. She's just getting.
She's getting advice. Okay.
Okay, thank you. So just to reiterate, there's a very strong public interest where our communities are concerned in the disclosure of this document for us. Again, to reiterate, SFPD owns this document and under law is able to disclose it. There is no reason for why they're withholding it. And additionally, they've cited to all these exemptions in state law and in the Sunshine Ordinance, but they haven't met their burden and haven't provided any facts as to why they're withholding this document or how any of the law is applicable to what they're doing. So again, I would respectfully request that you find that they're in violation and ask them to release the document to us. Thank you.
Thank you. Okay, members? Time to deliberate a motion. Yeah,
I
Member
mean,
Canal.
not being one of the lawyers on the panel here, I think that the document is a public record and should be released. If there needs to be redactions, the SFPD should redact the document appropriately and cite reasons why it was redacted. So, that's my feeling on it.
Member Martin?
No, I think I mean, I agree with Member Kanata. I think it's probably a public document. I don't know, and I'd imagine, I mean, the emails from an FBI special agent saying here's a white paper, and I understand the SFPD, I don't want, protecting that relationship or whatever you want to call it, but I still think it's a public document. I don't think no matter what we do, that it's going to come out anytime soon. But, you know, the Sunshine Ordinance is clear. I mean, public documents are public documents, and if there's redactions that need to be made, there's redactions that need to be made. That's where I am with it.
Anybody else?
And
Member
then
Tesfaye?
I just want to voice the concern, whatever that we choose to do here, I think that I would recommend that this item also be referred to compliance and amendments, because I want to make sure that, you know, I don't know where we're going to land, but if this document is ordered for release with redactions, for us to have an opportunity to follow up on making sure that the redactions were done accurately and precisely.
I would also add that in our order of determination, if we choose to take action on this, that we could also either make a recommendation or a request of the court, if we wanted to, as an extension. We don't have the authority to see items in camera, but a court does. And if we determine, you know, we can basically determine that it's the record is public. That's first and foremost. And if it is public, that it should be made available unless there's compelling the citations provided for withholding are compelling enough. And if not, we can then make compel the respondent to produce. If they choose not to and wait until, want to wait until the court date, we could put in our order of determination with knowledge that there'll be a court date. We urge the court to review in camera the document and maybe advise us back. And so that way it doesn't waste taxpayers' time and money to go through an entire possibly lengthy court case. They could send it back like they would to a lower court, with advice saying, yeah, I've seen this document, it is not what they say it is, or what it is what they say it is, and this is, how you should or should not dispense with it. It's advice from the court at that point. Yeah.
Yeah, I think that's actually an excellent suggestion, because it sounds to me like the respondent saying that the document itself is saying don't share it, but she can't show us the document that says don't share it. So it's kind of a difficult catch-22. So I really like your idea of having the court review those and then give us guidance based on what they see.
Yeah, because we've tried this before. We've tried to see if they would let our legal counsel see it in camera. They won't do that, even though it's an ethical firewall.
Right. They
They won't do it. And, the other way to do it is to send it over to the Ethics Commission, because they have an investigative, confidential investigative, but they may not do it there either, even though they have enforcement power. So they're somewhat quasi-judicial like we are. They're probably more judicial than we are, because they can invoke penalties and whatnot. So for you lawyers that have, done litigation before, what do you think about that? Is that something irregular? I mean, this is just my own logic. I'm not a lawyer, so.
Asking the court, basically stepping in a sense, and getting involved in the litigation effectively.
Well, there will be a litigation because they already have a court date, so there'll be a hearing. So the question, if we determine that the record is public, which we already have, we've already found jurisdiction, and it's public, if we continue to sustain that, and we invoke 6721 to compel the respondent to release the record, refer to compliance amendments, but then send a communication attached to the order of determination to the court, saying, can you please review the document, because we can't see it in camera, you can, and let us know, and then it can come back here, we can make a final determination. If the court says, yes, it's public and should be released, They don't need a court order.
But for something like that, I think we would need to put in a motion for party status in some way if we were going to make a request to the court.
Yeah, or you could do some kind of
Okay.
letter. I mean, there's no doubt that, well, probably regardless of either way, we voted on this today. But I think I think we're getting a sense of where we're going with this, and I think that there's a violation here, if nothing else, for failure to redact as much as there's a plausible argument for. But so regardless of what we do today, I mean, I'm assuming one side or the other will possibly notify the judge at either a status conference or some kind of briefing that this is just one other additional argument for their particular position. And it'd be good if. I don't think the judge would necessarily want to listen to us about whether and how he or she should look at the materials. I think the worlds are a little overlapping in a theoretical sense, but I think we should probably just kind of let them play out separately.
Okay.
There's not a requirement, though, that we have to wait. There's not a requirement that the petitioners had to come here first or have to wait until a court action is resolved once they've gone that route. I think we should speak as we want to as the task force. The parties, should do with what that information, whatever determination is, whatever they feel like, and it'd be great to be updated.
And the court will take whatever our decision is and weigh it against it. Okay. Member LaHood.
Not an attorney, but so this is not something that you think requires like an amicus brief or something like that, or just that our decision, whatever it is, will be used by the parties.
I mean, the parties will use it however they want to
They
use
don't-
it.
And we
Right.
step back.
Yeah.
Right.
Got it.
Yeah. Consider us as part of the judicial process. It's just we're the local administrative process, so to speak. Right? Okay. So I have one additional clarifying question for the petitioner. Have you received this quote-unquote white paper from any other public records request of any other federal, state, or local agency?
We've only filed a public records request with SFPD under the CPRA and the Sunshine Ordinance because state and local laws provide for more disclosure than federal laws do. And also, like I've said it again, we are not required to go to anybody except SFPD under the CPRA and the Sunshine Ordinance.
Have you ever received similar white paper before?
I don't think we've asked for a similar white, but we've always, in the whole time, in the past 20 years that we worked on this issue with SFPD, right? Like, this is an ongoing issue, the JTTF involvement. We've always directly gone to SFPD and asked them for the documents. And in the past, they've always been very open, and they've shared all the documents, no matter what the federal government has said.
That wasn't my question.
Okay,
Have you
please ask him?
received a white paper of this similar sort before, since you've been working on this for so long?
Right.
Have you? Is this the first time that you know about this quote unquote white paper,
Yes.
or is this kind of a regular practice among the two agencies?
This is the first time that we're seeing the white paper issue. Usually, the things that we've asked for have been things like the MOU in the past that SFPD had with the JTTF.
Okay, thank you. Okay, members, is there a motion?
Sure, I think I'll move that there's a violation of 6721 and then 6724 for the, is it 24 for the redactions or not?
6720.
67,
$67.27.
okay.
6724, let's see, that's personnel. 67.
26. 67.26.
Yeah.
Okay. So 6721 and 6726.
Second.
So moved by Member Kanata, second by Member Kate. I would like to add to that.
I would also like to add to that.
Go ahead, Member Tesfaye.
So, I mean, I would like to add for this item to also be referred to compliance and amendments, so we can get some follow-up. I have some concerns about level of redaction that we might see, and I just want us to be able to make sure that we close the loop.
I'm a little concerned about some of the responses we got from the respondent. I know that they had kind of a hard response to stop at, these citations, and that they weren't going to comment on even a description or characterization or category of what type of document this is. And upon some of the questions that you all have asked, including myself, am finding that possibly the representative is not knowledgeable enough, that there may be others that might have a deeper knowledge. The other concern I have is legal counsel. Since it's the SFPD is a city department, they're represented by the city attorney's office. The ordinance is specific about providing advice that would expedite a denial of production, providing arguments not to produce. So I'm a little concerned about that, and probably would want to hear as to why that is. So I wanted to throw that out there for if anybody thinks that that's worthy, any of those items are worthy adding to the motion.
Yeah, I don't know about the second item you were mentioning, but the first item, to me, it was clear from the respondents that they were here to tell us they weren't going to produce the document, and I don't know if it would have mattered who came. It just seemed, it was, right out front, we're going to wait until the court case, we're not going to produce the document. So I don't think a more knowledgeable person would have said anything different.
Great. Okay. Fair enough. It's just, we've focused on these items before when these kinds of issues come up. Okay, so we have a motion on the floor in violation of 6721 in total, or do you want? Is there a specific paragraph?
They didn't produce anything, so.
You want to exercise 6721
Well, B, they didn't comply with the request. They didn't produce the documents.
What about an E? Upon determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request.
Yeah, that's right, absolutely.
So B and E?
B and E is good.
Okay.
And 6726?
And
6726.
6726.
And then refer it to compliance and amendments.
And because E says a lot, that we also order the production of the document. Actually, we order SFPD to comply with the Sunshine Ordinance to produce the document. Or call it a record. And 6726, and then referred to Compliance and Amendments Committee. Okay? Mm-hmm. All right. Ready for public, shall we call public comment? Ready, okay, any public comment? These are for persons not party. Seeing no public comment, we ready to vote? Please call roll.
Member Kanata?
Aye.
Member Kanata, aye. Member Kate?
Aye.
Member Kate, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf, absent. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
I just kidded, but aye.
Okay. Member Highland, absent. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay. Thank you all. It is now 5 o'clock. We are going to take general public comment. Any members of the public may address the, why don't you read it? You don't mind.
Hello, members. I would
Hold
just.
on a second.
Hang on. Item number 3, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Please reset the clock. Okay.
Hi, my name is William J. Clark. I just want to mention something about something that occurred in the past. In the past, I requested a log from the San Francisco Arts Commission regarding their telephone calls that they received from the public. And I was told they didn't have any log and that they didn't keep a record of their incoming and outgoing phone calls. And I noticed, and I remember you all discussing the issue of phone calls from different commissions and departments, whether they were required to keep track of them. And I found in the new charter, the 1996 charter, section 6730, oh no, excuse me, not that one, section, let me get the right one here. Section 8.31 of the, it was in the Administrative Code, Section 8.31 regarding sound recordings. And in that, it said that the definition relates to telephone recordings between the public and government departmental agencies. And it says in Section 8.3-1, subsection 2, it specifically says that the police department and the fire department are required to keep their phone call communications for at least 6 months. And I believe the Muni was for a year. And then in subsection C, it said that anybody not mentioned in section B was required, any department not mentioned in section B was required to keep those phone recordings for a period of 100 days. And it says shall in there that any department not in subsection B shall keep those recordings for 100 days. And I believe that this is the administrative code section that requires all city departments to keep their telephone communications between the public and the department that has to do with any of their anything to do with their departments, that they're required to keep it. Specifically, okay, I have.
So I'm just going to respond to Mr. Clark here for a second. I just looked up Administrative Code Section 8.31. Is that the one?
That's correct.
It's been repealed.
It has.
Repealed in July 15th of 2018, retroactive to July 1st, 2018.
Okay, well, forget that then if it's been repealed, but has it been replaced by anything else?
No.
Okay, so...
It's just grayed out and says big letters repealed.
Okay, well, that's that. I wanted to bring that issue up to you because in the past, when I requested those things, because obviously it was in effect when I requested that, and I'm sure you've answered that in the past.
I'm sure we have. But
so
unless there was a pending case that was still open prior to that time, we probably couldn't act on it.
Right. I'm just saying, obviously, we missed that at the time.
Yeah.
Well, thank you for that.
Sure. You're welcome. Any other public comment? Seeing no public comment is closed. We are going to recess for 15 minutes. We will arrive back at 20 after 5. We are in recess. Please shut off the mics. 2. Microphones on? Yep. Okay, great. So recording started? Okay, great. Welcome our legal counsel, DCA Mark Price Wolf. Thank you. You missed an interesting case, the first one. That's all right. All right, let's pick it up with the next item.
Items number 5 and 6, file number 19031 and file number 19032. Mr. Sullivan emailed me today at 2 p.m. to say that he'd been injured while donating for blood and could not make it to today's hearing, and that we should postpone it. I notified the respondent, and the respondent is here for another matter. So everybody knows.
On both cases? One is for OEWD, the other one's for DPW.
Yes, yes, I emailed both.
Okay, great. So the request was for continuance?
Yes, continuance.
Continuance, okay.
And I believe it was his first request anyway, so.
Okay. Is there any objections from the other party, from the respondent? OEWD or DPW? Is there any issue with that? Nobody? Okay. Members, shall we? So let's get a motion in a second, and then we'll take it from there.
Move to postpone at the call of the chair, or?
Was there a date? Did he say what date?
He didn't say what date. I suggested August 7th because
Okay.
that would be the next task force meeting,
Okay.
but he hasn't responded to that yet.
All right.
so.
Yeah, let's leave it at the call of the chair. I'm not through
Okay.
working up the next agenda yet.
I'll second the motion.
Okay, so the motion is to continue items 19031 and 32 to the call of the chair. Can we take that by acclamation? It's not substantive. Seeing no objections, item is so approved. All right, let's call next item.
Item number 7, file number 18095, complaint filed by Sandra Weiss against Kevin Guy and Office of Short-Term Rentals for violating Administrative Code Section 6721 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, so
This was heard by the Compliance and Amendments Committee, and it was referred back to the task force because respondents did not provide the documents that were requested.
okay, so
Yes,
Member
so-
Kanata.
So in our order of determination, it was sent to Compliance and Amendment stating that the Office of Short-Term Rental should provide legal justification for redactions and provide unredacted documents. At the Compliance and Amendments hearing, the Office of Short-Term Rentals just stuck with their argument from the regular hearing, saying that the city attorney advised them not to hand over this information. Ms. Weiss again stated that these are now businesses, they're not individuals anymore, so that they shouldn't get the protection of individual personal information. And so we sent it back up here. We didn't have a recommendation, but, I mean, the Office of Short-Term Rentals just refused to do anything.
Okay, so so is there a recommendation? So at this point,
We did not have a recommendation.
Okay.
I know what my feelings on this are.
well, why don't you pick up from there and help us along?
My
what you think
feelings are, we had an order of determination. The department just refused to do anything about it, so I don't see any options for us except to move it forward to either the DA or the Attorney General. I mean, they came up with no new argument. It was just, this is what we decided to do, and your order of determination didn't change what we decided.
They have a different answer now. Should we ask them?
Sure, I think we
Okay.
should go through with the hearing.
Okay, well, we've already been through a full hearing, so
Okay.
this is just bringing it back
Right.
because there was,
And at Compliance and Amendments, Mr. Guy was not there either. It was, I'm sorry, I don't know, what? His colleague?
Mr. Guy's colleague appeared. Mr. Guy is
Right.
on leave right now.
Okay. And she is here tonight. also, I believe.
Okay.
Correct?
And
Yeah,
they're,
she's here tonight.
okay, and they're citing Administrative Code Section 41A.
They're citing the exact thing they cited when we found violations.
Okay, great. Okay, is the respondent here? Who is the, yeah, please come forward.
No, you're
That's
the
a complainant.
petitioner.
Oh, it's
You're the
complainant.
petitioner.
Want the respondent from short-term rentals. State your name for the record.
Good evening, Chair and members of the task force. Christine Silva, planning staff, on behalf of Kevin Guy, who's on leave. I also have with me Omar Mazri of staff to address any questions. Would this be the time to make our presentation?
Well, we're not, the presentation's already been made. There's no presentation to make. What I want to ask is if you've, if there's any other, have you come with a different response?
So at your May 1st meeting, you referred the matter to the Compliance and Amendments Committee, and in your order of determination requested that we provide legal justification for redaction or alternatively the unredacted documents being requested. And so on June 18th, the city attorney provided you an 8-page memo providing the requested legal justification. A copy of that memo is on pages 515 to 522 of today's agenda packet. At this time, and consistent with the advice given to us by the city attorney, we believe that nothing about the records request on which the complaint is based takes it outside the general rule that such private information must remain private. Indeed, for the reasons stated in the city attorney's memo, there are heightened privacy concerns in disclosing email addresses and telephone numbers regarding individual hosts registered under the short-term rental program, as well as concerns that disclosure of such information could cripple the program. Consistent with the longstanding opinion of the city attorney's office regarding privacy protections for email addresses and telephone numbers, and consistent with their advice to us regarding the redaction of such information from records produced in response to requests for registry listings, the Office of Short-Term Rentals believe we correctly chose to redact such information from the records it provided in response to the original request. And so we ask you to dismiss the complaint, but we're happy to answer any questions you might have.
Okay. So I generally, when you receive advice from your attorney, it helps you make a decision to, you know, I get a little concerned when people start saying, well, whatever our lawyer said, okay? What is the department's position on this? This is about what the department's position in how it's going to carry forward this issue for anyone else that makes a similar request. Has a policy? Is it now policy? Is it, I mean, how are you dispensing with this?
Thank you. Omar Mazri, Senior Analyst with the Office of Short-Term Rentals. We haven't created a new policy, but are relying on the policy embedded within 41A of the San Francisco Administrative Code, which continues to, and has not been amended since its inception for our office, to state that we would redact personally identifying information, but provide information to the extent possible, as we've done so already, to both the respondent and to the general public regarding short-term rental information.
No, you have to wait your turn until we,
It
the
is
way
our-
our process works.
It is our belief and observation in the implementation of this program on a day-to-day basis that providing this information would be of detriment to the ability to maintain our relationship with both our host and to effectively regulate short-term rentals.
So, I mean, how do you come to a conclusion that it would be detrimental?
So we have seen a pattern of records requests that would appear to sort of challenge the relationship we've built with both the host community as well as the hosting platform. So, for example, we have seen examples where we see the spouse or former spouse of a host requesting data about a short-term rental host, wanting to know what email addresses are being used to see if there's a new managing agent who happens to be somebody that they're associated with, trying to understand as part of divorce proceedings how much money is being generated by short-term rental operations after the couple have split. We have seen folks who contact us trying to sell very expensive labor employment posters at $85 a pop to our more elderly hosts who, in many instances, this is their first time operating a business. And so their inclination to interact with city government has often been circumscribed or challenged because this is their first time operating a business, first time working with a local government agency. They're more comfortable knowing that there's a bit of privacy, especially given that while it is a commercial business operation, it is occurring within the confines of their own home. And so when folks contact us to submit applications, one of the questions we often receive is whether this information will be made public, how much their rent amount is, how long they've lived there, who else is living in the house, and that sort of thing.
Okay. Any other questions? Member Martin?
Yeah. I think you guys were, or sorry, Mr. Guy was here on May 1. We found a violation. I think we actually discussed 41A at length. Doesn't include phone numbers or emails in the section. And is it your position you're still relying on that section for not producing phone numbers and emails?
That is correct.
We also rely on the state code for personal or privacy protections for personal email and addresses.
What, and are you citing a section for that?
Yeah, so in the memo, let's see, on page 2 of the city attorney memo, it's page 516 of your agenda packet. There cited is California Government Code, section 6254C. Disclosure of personal, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of personal privacy.
So, I mean, this is a business record, right? These are businesses that are operating, correct? The short-term rental properties? And that's something you're comparing to medical record privacy?
We're just talking generally about general protections.
Page 5 what?
516.
16.
516.
I mean, I appreciate that the people on the registry probably didn't anticipate that their phone numbers and emails would be subject to disclosure, but that doesn't change how the 41A is written. And again, it's a little frustrating that you guys are back here and didn't adhere to the order of determination. I just don't know how you guys get around this.
I want to interrupt you for a second. In the memo, it says 6254. I'm sorry, continue.
Our understanding was that at that May 1st hearing, your order of determination was to provide legal justification and or the unredacted records. So we met that by providing the legal justification with the memo.
Right. Yeah, I would have to concur with Member Cates' reading of the law. 6254, except as provided in sections 6254.7, 6254.13, comma, this chapter does not require the disclosure of any of the following records. C, personnel, medical, or similar files. I don't see how this information is similar to personnel or medical. I mean, that is specifically kind of talking about employees and medical information related to the employees with regard to like healthcare plan and things like that. So I'm not inclined to agree with the city attorney's interpretation or use of that, actually. I think it's a reach and incorrectly cited, at least from a lay person's perspective. We have 3 attorneys here. So, you know, and on top of our legal counsel ourselves. So, yeah, Member LaHood.
I have a question. So I do appreciate the concern you have for people who might not be savvy business owners. This is the first time they're doing it. Mm-hmm. But knowing that there are protections for access to public records, have you tried to do other things to help some of these people, like maybe explaining to them that they could create a new email account or a Google Voice phone number or other things that might, warning them about the solicitations they're going to receive about the posters. I mean, I get those. And the first time I saw one, I didn't know what it was, and I had to figure it out, and I did. Have you considered putting together a packet of, if you're a first-time business owner, you might want to consider doing these things. Keep in mind that what you put on this application is a public record.
So we have not done so because since the inception of the program, we haven't had to release this information. There are limited opportunities for folks to get a sense of where hosts operate their businesses. So for instance, in certain neighborhoods in the west side, we have to notify neighbors within 300 feet, and we put their name on the letter. But we tell those folks in advance, we're going to put your name on the letter we send to neighbors within 300 feet. But we don't put down their phone number or email addresses. And so if we were in a place where we have to let people know that their information has been released, of course, they would probably operate from a standpoint of creating a separate phone number or creating a separate email address that is more akin to setting up, say, an LLC for their business. But because we haven't been at that point where we've been forced to, because we've been operating under how we've interpreted 41A, we haven't had to spend additional time working with folks to educate them on.
You need to speak into the microphone.
I'm sorry. We haven't had to spend additional time educating folks on taking those additional steps that you referenced.
So it's unfortunate that it hasn't happened yet, but it could happen, and so it is something that could be done going forward.
It is possible, if necessary, to educate folks about what they're going to be what information will be exposed, and then steps they could take. It is a balancing act because we're trying not to overwhelm people who, like I said, I mentioned this is the first time running a business. In terms of getting business licensing, dealing with property taxes, business personal property taxes, hotel taxes, and then registry through our office. And so we're trying to keep the program as sort of flat and simple as possible, combating a substantial amount of fraud, but also working with a lot of eligible hosts as well. And the anonymity that people enter into the program with has made them more comfortable to give us information to a degree.
Member Yankee.
Yeah. If I recall from the last time we discussed this, that someone here, I believe, looked up business licenses and found that they have, all the information that is being requested here. And so I guess I still struggle to figure out why those are all disclosable, but you're somehow special. I don't see a particular citation in anything that talks about why this particular program deserves some special type of treatment, whereas, let's say I just ran like some type of, mail order business out of my own home and registered a business license. Well, obviously all that information would be out there. So I guess that's where I'm struggling here, why this is such a unique case, because I'm not seeing that.
And I appreciate that question. I think an important distinction is when anybody goes to the SF Open Data website and looks at business licenses, they're not going to get the phone number or email address of the business owner. They could probably gain a sense of whether they're running a short-term rental business, because if you see a business license for accommodations as the business category or the TOT, hotel box, checked, they're likely, and it's in the Outer Sunset, for instance, it's probably a short-term rental, but not necessarily. It could be a motel on 48th Avenue. So what I'm getting at, just to round back up, is while some information is made public of business licenses, the information being requested here is not provided by the tax collector, and from what I can tell has not been provided in similar fashion for other businesses, say a florist or a shoe shiner, in terms of their email addresses or phone numbers. So it seems like something is being specially asked of this type of small business operator that is not being asked of other small business operators in the city.
That doesn't necessarily mean that you're talking about the same class.
Correct.
Because there's the whole class of, say, small craft sidewalk artists. They have their own section of law that has a whole, all kinds of different set of requirements. So you can't put everybody in the same basket, not in this city, okay? And, frankly, what concerns me a little is this issue has been such a hot topic for so many years that this is what started our tech boom, was Airbnb. So I'm a little concerned that how people would not know that, these laws were going to get into effect. It's been in headlines left and right. So I'm a little concerned that people going into this business, would be, unknowledgeable about it and would definitely put up some sort of legal, response to try and not have the information recorded back. I did want to say that still rereading through your legal counsel, the city attorney's response, they cite, I don't know, you guys got to, I read this with me, I guess, I don't know. On bottom of page 15, it says, following the example from the Public Records Act, Sunshine Ordinance also recognizes that, quote, private entities and individuals have rights to privacy that must be respected, unquote, while maintaining the Act's general privacy exemption. And then it cites Admin Code 6721K, which is the ordinance. And under 6721K, it doesn't even talk about that. 6721K says the release of documentary public information, whether for inspection of the original or by providing a copy, shall be governed by the California Public Records Act 6750 et sequitur, in particular is not addressed by this ordinance, and in accordance with the enhanced disclosure requirements provided in this ordinance. So I'm a little bit confused as to whether your legal counsel has provided you with adequate counsel, because somehow it's not kind of jiving with what the law currently is, unless that statement was meant to be implied in some way. I don't know how else to read it. Maybe somebody else who's a little better at legalese can help me out with that. And the other thing I'm concerned about is when we talk about personal information, when somebody pays their property tax, it's a one-on-one relationship between the city and that person. So that personal information is one thing. It's another thing when somebody's doing business and they have a clientele that must, provide certain information. And then the city has laws with regards to the production of information about the business that they're doing. They may have information that might be withheld about the entity themselves. As you were stating, the entity may not on the website show their phone number or what have you. The city does have a policy not to post certain things on the website, but that must be revealed in writing on the hard copy. So there's a difference between what's posted on the web. The web is considered somewhat secondary to the actual hard copy record, the original record.
I'm sorry, you're referring to the hard copy of the 41A section we're relying on, or something else?
Well, I'm referring to the information that the requester was requesting.
Okay.
Okay. So if the information they were requesting, it exists on a piece of paper somewhere, right?
It doesn't necessarily, because we're going through large batches of applications and then having hosts drop out on a daily basis. We don't maintain a printed record of registry of hosts.
How are those? Yeah, but either way,
we store them electronically.
Right. So somebody applies for the application online?
Yes.
Okay. So the information is there. Okay.
Yes.
Your choice of redacting it is for public consumption on a website, which is different. Okay. The information that was taken at the intake, the actual application, the information does exist. And if a printout was requested of that application, there may be, I don't know, it's not clear to me yet whether that must be revealed or not. But in many other areas of the city and their departments, that information is wholly available. But maybe, like for instance, in the planning department, there may be certain information about a project on the website for public consumption. It may have certain things redacted, so it can't be scraped like by robots, right? That kind of thing. But if you go into the planning department and you ask to see the document, all that information is there. It's not redacted. Why? Because it's public information. It must be revealed. So they're two individual production of records is what I'm trying to get at here. Whether I don't quite haven't come to a conclusion about that yet with regards to this particular section, and that I think that's what we're trying to get down to. Anybody else? No. Okay. We've given you plenty of time. I'm gonna give the petitioner some time if there's some statement you want to make or rebuttal.
Thank you. I appreciate it. So there was no new information presented in the memo that was delivered on June 18th, just before this committee met, by the way. So there was no time to even look at it or digest it by me or the committee. But I did review it since then, and it's nothing new. It's nothing new from when you were presented and you made your decision. It's the same arguments, and frankly, they're sloppy and they don't apply in most cases, to be honest with you. So I hope that this committee is going to be respected and will be able to fulfill its mission. This department is just blatantly disregarding your decision. And I don't want to belabor the point. So I hope you'll try to enforce it.
Thank you. Okay, members, what should we do? You have a recommendation?
Yeah, I agree with Ms. Weiss. I mean, I don't. The city department is interacting with people who are running businesses in San Francisco and have not taken the extra steps to make sure that those people running these businesses, whether they're novices at it or not, realize what they should be doing to safeguard their privacy. So these businesses shouldn't be treated differently than any other business in San Francisco. So I think we have to send this up to the district, to someone to have the department fulfill the order of determination.
I would just,
Member Martin.
yeah, thank you. I would just add that I think I kind of understand the predicament that the entity is in if people filled out the application assuming that their email, however wrongfully, or phone number wouldn't be disclosed, and to notify the people that, well, that's not the case, and you might opt out or whatever else, or a time to remedy. But I just, the code section I just don't think applies that they're relying on, and I don't think they can redact the information the way the statute's written.
Okay. So we have an order of determination. We asked for them to comply under the determination that we had. Well, let's put it. Let me rephrase that. We had asked them to provide legal justification for redaction. It didn't seem to muster a different response from the Compliance and Amendments Committee. The question is whether we continue to hold that same position at this point, and what do we want to do next?
I think that the previous time we met, I think Member Kate made a motion. I seconded the motion. I would. Do you remake the motion, and maybe send it to ethics if they're not going to if they're not going to comply? That might be problematic since they did apparently, attempt to show that they didn't have to comply with the order. But I don't know. I mean.
And I've stated my feeling, but we've had I think this is the third issue in the last maybe 6 months where a department refused to comply. And the other two we sent up to the Attorney General or the District Attorney. I think we have to be consistent on how we handle these things. I mean, otherwise all the departments are just going to say, the heck with it.
Waiting for a motion.
I make a motion, this goes to the district attorney. ordering the department to comply.
Second.
Okay, moved by Member Kanata. Second by Member Kate. Any further debate on the motion? Is there public comment on the motion? Seeing no public comment, are we ready for a vote? Okay, please call the roll.
Member Kanata?
Aye.
Member Kanata, aye. Member Kate? Aye. Member Kate, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Thank you very much for attending. Please call next item.
Item number 8, file number 18059, complaint filed by William J. Clark against the Arts Commission for allegedly violating Administrative Code Section 6716 by failing to make meeting minutes available in a timely manner, specifically referring to the June 5th, 2018 Advisory Committee of Street Artists and Crafts Examiners.
Okay, so this was heard in the complaint committee on June 5th. Task force moved to include D.C. Baumgartner's memo drafted on behalf of the Arts Commission into the file. We had asked them, Ms. Tricky, attend the today's meeting. And that the Committee on Street Arts and Crafts Examiners is a policy body and not enumerated in the charter. Okay. All right, so the matter here is to, we're going to pick up on this point now that we have this information. I believe we have we have from our legal counsel on this. We had a memo that was forwarded to everybody. It should be in the record. We did find that this was, in fact, a policy body, so now we need to make an order of termination, I believe. So so unless there's any other further clarifying questions or information you may need, or this would be the time to make a motion. Or not. Or to find that there's no violation. Well, I'm. The question is, I mean, I'll give you a few minutes.
Thank you.
But I'll have to give
you.
the other party a few minutes too.
Thank you, I appreciate that. Because I was unable to attend the last William J. Clark.
Yeah,
Just a
1
moment.
minute.
Okay.
William. No, I'm just gonna I'm just gonna give you a few minutes to
Thank
make
you.
a point. We've had a lot of testimony. This has been through it. We've got lots of information. The information is pretty for us. I think, at least for me, is conclusive. I don't know about anybody else, but I mean, unless it's something
Well, it's something.
more pertinent.
It's something.
Okay.
I'd like to, I read the minutes of your last hearing, which I wasn't able to be here because of health reasons. And I noticed that the Arts Commission representative gave you some false information. She said that this matter was based on whether or not the fact that the minutes weren't posted within 10 days, that was the basis of my complaint. That wasn't the basis of my complaint. Basis of my complaint was that the draft minutes of the meeting were not made available to me after 10 days of the meeting, and I was told that they were just doing minutes as a favor. And she also made the statements that the meetings of the Advisory Committee of Street Arts and Craftsmen were not recorded. That's false. Those meetings are recorded, which I think are relevant to your decision of the last meeting. I actually have the recording from the meeting in question, the 6/5/18 one year, and I have 9 other meetings which I've requested in the past of the advisory committee. And I realized that there was a distinction made of minutes and a record. And the Arts Commission is saying that they're only required to keep records, and therefore they were not in violation of 6716. Well, as I sent to you in my email, I sent you a copy of the minutes of this particular meeting, which were much more extensive than just an initial record. Of that day. And for the past 40 years, the Arts Commission has kept minutes. It's the policy of the Arts Commission to keep minutes, not a record, and those minutes are extensive. And even as a matter of fact, at the beginning of this meeting, the Arts Commission actually stated in there that several things, including that a public speaker could submit a paper with 150 words on it, and that would be included in the minutes. That was stated at the very beginning of the meeting. And so if it walks like a duck, quacks like a duck, and it's a duck, the policy...
But wait a minute, Mr. Clark. I mean, they were under the impression prior to this hearing that they were not a policy body.
That's correct.
So they were acting in the way that they had thought they would be. There would be no way to retroactively to do that. The fact to retroactively.
You're confusing me now. I would like to just finish my thing because then I'd be glad to listen to anything because it takes me off my train of thought. Because what I'm saying is that the policy of the Arts Commission is to keep minutes, just like the policy of this body is to keep minutes. Now, you and the screening committee of the Arts Commission were ballot measures passed by the voters. You've chosen to keep minutes, and the advisory committee has chosen to keep minutes. And just like you're not enumerated in the charter as the city attorney has clarified, therefore this body is not required to keep minutes, but you could just keep a record of who votes and the issues, the statements that were given to you by the city attorney. But you choose to keep minutes. Just like you choose to keep minutes and keep a recording. The screening committee, the policy of the Arts Commission has been, at least until this last hearing, that they keep minutes and that they post those minutes and that they have a recording. You all got into the issue of what is a timely manner because you came to the realization that, okay, this is not required to keep minutes. They're only required to keep a simple record. And you asked, well, if they said, well, what's a timely manner for them to provide this information to the public? And you made the statement that if there was an audio recording of the meeting, then that audio recording should be provided to anyone requesting information about what happened at the meeting. If they're not going to provide the actual minutes, if an audio recording was taken, then somebody asking for...
Okay, Mr. Clark, I'm not going to let you go on and on because we've heard this case pretty extensively and have done quite a bit of work on background on this.
I appreciate that.
Okay.
Can I make a closing sentence?
Okay.
So therefore, all I'm saying is that since their policy was that the charter says that the Art Commission cannot change its policy without a public hearing. There has not been a public hearing on whether or not to change the Art Commission's policy from keeping minutes and recordings and making them available pursuant to the Section 6716 of the Sunshine Ordinance. There's been no public hearing to change that policy. At the last meeting, you were told that we're going to have a new policy now of no longer keeping minutes and only keeping a simple record. And therefore, I would still request that you find it a violation, because the policy of the Arts Commission, just like your policy, is to keep minutes and recordings of your meetings. Thank you.
Ms. Patterson, I'll give you equal time.
Kate Patterson, Director of Communications for the San Francisco Arts Commission. I don't really know what Mr. Clark's talking about a policy to keep minutes. I mean, we do for our subcommittees, but this is, as we've discussed previously, sort of a different composition than our standard full commission and subcommittee meetings. So I don't think it's correct to say that it is our policy to keep minutes and recordings. I did ask Ms. Trickey, who, as she explained in her letter, is not here today, specifically about the recordings. And we do make recordings, but we don't post them on the website. They're just additional records that are available upon request that in the past have served to support the record, and I think it's a tomato situation, but the record as we defined at the last hearing was just establishes which votes were taken and by whom, et cetera.
So action minutes.
Action minutes. Okay. So I have nothing further to add. We put forward the memo from our city attorney, and so we will let that speak for our position.
Okay, thank you. Mr. Clark, what I'm having trouble with is I'm looking at your intake form for this, for bringing this complaint forward of June 25th, 2018. And it was very simple. It says on June 22nd, 2018, after I requested the draft minutes of the June 5th, 18th meeting of the Advisory Committee of Street Arts and Craft Examiners, the Arts Commission failed to provide me with the draft minutes more than 10 working days after the meeting. The Advisory Committee of Street Artists and Craft Examiners is a policy body. Therefore, the draft minutes are mandated by Section 6716 of the Sunshine Ordinance to be available on request no more than 10 working days of the June 5th, 18 meeting. It's timeliness only.
That's correct.
Okay, so I'm not following what you mean by one type of minutes versus another type of minutes.
Well, at the last meeting, and in the city attorney's memo, he advises you that because they weren't, the screening committee is not a commission or a department enumerated in the charter, that they're not required to keep minutes. They're only
a passive meeting body, you mean?
No, a policy body.
No, a passive meeting body is not required to keep minutes.
No, he said that because they were not enumerated in the charter, that they're not and that 6716 only refers to boards and commissions, boards and commissions, I believe, that are enumerated in the charter. And he said because the advisory committee is not, therefore it's not required to keep minutes as established by the Sunshine Ordinance. And I agree with that opinion at this particular time. Mm-hmm. And however, I'm just saying that they chose to keep minutes. They chose to record it. Just like this body is no different than the advisory committee. You were established by ballot measure, but when the new charter came into effect, you were no longer, the Sunshine Ordinance was no longer a charter amendment. It became published as an ordinance. And so therefore the task force itself, using the city attorney's same legal opinion, is not bound to keep minutes. But all I'm saying is if you choose to keep minutes, then you should be required to follow the Sunshine Ordinance
So
regulations.
you're citing precedents.
I don't know what you mean.
So the
what-
practice that a body has
Okay.
been using for many, many years that they should continue to use that unless there's some specific action not
And,
to.
well, I'm saying they can change it. However, when I made my complaint that their policy was to keep minutes, that was to record it, and that you were misinformed at the last meeting because you were told no recordings were made. And you got into the timeliness of, okay, now we're going to scrap this meeting minutes stuff, and we're going to say they have to provide this timely record. How do we decide? And you even said that if they kept recordings, then that would be within a reasonable period of time to offer that recording to someone, not to make them wait more than 10 days.
If I recall, though, the elephant in the room was to determine whether this was actually a policy body or not, to determine whether they were required to keep minutes.
That's
and
correct.
The fact that, and so the purpose, our purpose of investigating that and making that determination that it's a policy body was, in fact, they should keep minutes. How they keep minutes, in what format, where they keep, all that's a completely different question. That's not before us.
Yes, no, you decided at the last hearing that the advisory committee was not required to keep minutes because of the city attorney's memo.
Right, but I'm saying is that if they choose to keep minutes,
that's correct.
Right, if they self-impose it like we do,
right,
okay,
right,
then. Right, so that's what I'm talking about. But
Okay.
the type of it sounded like you were saying earlier that you were concerned about the type of minutes.
No, I'm saying that
Okay.
trying to make the distinction between minutes and a record, because that's what the delineation was made by the city attorney's memo. And he said that the advisory committee was not required to keep minutes. Therefore, the Art Commission didn't violate 6716 when I made my request. And all I'm saying is that they can change their policy in the future if they choose. But at the time my request was made, and for the last 40 years, the advisory committee has kept minutes. It's labeled on the website as minutes. I gave you a copy of the minutes, which is very extensive, and they recorded the meeting, yet they didn't provide me with that recording or even tell anybody they have recordings. And so I'm saying they chose...
Have you received recordings of this meeting before?
I have. I just said I have 9 different meetings with me right now,
Okay.
and I have many more at home.
Okay, so let me ask Ms. Patterson a question, if you don't mind. So was there some change in this last meeting, in this particular meeting of, was it June 5th, that he was asking about that was departed from your usual practice?
Not that I'm aware of.
So was
I'm not aware of a moment where we changed a policy.
Okay, so was the same set of minutes and the same recording made for that meeting?
I believe so. I think that it's possible that the record minutes or what's the term that we're using?
Action minutes.
Action minutes were less detailed than they had been in the past.
Is there a reason for that?
It could be because, like as Ann Trickey noted, that there's staff capacity. We're also not required to do extensive, minutes. So. I think that given the staff capacity and given what we are required to do, I think perhaps that was evaluated and, we did what we could do and what we were required to do.
So, but there are minutes available for that meeting.
I believe that I showed them last time. And I'm very open to going back and looking at previous minutes on the website.
What about the recording?
The recordings we don't post on the website.
I know, but obviously he's received recordings, he's just waived a bunch of CDs.
Yes, by request we do provide them, as a record.
And do you have them? Do you have that recording?
I believe we do,
Okay.
yes. I
Okay.
did ask about the recordings, and I was told that they are recorded, again, as a reference for, the staff, and they are available upon request.
Okay, thank you. And Mr. Clark, do you now have the minutes and the recording of that meeting?
Yes, I now have the minutes of that recording, but that was after more than 10 days
I get that.
after
So
I
we're-
requested them.
Right, so again, we're focusing on timeliness here.
Yes,
Okay.
exactly. That's the violation.
Great. Member Canada.
So I'm thoroughly confused now. Okay, I thought we decided this was a policy body, and if that was the decision, they have to adhere to 6716 and keep minutes in that format. So Mr. Clark just confused the heck out of me by saying, by saying he didn't think it was a policy body now. So,
No, he's saying that it is a policy body, but if you read the first sentence of 6716, the clerk or secretary of each board and commission enumerated in the charter shall record the minutes for each regular and special meeting of the board or commission. So it's board and commission. It's not necessarily, it's not policy body. Okay?
okay.
This is a committee, an advisory committee. It's not a board or commission. The word advisory committee appears, and it's not necessarily a part of the definitions, because otherwise it would actually say policy body.
Okay.
The ordinance is pretty clear on that. Member Yankee?
Yeah, I recall exactly what you were saying, that we decided it was a policy body, but it wasn't a board or commission enumerated in the charter. And since 6716 talks about specifically boards and commissions enumerated in the charter and imposes the 10-day limit specifically on those, the fact that it's just a policy body and keeps, I think, record of proceedings is what they were calling it specifically. I don't see how 6716 and the 10-day limit applies directly to what we call the action minutes or the record of proceedings.
Yeah. Like people finished reviewing, everybody's got their heads down in the documentation.
So if 6716 doesn't apply to policy bodies, the whole argument is precedence, that this policy body in the past has had their draft minutes ready in 10 days?
Yeah, well, the question is whether they are required. Now the question is if 6716 does not apply to them, are they required to follow 10 days?
Right, according to what part of the ordinance. If it's not there, then they're not.
So is there a motion?
But they're still required to provide public records.
Public records,
Public
but
records.
it doesn't necessarily mean a recording of the meeting.
Right.
Okay, it's somewhat of a kind of a weird thing to be a policy body and make deliberations and decisions that are substantive and not to have a record. The fact of the matter is they have been providing records, and they continue to provide records. They may have changed their format from being there'd be narrative, not verbatim, but narrative, where they will give some paraphrasing of like what we do, okay, which is basically narrative type minutes. For that meeting, they've changed it to action minutes, which just notes the motion and the votes. Member Yankee.
Yeah, I think you brought up a good point earlier when you went back to the original intake form, where Mr. Clark specifically talks about 10 working days after the meeting. I believe he referenced that 2 times in his intake form. And I just don't see, I think it's a timeliness issue that we're debating. I don't see how the 10 working days applies. Just because they gave more detailed minutes doesn't mean that they suddenly, in my opinion, imposed a 10-day limit on themselves. It just means their record of proceedings contained more information than perhaps required. But I don't think that somehow now, because they had included more information in the record, suddenly self-imposes a 10-day limit. So I don't.
Okay, so I just want everybody to be clear. This is a very important kind of determination that we're making, because this will now set for any other types of bodies of a similar, color and shape. Okay, that we be consistent moving forward. So we're making a determination. This is a somewhat in a general type of determination, because it could be any other body that was created in the same way, that is also a policy body, but is not enumerated, so on and so on. Okay? So I just want everybody to be clear when you make a motion on this, that this needs to be remembered and somehow recorded in a way that when other cases like this come up, that it's referred to. Member Kanata.
I mean, it seems to me that not including a policy body might have been an oversight, because policy bodies do make substantive decisions. But since it's not in the ordinance, how do you find a violation if they're not required to do this by the ordinance? And having said that, then setting a precedent like that for policy bodies, I don't know. I mean, it's.
Yeah, I think we talked a little bit about that, and I think we talked about 6714, and if you go back and forth between, like, for example, A, B, and C, it actually flips back and forth between using the verbiage policy body and board or commission enumerated in the charter. So because certain sections elsewhere in the Sunshine Ordinance seem to reference them separately, I think we have to take this exactly on face value and say that 6716, because it says enumerated in the charter, that's specifically what it means, because that's what they wrote.
Right. So then taking your point for 6714, would that be applicable, since it does spell out specify a policy body?
Well, A and C do, B does not in 6714. See, 6714, right. See, it flips back and forth. Well, I would say A and C would apply to all policy bodies. B would apply specifically to boards and commissions enumerated in the charter, because that's what it says.
So there's a requirement for audio video, but not for the written document, the written set of minutes.
That would appear to be how, they wrote it.
Okay. Okay, so then that then sounds like there's a word for it when you. Okay, anyway, that brings it down to now whether there was a recording as required for a policy body made within, because the request included, I think the request included the. Let's see here. Nope. Only talks about draft minutes.
Right, but 6714C does say that the recording shall be available within 72 hours of the date of the meeting or hearing, and for a period of at least 2 years.
But the requester asked for draft minutes,
exactly.
which is not the recording.
Exactly, but in the future, at least, there is a way for a person to get the recording in a specific period of time.
Right.
Well, and even C is even more specific. I mean, if you really want to drill down, it says in a city hall hearing room. Mm-hmm. So if they're not having it in city hall, C may not even apply.
Well, there's an important or before it says or hearing open to the public held in a city hall hearing room. So I think it just includes the city hall hearing rooms in addition to regular meeting, special meeting,
I see
or
what you're
hearing.
saying.
But to get to the point here, I don't think. I mean, it's such a particular statutory creature. I don't think the 10 days can really apply here in this instance.
Well, I'm sorry to interrupt you, but what does apply is the city shall make audio or video recording available in digital form at a centralized location on the city's website within 72 hours of the date of the meeting or hearing, and for a period of at least 2 years after the date of the meeting or hearing.
Right, but again, if we discussed the original complaint.
Right. The complaint was not a request for the recording.
I mean, it's entertaining a hypothetical that they weren't able to respond to.
Right. So,
So since now going forward, since it was determined that this is a policy body, their recordings do have to go on the internet.
Yes.
Which the respondent said they do not put them on the internet now.
right. But that's not
not
an
part of this
issue
case.
here.
Right.
But,
Correct.
as far as knowledge of how this particular animal now is supposed to work, just like us, even though we self-impose something different, they're not required at that point. Okay, so how should we dispense with this?
Do we need a motion not to find
Need to-
violation?
yes.
So I move that we do not find violation.
Well, actually, the way we should do it,
We've been through this.
yes, we've been through this, that we assume that there's a violation and then vote it down.
And the person making the motion can vote against their motion.
Yeah.
I'm sorry, what?
We've had a lot of confusion, this is just procedural note. We've had a lot of confusion in the past. There has been some concern that if no motion is made, then the item dies. That's general parliamentary procedure, but with regards to being somewhat of a quasi-judicial, you got to find either violation or find no violation. The question is, how do you do that? Do you put a motion forward for stating that there is a violation, and then if everybody votes no, then it fails? There's no violation, meaning there's no violation. Okay? Or do you put forward a motion to find that there is no violation, and everybody votes yes, which means there's a positive finding of no violation? So it's somewhat semantical, but we have to find some consistency so there's familiarity and predictability for all the parties involved, including ourselves and for future Sunshine Task Force.
Okay, I think I must have just misheard you. I thought you were suggesting that if someone wanted to find that there was not a violation, that they would have to move to find a violation and vote against it. That's what I heard.
Right.
That is correct.
I don't like that.
Okay.
But I don't like that at all.
Okay.
I just think that if someone wants to move to find no violation, they should make that motion, and if it fails, it fails. If it
Okay.
passes, it passes. Likewise, if you want to find a violation, then you should, those are two
Okay.
separate.
I hear you. It was for a matter of consistency because it's created a lot of consternation over the years with different iterations of the task force. So I would suggest, let's get through it today. I think the Rules Committee should take up that issue. I'll put that before them so that there's at least it's written down somewhere so that people can see it and prepare themselves if they've never been here before, that they have some they can get familiar and understand it.
The bylaws say it could be either one right now, so maybe that's a good thing to.
Yeah.
Yeah.
Yeah, it's a good thing for.
And I agree with Member Kate. I don't like the idea of putting up a motion and then voting against that motion. And I think it's almost sort of a double negative.
Yeah, I hear you.
So
I would like I say, it's just been consternation with this.
Right.
And I don't care either way. It's just whatever everybody's comfortable with. But I think our job is to also make sure that it's not confusing for the public and city family.
So I would like to make a motion to find no violation.
Okay, moved by Member Canada.
I'll second that.
Second by Member Yankee. Any public comment on the motion to find no violation? He's not party.
Good evening, Robert Clark, the better half.
The more handsome one.
Yeah. I want to oppose this because I just want to remind you of a couple of things that I think were done on the sly in the last couple of meetings to get you to propose no violation. One, we remember when this whole thing started, the whole incident occurred because we were asking for the draft minutes, and we were told by the Art Commission that the city attorney had informed the Art Commission that the advisory committee wasn't a policy body. So that's why we came here, to get it established that it's a policy body, and you requested them to get information from the city attorney saying that it's not a policy body. So in effect, the whole time we were being lied to by the Art Commission, being told that it's not a policy body, and they had city attorney opinion saying it's not a policy body because you received the city attorney opinion finally stating that it is a policy body. So therefore, that was a lie right out of the gate from the Art Commission. And what that policy body that you said established, because it's not this advisory committee is not enumerated, you kind of had separation here. And therefore, what I'm saying is that at the last hearing, the Art Commission also came up and said, well, I don't think we record any meetings, implying that they didn't record any meetings. And during your discussion, you established that if there is a recording, and it takes a while for a minute to get up, that a recording can be considered, an audio recording, it can be considered an official record, so that information can get out to the public right away within 72 hours. And so we were, at the time when he requested it was already 10 days. Now, the Art Commission should have turned around to us and say, well, we don't have to do minutes and all that, but we do have a recording. And they should have immediately told us that we can't give you the draft minutes, but we can give you the recording. And they didn't do that. So that's why we asked for the draft minutes, because we weren't aware of this technicality that you guys worked out in terms of, is it minutes, is it recordings? But since they do have a recording, when we asked for the draft minutes, they should have turned around and said, well, we don't have draft minutes, we don't do draft minutes, but we do have an official recording that you can come down and listen to or get a copy of. And they didn't do that. So therefore, I'm opposing this, that there is no violation. I think there is a violation. I think that they're not only did they intend to misinform this task force by saying they don't ever record recordings when they've been doing it for years. They should have at least been aware of the fact that they should have turned around when we were asking for the draft minutes to tell us, okay, but we have the recording. Doesn't matter if we've gotten recordings in the past. They should have turned around and said, here, you can have the recording. You can listen to the recording. Instead, they made us come to the task force and spend all this time with you folks trying to figure out what is what and who is where, what's a policy. And I think that that's an important statement to make, that this Art Commission deliberately lied to this committee. They deliberately lied to us when they tried to tell us they had a city attorney opinion that it wasn't a policy body. And it must have been over a year, we were trying to get the city attorney to give us an opinion through the Art Commission. And we finally got it, and the city attorney said, yeah, it's a policy body. And so all I'm saying is that there is a violation here. They should have given us that recording. They should have told us that. And they shouldn't be lying to they shouldn't be lying to the task force, and they shouldn't be lying to the people who are just trying to get the information about what happens at these meetings. So I request that you vote against this measure, and vote it down and find the violation.
Any other public comment? Seeing none, members, any other comments? Yeah.
The speaker brings up a good point. Should we be considering 6721C, in that even though that information was requested, and even though that information wasn't required, although they did not know that at the time, that there was an alternative source of information that might have satisfied the requester's information needs?
Do you have are you making a motion, like a replacement
I'm
motion?
bringing it up for discussion.
Okay.
So
Member Canada.
I would not be opposed to that, but since my time on the task force, we've gone a couple of ways on this where if the complainant didn't specifically, ask for certain violations, we didn't consider it. And other times we have added additional ones. So I think we should try to be more consistent with that one way or the other. But I can see the point of the last speaker.
Anybody else? I know Member Kate has his thinking cap on.
Well, it's just that I remember when I kind of came in the middle of this one last time, and I was talking about something about similar to this, about whether or not there was a production of under the records provisions, and so I have that concern as well, and it's. I hesitate to suggest that we should try to be overly particular in a complaint when this is a forum that's usually not one where the complainants are represented by counsel. It's almost never the case, although we've got one coming up that's different. But you kind of want to get at the root of the problem and not at the labels of it. And now at this point I'm kind of a little turned around on what wasn't provided and what was. I agree with the provisions about the 10 days and the draft minutes and whether or not that ordinance section applies. But I recall having an issue, and I think this is the issue that's being raised right now about whether or not records that were in the possession weren't provided as a backup to the requests. But honestly, I don't remember the facts at this point on whether that's the case. If that was the case and that they didn't get information or didn't get help to identify the information, I would think that we should be able to we should find a violation of 6721C, whether it's from the assistance standpoint or the production standpoint. At that point, the facts I'm kind of.
So I'll ask the question again, is there a motion substitute? You can substitute the motion?
Just to me, I think
Come
that's a
Yankee.
good point. I'm not sure there's necessarily a timeliness issue as described in the initial intake form, but I absolutely do see that point that, obviously there might not be draft minutes, but I absolutely see the point that a recording that should exist within 72 hours, would certainly be something that the petitioner may very well be interested in. So I could see not a timeliness issue necessarily, but the violation under 6721C.
I would.
So is there a motion?
Well, I'd like to comment before there's a motion made. If it's okay. I think if you look at 6721C, it says a custodian of any public record, when not in possession of the record requested, which appears to have happened here, shall assist a requester in directing a request to the proper office or staff person. To me, that is not saying, oh, but there's another medium of the recording. It's no, I'm not in possession, but here's the person who may be in possession of the draft minutes. So that, if that's not what we're talking about, please let me know. But to me, that sounds like I'm not in possession of what you're asking for. This other person is. Not, I'm not in possession of this, but I am in possession of this other thing that also it involves.
Wait, it says the existence of. It doesn't. It says
Nature. Existence and nature of any records.
Yeah, you got to take 67C as a whole. You can't pick it apart. You got to start. It's in
from the
sequence.
beginning.
You got to start at the top. They're in record. Are they in receipt of the records? First of all, are they in custody? Well, they have been in past history. Okay, so there's some expectation for the public That's one point. The other point is that they must provide a response within 7 days following the receipt of the request. Did that happen? Or a statement as to the existence or the quantity or the form or the nature of the records. Form and nature, written or audio, or some other format. And then finally, when not in possession of any of that, shall assist the requester. So, Member LaHood makes a good point.
One more question related to that, just because there are so many details and so many conversations. Do we know when the audio was requested and received? And was that anywhere near the time of the original request?
The audio was not requested. It was the draft minutes were requested based upon precedent of previous meetings.
Right. And so the audio was received unrelated to this request.
I'm not sure. You'd have to ask the requester.
Can we ask the petitioner? When did you request the audio? When did you know of the audio's existence? When did you request it, and when did you receive it?
You know, I don't remember the exact date, but it was way after this. I filed my initial complaint, and things were prolonged over a period of time. I eventually requested a copy of the audio. So I'm sorry, I really don't know how long it was.
Oh, okay. It was so. It sounds like it was well after the initial request. Then I'd like to motion to find a violation of 6721C.
Okay. So what we're going to do to make this, because we have a motion on the floor, okay? So we have to dispense with that first. So. The question that you could put before, either we vote on this and the outcome is the outcome, and a subsequent motion could be made, or a motion to amend to substitute. And basically, it's kind of like a gut and amend.
I'd like to motion to amend and substitute the motion on the table to find a violation of 6721C.
Okay, is there a second to that?
I'll second that.
Moved by Member LaHood, second by Member Yankee. Discussion.
I'm fine with it.
Okay, great. Any public comment? Sure.
So this was at a subcommittee where you got to hear from both sides, and now you've introduced a new motion, and I have not been given an opportunity to respond to this new violation. So I do feel like that's kind of unfair. So, I mean, I have a few things to comment on.
I hear you. What happens in a subcommittee is preliminary to, because things can change once they come to this level. And it's happened many times before because either new information or a different explanation has come to light. Now here, since that subcommittee, we've gotten new information.
Right, but you've heard from not the primary complainant, but you heard from a member of the public in public comment, and then you decided to add an additional violation, which is fine, but I just feel like that was supposed to be public comment, and now you're adding a new violation, and I have not had the opportunity to speak, whereas he's sort of by extension, part of the complainant.
I understand.
Okay,
but
so I just
anybody else making a public comment is also, on whatever side that they're speaking in favor of is by extension at the same time. So I get what you're saying. I'm happy to provide you with the
I appreciate that.
To make some comments on that. Go ahead. Yeah.
Time
Okay.
frame on it?
Sure.
So give her 3 minutes, please.
So so Mr. Clark asked for the draft minutes, and I think that we heard an accusation that we lied and that we withheld a recording when we just had a CD waved around saying that he has, Mr. Clark, one, had lots of recordings at home and is very aware that we record these meetings. So I think that that's just categorically false, that we lied. And they do know, because historically we have recorded these meetings, that those are available, but they asked for the draft minutes. And that's the record that we thought that they wanted. We did not had they asked for the recording, we would have provided that. So I just feel like it's a little bit unfair because, we interpreted it specifically to the ask and provided the records when they were completed. Because we are not beholden to a 10-day time frame, they were completed after 10 days. So we gave him the records as soon as they were available. That's all I want to say. Thanks.
Member LaHood.
May I respond? To be clear, was not responding to any allegations of lying. It was purely a response to 6721C, which is that the custodian of public records, when receiving a request, if unable to respond to that specific request, shall assist the requester in identifying the existence, form, and nature of any records of information maintained by or available or in the custody of the custodian, whether just without reading the whole thing, other alternative information that may suffice in serving the information needs requested by the requester. That's what I'm responding to. And since there was a recording, I think that existed, and the custodian should have said, we don't have those minutes, but we have this recording. Would you like it?
Yeah, I would just say that, we're not paying attention to the rhetoric. I think what we're looking for here is to make sure that the process is correct. We have to be clear as to, because this was an unusual situation of now determining and finding out that an existing body is not what it had considered it to be prior to coming here. There are a new set of rules that apply to it, which kind of creates a bit of a kludge. So I think we're recognizing that, but at the same time, there still is an existing responsibility, and to at least comply with a request for a public record, whether it exists or not. If it's not in the possession of somebody, then to help the person find it, and there's the whole process of in the 6721 section. So I think that's what we're focusing on. It's just plain and simple with regards to that. It makes things clear now. It makes it clear that this particular advisory committee, what type it is. It is a policy body. It is not a board or commission. It can do this. It does not require it to do that. And moving forward, now the process is corrected and it's clear in the public's view. And I think that that's what we're seeking to try to do here, is to provide more clarity and so that people can follow it, moving forward. Remember, Kate, something you want to say?
Well, one of the things that, talking about the 6721 add-on and trying to help when possible or when needed, a petitioner to kind of get at the crux of the problem is one of the issues of trying to construe that kind of liberally is sophistication and experience, I think, in terms of whether we want to limit ourselves to the specific complaint identified in the complaint. And so, I guess, and this is me not maybe fully understanding, but I think I've heard something that maybe I have a couple of questions of Mr. Clark along those lines about knowledge of recordings beforehand, because I think if I've missed something, apologize, but if there was a knowledge and prior kind of history of requesting recordings before the complaint where we're talking about draft minutes, I think that actually is pretty relevant to know to determine whether we should actually extend the complaint to include this provision of records. I don't know if that makes sense. What I mean? Because I don't want to start. I don't think we should, always bend over. I don't say bend over backwards, but how far do we go helping someone, identify the problem of the complaint if they've got a history or they understand the ordinance very well, and they actually are identifying specific complaints as opposed to others. And I think that's a relevant fact, at least for me, in terms of voting on what I was initially expressing and still have, interests and concerns about.
So the not just the ordinance, but the Brown Act and the CPRA, it leans heavily towards the public's right to know. Okay? So and we've had some discussions and some struggles with around expediency. Doesn't matter how, when, what, as long as the public gets it, that's all that matters. That's one perspective. There's another perspective that we have this ordinance. It specifies how things are supposed to be produced. And so do we stick by the letter of the law, or just the fact that they're supposed to get the information, no matter how they get it, they got to get it. That's all that matters. Now, we have had some particular good debates about it. There hasn't been any conclusion. It really comes down to how we want to apply the ordinance in this way. I see you, Member Yankee, but I want to go back to Member LaHood's original premise for this, and it's really about the last sentence of 6721C. A custodian of any public record, when not in possession of the record requested, shall assist the requester in directing a request to the proper office staff person. That presupposes that you have to respond to somebody within a timely manner, whether or not you have it or not. So if Ms. Tricky didn't know whether she had the recording or anything, any form or nature of a record, she had a responsibility to respond within 10 days. Not to respond at all is, I think, Member LaHood's assertion is correct. Member Yankee.
Yeah, I was just going to respond to Member Kate's point. I think that's a good point. The only thing in this case, though, is they said that they had traditionally made these types of minutes, and that there was some type of, I think she's mentioned perhaps a staff shortage, and the minutes were different than what they had originally done. So even if he had customarily been used to getting these records, even the respondent admitted there was a change. And because of that, I think that may have been, in my opinion, a good point to say, hey, we have a staffing change. We're not going to be doing the type of minutes that we customarily have provided you. Remember, there's audio recordings available too. Because there was that change and that they've admitted to, I do think that they had an obligation to offer the recording as an alternate.
Anybody else? Yeah, I see this as a correction. This is a correction, and it had some kludginess in it, but I think the motion is correct. Okay.
Are we dealing with Member Kanada's first motion to find
So
no violation?
So what we're voting on now is to amend the original motion and to substitute to find in violation of 6721C. Any further comments or debate?
Yeah, sorry.
Member
I mean,
Tate.
I especially since, again, that the complaint was brought on the violation of 6716. Bless you. I feel if we think and believe that there's not a violation of that particular ordinance, that was actually the driver of the bus here. I mean, I think that the Arts Commission, I don't want to say entitled, but maybe entitled, if one were to the task force were to vote on that and believe this, entitled to, just as a petitioner is entitled to a vote on a violation. I mean, I think it's important to vote on findings of no violation whenever it's clear, as I think it is, that there's not a violation, with understanding, while you give and you take, that that there's a violation under 6721C, but that there was not a violation under 6716E or 6716 because it didn't apply.
I'm going to throw it back in your lap now. You said just earlier that, petitioners don't have the privilege of legal counsel with them. What they may be interpreting from the law may be incorrect. And that's really why we're here, is to determine whether, first of all, never mind what they think it is a violation, what section it is a violation of. Is it a violation of the Sunshine Ordinance? And that it's an interesting question because you can bring a case, if you, in court, and correct me if I'm wrong, if you bring a case forward and you're saying, I believe that there was a violation of this particular section of law in court, if you're a lawyer, I think it holds a little bit of different weight than if you were just a general member of the public trying to figure out what applies, what doesn't apply.
Well,
I think their first, at first blush, if they were to say, well, it's minutes, I'm looking for minutes. So there's a section in the code that says minutes, and it wasn't delivered in a timely manner, okay? And part of the complaint was specifically about timeliness within a period of time. And so I think it's somewhat inclusive of that because they're well aware. Forgive me, but these petitioners are well aware of the timeliness factor, okay? So I think it would, to me, it's somewhat implied in their complaint because they specified 10 days, that it wasn't delivered within 10 days. So the first question is are they required to provide minutes? The second question is, was there any response within the correct period of time? And I think that's for us to determine that under what sections of the ordinance were violated or not. And we've done that many times where we've said, you know what, not only did they do this, but they did that. And that's a violation of this other section. We do that all the time. So I'm just pointing that out as a matter of our past practices.
Sure. No, I get it. I think from the I feel like I don't know if a matter of fairness or I feel like the Arts Commission ought to be able to walk away today 1-1 instead of 0-1, and that just because of the way it was put in the complaint, and that's just my feeling. Then
I just want to reiterate their intake form. I requested draft minutes. Arts Commission failed to provide me with the draft minutes more than 10 working days after the meeting. I requested a public document. I didn't get it within the 10-day period of time. I think that's the thrust of Member LaHood's motion here. Correct me if I'm wrong.
Well, the thrust of it being that the assistance is supposed to be provided if the documents requested are not available, assistance is supposed to be provided in identifying if the information exists in another format or in the hands of someone else.
Right. Member Martin.
No, I'd just like to, I think, kind of add on to what Member Kate said, is that I think there's a sense of due process when you're arriving to a hearing, knowing what you're confronted with and what arguments to make. And I can see how if you're the Arts Commission, you show up and you just were not anticipating this turn, rightfully or wrongfully. But either due process goes both ways. So, if someone shows up and they say, I didn't know this was going to be an issue, this is a surprise, I'm not prepared, that's legitimate. That's a real issue. And, I think it can be, you don't have to have draft minutes, that's true. You also should have done a little more in helping this person obtain what they were looking for. I think both of those things can be put into motion. That's just some input.
Can we modify the motion in that way to say no violation and violation?
No violation of what? 16. If you want to amend your motion, you certainly are
Actually, I
free
think
to
Member
do so.
Kate suggested it, so if he wants to amend the amendment.
Well, whoever wants to do it, do something.
yeah,
Time is a wasting for
indeed,
other
yeah.
cases.
Absolutely. I would move to amend the outstanding motion to find no violation of 6716 of the Sunshine Ordinance and to find instead a violation of 6721C.
That's already on the floor. So just amending, not
making it clear.
Yeah. Okay. Okay. So is there a second to that amendment?
I'll second it.
So moved by Member Kate, second by Member Martin, is there any public comment only on the amendment to find no violation of 6716? Seeing none. Okay, I'll reiterate the motion that's on the floor. And so now, oh, I'm sorry, now we need to vote on, actually, we need to vote on the amendment that Member Kate made, and then we need to vote on the amendment.
No, it's one.
It is one thing now. It's an and situation. We are finding no violation of 6716, and we are finding
No, I know, but we have to approve these amendments first before we vote on. So this is wordsmithing. We have to approve the wordsmithing.
The original motion be withdrawn?
Yes. I can withdraw the original motion.
Well,
I think.
Well, it's now the amendment that's on. It's actually now the amendments on the floor. So everybody who has made amendments would have to withdraw.
Now,
Going backwards. Okay.
Yeah.
So we're going to approve Member Kate's amendment first, and then we're going to approve Member LaHood's amendments. It becomes now that amendment, and then we're gonna vote.
okay.
So we're gonna vote 3 times. Okay.
Times.
Member Yankee, right?
Yes.
Okay. Good. Have another parliamentarian in the room. Okay, great. Okay, so call the roll, and this is for Member Kate's amendment to find no violation 6716.
Okay. Member Kate. Member Kate, aye. Member Martin.
Aye.
Member Martin, aye. Member Yankee.
Aye.
Member Yankee, aye. Josh Wolf, absent. Member Tesfaye, absent. Member Kanata.
Aye.
Member Kanata, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Hinsey.
Aye.
Member Hinsey, aye. Chair Wolf.
Aye.
Chair Wolf, aye. The motion approved. The amendment passes.
Okay, so now the motion, a motion on the floor is an amendment to the original motion, and the amendment is to find a violation of 6721C and to find no violation of 6716. So we're going to vote on the amendment, okay? And then once we vote on the amendment, then we're going to vote. That becomes what will be the primary motion on the floor. So please call the roll. And so is Member LaHood who seconded?
Yeah.
And Member Yankee seconded it.
Seconded, okay. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Martin, aye. Member Wolf, absent. Member Tesfaye, absent. Member Kanata?
Aye.
Member Kanata, aye. Member Kate? Aye. Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland, absent. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay. So now we're going to take a third. Now the motion on the floor is now to find in violation of 6721C and to find no violation in 6716. And this will be the final vote. This is the actual motion. So
I made the original motion.
And I
No.
seconded the original.
Yeah, and you
Right.
seconded, okay, so this is a violation.
So, yeah, right. So we did an amendment to an amendment, then we voted on the combined amendment to approve the amendment of the original motion. Now that we've done that, it's been substituted. It's been gut and amended. Right.
So that would be Member Kanata,
Aye.
aye. Member Yankee,
Aye.
Yankee, aye. Member Martin,
Aye.
Member Martin, aye. Member Wolf, absent. Member Tesfaye, absent. Member LaHood,
Aye.
Member LaHood, aye. Member Kate, Member Kate, aye. Member Hinsey,
Aye.
Hensy, aye. Member Highland absent. Chair Wolf.
Aye.
Chair Wolf, aye. The motion passes.
Okay, great.
It'll be interesting to read
Thank
our
you,
minutes
everybody.
on this.
Maybe calling you.
Sure. Okay, let's call the next item.
All right. Would you like me to read the next four together, or how
Okay,
are we going to dispense
so-
this? Because when this was first heard, both the complainant and the respondent agreed in the complaint committee to hear all items at the same time.
Okay, so Member Martin,
Yeah, I mean,
do you want to make a recommendation for
yeah,
combining?
if it's okay, I would. I mean, if it's still okay with the complainant and respondent that we keep your complaints consolidated, that's up to you. I mean, they're each one. I'd like to proceed that way. I think it's more efficient. But
Well, when we combine them, it becomes one case for all of them. So you will have one period of time that is as per our regular procedures. It's not now, it's consolidated. So instead of four separate, it'll be one, and you'll have 1 5-minute period to present. You still okay with the combining? Okay. And the respondent? Okay, great. So we need a motion to combine these four items. Moved by Member Hensy.
I'll second.
Second by Member Martin. Is there any public comment on combining? Seeing no public comment, this is not substantive. Do you want to, is this considered substantive? Mark? Yeah. Is it procedural? It's procedural, okay. Can we take this by acclamation?
Yes.
Okay. Seeing no objections, these items are now approved as combined. Okay. So, Member Martin, do you want to give an opening?
Did you want me to read them?
Oh, yeah, why don't you read them? Okay.
Item number 9, file number 19019, complaint filed by Javad Mercedes against David Steinberg, Public Works, for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. Item number 10, file number 19020, complaint filed by Javad Mercedes against David Steinberg and Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. Item number 11, file number 19021, complaint filed by Javad Mercedes against David Steinberg and Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. Item number 12, file number 19022, complaint filed by Javad Mercedes against David Steinberg and Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. There's slight variations for each one of those complaints, but they all relate to Public Works. So that's why we separated them, just to let you know.
Okay. Well, we'll hear during the presentations what each of these issues are. Okay.
I think it's Mr. Mercedes trying to get access to documents that the city attorney's office, I believe, is kind of reviewing for the Public Works Department before they get to Mr. Mercedes. Okay, and they're either not producing what he wants or claiming litigation privilege for what he's trying to obtain. I know we saw him again, and we got an update, I think, on what was being produced, and
City Attorney's Office.
yeah, and it's Mr. Mercedes, I think, is still having issues with what is being produced and how much, and that it's going through an essential, almost like a doc review with the city attorney's office. So the Public Works, this is why I understand it, and we'll get some clarification. Public Works sends it to the city attorney's office for doc review, sends it back to Public Works to send on to Mr. Mercedes. And it's a question as if he's getting what he's supposed to be getting. And that's been going on for some time. And we found them public documents and sent it back up to the full task force.
Okay.
And I'm sure if I did not summarize that correctly, he'll let me know.
Okay, great. Okay, so we'll hear from the petitioner first. You'll have 5 minutes. Are you the respondent or the petitioner?
I am the petitioner.
Petitioner, okay, great.
Yes, sir. Debate and discussion so
Please
far
speak
has
into the
been
microphone.
fascinating, I tell you that. Very interesting. Section 67.21I says the city attorney office shall act to protect and secure the rights of people of San Francisco to access public information. My experience has been that the city attorney's action has been exactly otherwise. And they have interfered, slowed down, and hindered the process. This request was made, when it was made, DPW requested the documentation from IT. IT provided the documents back to DPW, and then DPW had to send it to city attorney for review. Number one, why do they have to review it? Their charter is to process and make sure everything is happening quicker rather than slower. So what happens is that the city attorney cannot read this document that is sent to them by Public Works because the format doesn't comply, or they can't just open it. It takes a month for DPW to convert these documents to what city attorney can read. And then right now we are in the situation that city attorney gets these documents, reviews them, and it's just redundant because DPW, the custodian of the record, they have been doing it for years, and they know exactly what to keep and what to disclose. Why doing it, city attorney? The question I have, number one, is what triggers involvement of city attorney to this process? If instead of Javad, this request was made by anonymous, would city attorney get involved? And if the answer is no, then we have two standards. One is standard with Javad and one with somebody else. And having city attorney review all these documents is just like having the fox watching the hen house. Or as I said it before, it's just like President Trump redacting Mueller's report before going to public. And I have received a lot of documents so far. And all these documents has been reviewed and God knows what with city attorney. So basically, I have been reviewing a lot of garbage. I mean, city attorney, there is the biggest question, I mean, there are a lot of questions. Why are they involved? What is their involvement? There is no redaction or anything. But the biggest question is the city attorney has no oversight. They can do anything they want to those documents. If there is a damaging document or anything that they don't want me to see, they can just simply pull it. And no one knows in this room or anywhere else. I tried to be as brief as possible, and thank you.
Thank you. Are any persons or witnesses provide any facts or evidence on behalf of the petitioner?
Yes, John Nadler on behalf of Javad Mercedes. And I just want to add some context and some substance to some of his comments. He had mentioned that he'd gotten lots of documents. There's still quite a few left, and it has been going on for months and months and months. And even the initial disclosure took several months because of the second layer of review by the city attorney's office. Also, there were some documents that they said that they no longer have access to because the employees have quit. This was subsequent to the request, and there was a notice given out by the city attorney's office to preserve all those documents, and under the code 67.29-7, they're supposed to make sure, I believe, the documents are available and preserved. So, second, the city attorney's office said that they were reviewing it for privilege, and then when I asked about other things, then they said, oh, well, we're reviewing them for relevance too. So there's not a clear answer as to why the city attorney's office is reviewing them. And under 67.27, if they withhold any documents, they're supposed to specifically identify the reason for withholding those documents. That has never been provided. They've never even said that they've withheld any documents. Lastly, Mr. Mercedes actually received a bunch, over 1,000 pages of corrupted documents, and we asked for that to be corrected, and it has not been done. And I would ask they said that they spend about 30 minutes a day reviewing documents. I would ask that that time is not reasonable. I would ask for, hour and a half, an hour, to double the time just to get out the number of documents. There still could be a bottleneck with the documents received from the city attorney's office, which may not make that practicable. So I would bring that up. And those are my comments. So thank you.
Thank you. Any other persons or witnesses providing any facts or evidence on behalf of the petitioners? Seeing none, respondent, you have 5 minutes.
Hi, my name is David Steinberg. I'm the custodian of records for San Francisco Public Works. So first, actually, I want to respond to a couple things that were said that are incorrect. One, we never said we didn't have access to emails for people who no longer work there. In his original request, Mr. Mercedes asked for records for 24 different people. Not all of them were Public Works employees. We don't have access to their email if they're not our employees. So there were, I think, 10 or 11 that were, and those are the ones that we've been producing. In terms of the corrupted data, we've told them about that. That's the form that the attachments were in. I have no way of recreating something that may or may not have existed at a previous point, but that's what IT gave us the information. That's what it was. I can discuss the 30 minutes a day if you want later. As far as what Mr. Mercedes said, calling the city attorney review redundant, it's a different type of review. I review things for personally identifying information. We take out cell numbers, personal email addresses, things like that. But the city attorney was doing a review for attorney-client privilege, and despite what he said several times, it wouldn't matter who made the request. It's not specific to him. On April 17, 2018, a letter went to, I believe it's 23 people, because Mr. Mercedes has initiated several lawsuits against the city. These people got a letter. I got a copy as custodian. It's a whole letter. They were told, you are not allowed to destroy or delete any things related to this case. And the template that comes to me as custodian, it says, quote, it is imperative that you alert the city attorney's office immediately in the event that you become aware of any related request for public records via the Public Records Act or the Sunshine Ordinance, so that the city attorney's office can review the materials, redact protected information, and coordinate the production of any response to such a request. That's a standing order that the city attorney sends out. So that's why we notified the city attorney's office. At the moment, in terms of the amount of time that we spend, I've talked to the city attorney's office, not at your request. There's someone from the city attorney's office here, but that's their litigation. I work with someone who's more familiar with public records. Once we hit a certain point, we invoke the rule of reason. He advised us that 30 minutes a day was a reasonable amount of time. I'm essentially the only person who answers public records requests for our department, although a coworker of mine is actually handling this because although his job changed when it first came in, he was still doing it, so he got stuck with continuing to work on this. Otherwise, I'm the only person who does it. We received last year 840 public records requests, which was up 11% over the previous year. Up to today, we've received 514 already. That's up 15% over the same period last year. So we're on track to hit about 1,000 requests. I take the job very seriously, and I take the limits and the deadlines very seriously. The average time for us to close in 2018 was 4.7 days for each request. This year was 4.8. Last year, the mean days to close were 2 days, and the mean days this year to close are 1 day. So I turn most of them around as fast as I can. When we had to send the stuff to the city attorney's office, we, when they went through the information and they checked for privilege and they gave the stuff back to us, in virtually all cases, we, once we got the initial ones, we released that information the same day to Mr. Mercedes. At this point, there were a total of, I have a minute, 30 seconds, sorry. The city attorney still has 2,167 documents. That's approximately 14,286 pages. To date, they have reviewed 56,645 pages. That's 6,099 documents. The total documents for this request are approximately 119,000 pages or 30,000 documents. So we're talking a significant number of things. I know Mr. Mercedes is uncomfortable with some of the things he's gotten back. He says they're gibberish or they're unrelated. Those were the search terms that he gave us. We can only search for what he gave to us. And in fact, we asked him to, we tried to narrow it and he refused, although he said at one of the meetings that he did, but he changed it. But he refused to narrow the focus. So we were working with what we got. He asked for, unfortunately, very common terms like PG&E, things like that. So that's what we have.
Okay. Thank you.
And as I said, there is someone from the city attorney's office here because you wanted to talk to them.
Okay. Thank you. Any persons or witnesses provide any facts or evidence on behalf of the respondent?
Hi, committee members. My name is Erica Crane. I'm a paralegal with the City Attorney's Office. I was at the last committee hearing, and I was requested to come again. I just wanted to speak. There has been a change in development. The City Attorney's Office does not have any more documents to review. They'll be all turned over to DPW tomorrow morning. So our review and our involvement in this process is essentially done. We were just reviewing documents for attorney-client privilege because there is a pending federal litigation that is happening in this case. And as Mr. Steinberg attested to, based on that litigation hold, we were notified that Mr. Mercedes had submitted PRA requests to the department, and therefore our involvement, that's how we became involved. So I'm more than happy to answer any additional questions, but I just wanted to alert the committee to the fact that our involvement is actually pretty much complete as of tomorrow morning. Thank you.
Very good. Thank you. Can you repeat your name again? Your name?
Erica Crane.
Crane. Thank you. Any additional persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none, members? So I have a question, Mr. Steinberg. Did you want? Okay. First of all, you stated that Mr. Mercedes had asked for information from like 23 different people. What he was asking for, from what I can read in his complaint, is he was asking for communications between DPW and those people that might be to or from a period of time between May 1st, 2015 and March 30th, 2016. It's quoted.
Yeah.
He gives a number of keywords.
Yeah, all communications, documents, disclosures, transfers, and exchange of information or opinion through any other means regarding these keywords. Keywords,
right,
with these people. Yes.
By, to, or from the following people. It doesn't mean that you need to go to those people and get the information. It's information that you would have in your possession already. And that would, like for instance, in an email account, you would be doing searches for those keywords, essentially. So I just want to be clear that based upon your previous testimony, that That's not what was asked for of DPW. Was
Well, actually, on the request 183875, it says all communication documents, disclosures, transfers, exchange of information, opinion, however made through any means regarding with these keywords by the following people: London Breed, Valley Brown, Iris Wong, Mohammed Nuru, etc.
I think it would mean the same thing. It's in your possession of information by those people. And from what we have, it's by, comma, to or from the following people.
Which request is it? Which complaint is that? Because he submitted four different requests. Actually, he's submitted a lot of requests, but
Yeah.
he's complaining about 4 of them. He's made 9 requests.
Okay. Well, I'm reading from our memorandum, but
which case number?
Let's see. Well, this is kind of consolidated because a memorandum was in noting the. Actually, no. Here. It's other means. Yeah. Okay. So 19022.
19022. Yes.
Yeah. It says here by, comma, to or from the following people.
Is that those are the ones that are specific people? That just London Breed, just Mohammed Nuru, and just Suzanne Suskin?
No, this one has London Breed, Valley Brown, Iris Wong, Mohammed Nuru, Fuad Swiss, John Thomas, Patrick Rivera, so on. Is a whole list of people there. That's in that one.
I see what you're saying.
In 19019.
Yep. No, I see what you're saying.
It says again by, to, or from London Breed.
I see what you're saying. I don't.
So, and then the third one, 19020, by, to, or from Mohammed Nuru. And the last one is Susan
Understood.
Susskind.
Give me just a half a second, if you wouldn't mind, because I have the next request. Receiver public records request, internal message, sorry. Following records. Because the original ones we actually had didn't say that, I believe. Let me look at what the actual original said. Extension, internal message. Let's try a different one. So 5.
Well, all I'm saying
yeah.
is that that's what's stated here as his request. So
Right.
I'm just stating that your testimony, it seems a little, if that was your sense of things, I could see why. We're not quite sure if that was the reason why it took so long.
No.
Because
we
you
would
were
have been
waiting-
we would have been adding a lot more additional terms actually in that
Right.
case.
Okay. So I just wanted to point that out.
Okay, thank you.
The second point is I mean, you made an interesting statement. He made this request of DPW as the agency.
Yes.
Would have it been more expedient to have pointed him to a specific people who may have the specific custodians of certain records that
In our
may
department, you mean?
Yeah.
No.
No what?
It would not have been more expedient.
It would not have been.
No,
Okay.
Centralizing it with me, and that's why the department does it, because,
Okay.
I mean, I've conducted trainings with people on what you're supposed to do, and basically it's send it to me because I know.
I understand that.
Yeah.
But
And by the way, I did find the original request.
Okay.
I know what it says in here. The original request that he made did not say by, to, or from. It said by the following people. The one that's actually, you can go on to nextrequest.com and you can see it, but the request that he actually submitted to our department said by the following people.
Okay. Do you interpret that to be something different than by, to, or from?
I mean, we took it to mean search for records in these email accounts. But as I said, we would have, I mean, we could add these additional search terms to a search. We would have gotten a lot more things that wouldn't necessarily have, I don't know if they would have gotten anything that was relevant.
Well, no, I guess the thing I'm a little concerned about is what you had stated in your testimony that you would have, that you don't have access to those people's email accounts.
Correct.
Okay? What I'm saying is that you don't need to have access to those people's email accounts.
If we received an email by this person that
by that
and we had it,
person to or any emails to or from.
Right.
Okay? By, it's just really all on your end.
Right.
You don't have to go out.
True. Right. I would say, however, that because it says that have the following terms in it, it would result in the exact same thing. If it had any of these terms and it also had Iris Wong, we would have gotten it.
Yeah.
If it didn't have Iris Wong, we would have gotten it. So I in thinking about it, it would not have changed the results.
I get you. I think he's trying to help in the query by you not getting all of all the emails from Iris Wong that have nothing to do with this case, okay? So by putting the search terms in, he's kind of helping you create and craft a query that will narrow things down to exactly what he's looking for.
Yes.
He's only looking for search terms with regards to those people.
Well,
that's how I read it. Being a database guy, this is what I
understood.
This is what I would do. The way I would read it, if somebody were to give me a work order, I would say, "Oh, you want me to find all the emails from or to these people that only contain these search terms."
Correct. So
I'm only
all I'm saying is I don't think because we search these accounts for those search words, whether a person that we didn't have access to had sent an email or not, we still would have captured them because of the search terms.
He's not looking for you. What this means is in the entirety of the Department of Public Works, he's looking for any information relating to these search terms.
Got it.
To or from, communications to or from these people in line. If somebody is not on this list, he doesn't want it.
Okay.
If somebody's on this list and those search terms aren't part of that message, he doesn't want it.
Got it.
That's what he's looking for.
And so I understand your point. And actually, we could still do because we're still going through all this
my
stuff.
My question is more about timeliness, how long this is taking.
Yeah, we could if we add these. We could do I could do a search for all of Public Works except for the people we've already run, with all of these search terms individually plus each name that is not in our department, and we could pull those, and there may be additional records. That would be more things, because we already are still working through all the ones we have, and that maybe we should go ahead and do that now. But it would pull additional records. It wouldn't narrow what we already have.
The point is he's asking for this, and if you're getting some because maybe of a query not written robust enough or what have you, then there is outstanding others. So what we're trying to help with is saying you need to look at a little,
and I
not necessarily broader, but a little more robust.
Right. I absolutely understand what you're saying, and we can certainly do that. That would not speed up the production of documents.
I get that, but
just so he knows.
In the end, the requester is looking to get the records. Yeah. Okay. Preferably sooner than later. Yep. But I think at some point in time he wants all the records. Okay, because for whatever reason he may need the information that's in there. Okay. The second point, I just got one more point. The second point, oh, never mind. I got the answer to that one already. Okay, Member Canada.
So also for you, Mr. Steimer.
Yeah.
I heard both you and I think the city attorney's representative mention going through these documents for relevance. I don't know what that means because it's the.
It's
the complainant who determines if the document's relevant to them. They should just get the document. I mean, you shouldn't spend time screening.
I don't. And that's actually been one of his complaints is that I'm giving him too much stuff that's completely irrelevant to what he's asking for. And my response is, if it has the search terms, I give it to you. I don't make a qualitative judgment as to.
But relevance was mentioned in the screening process. I just wanted to make sure.
My understanding is that the only thing the city attorney's office is doing is checking for privilege. That's what they've done. So as she mentioned, the last batch of them are coming to us tomorrow. So we will have everything, and we're working our way through them. To the point of how much time we're spending on it, at the moment, as I said, I'm the only one who's doing it, basically. I have 5 rule of reason requests at the moment. City attorney, we've talked, and these says if I spend 2 hours a week on each of them, that's reasonable. That's 1/4 of my time, and I have a lot of things to do. I'm trying to get help. One thing I know, Mr. Mercedes thinks that the city attorney's office slowed the production, but they actually spent funds and sent these things out to an outside firm and paid them to do the first cut and the first screening to try to speed them up. I'm literally doing all I can. We're spending time every day, every week working on these.
Okay, thank you.
Yeah. And I will investigate about doing those additional terms. That will extend the amount of time that it's going to take to get them all the records. But yeah.
All the parties are here. They're hearing it all together. So whatever you choose to do at this point. Any other questions, comments, clarifications?
I'd like to ask you, come up, Mr. Mercedes, if you don't mind. There's ongoing litigation outside in Superior Court, is that correct? Does it involve you?
Yes.
Does it involve the Department of Public Works?
Yes.
Okay. That's ongoing?
Yes.
I need to interject real quick to correct.
No, you can't. No. You can wait for a moment. We'll call you up. Let him.
It's okay.
He's addressing it too.
Well, to the best of my knowledge, the answer was correct.
Okay. And does it involve what you're requesting from the Department of Public Works?
Potentially, yes.
Potentially, yes. Okay. Okay. Thank you. That's all I
have
got.
a few items, clarification on general.
There's a rebuttal period. There's a rebuttal period. You'll get to come back up and rebut. And now, since you, all right, what is it?
Just for clarification, it's in federal court, and DPW was dropped from the suit, so it's only the city and county of San Francisco. Those are the 2 corrections.
Well, but the DPW is the city and county of San Francisco.
Yes, well, the city attorney's office disagrees with that. That they specifically requested that under the auspices that the Department of Public Works is a non-suable entity.
Right.
Yes, so that's the clarification I wanted to offer.
Yeah, any city department that gets sued is city and county of San Francisco. Right.
But it's nuanced, but that's the way the city wanted it. So.
Yeah, no,
All right.
we
But
get
it is in
that.
federal court. It was removed from city court to or Superior Court to federal court.
Well, congratulations.
Yeah.
Mr. Mercedes, can you come back up real quick? Has your information requested only been email? Is that what you're focusing on? You're asking for emails?
Emails or letters?
Okay, but correspondence, not building plans, not.
No.
Okay, that's all. Okay, thank you.
Yeah, it's. I'll read it. All communications, documents, disclosures, transfers, or exchanges of information or opinion, however made, whether orally, in writing, electronically, and or through any other means of communication.
Okay. And then okay, thank you. Is the city attorney office here?
Ms. Crane?
You got to sit closer.
I know. I like the walk, though. It's extra steps.
Okay. But to Mr. Mercedes' point earlier, if someone who lived out by Ocean Beach requested these emails as well.
Mm-hmm.
Would they again go through a doc review, or would they just get the correspondence?
So anytime that a city department is issued a PRA, they have the discretion to reach out to their advice attorney at the city attorney's office to ask for advice or involvement. As we've stated before, there is a pending litigation happening in this matter in federal court. The requester has filed 4 simultaneous discovery requests on top of these PRAs that also include these same PRA terms and requests that have gone to the DPW Sunshine for this PRA request. So it's duplicative. It's happening both in discovery and happening in...
Well, right, but I'm saying if someone else randomly asked for the same correspondence and the emails.
It would be the same question. If the department had questions about attorney-client privilege, which is really all we are involved in, they would send those documents to the city attorney's office, and it would go through the same
process. And how
process.
did it unfold here? Did the DPW receive something that said, alert, if you receive a request for any of these documents, be sure to send them to us?
So what they received is a litigation hold letter. So anytime...
From the city attorney?
From the city attorney, which we have to give out to the departments when we put people on litigation hold.
Before the request or after the request?
This litigation's been ongoing longer than this request came in.
Okay, so they had that
way before.
Letter before.
Right. So then when the request came into DPW, David Steinberg alerted our office per the terms of the litigation hold letter saying, if you get a PRA request, please inform us. And so then he therefore informed us that they...
But it's not requester specific. It didn't say if you get a request from the person who's
no.
a party, if it's someone else.
No, just if you receive a PRA request that deals with this litigation in any sort of capacity, whoever could have asked for it. It could have been Mr. Mercedes, it could have been his attorney of record, it could have been anyone. They would have still gone through the same process and alerted our office that they had received this.
Okay.
I have a question. So, based on when you say having to do with this litigation, there's a long list of people's names, and these people are involved in obviously a lot of things. And the terms in the request are, I mean, there's some specific terms, but some of them are very general. Right. If somebody else had come, to Member Martin's question, could Mr. Mercedes have asked someone else to file similar requests in pieces that would have been granted because they would not have been identifiable as part of this? Or are there enough things flagged here that it would have come up regardless?
All of these people have been put on litigation hold way before this case even came, even before this PRA was at issue. So all of these people are, if you want to say, quote unquote, flagged in the system. So if anyone had issued a PRA request, regardless of who it is, regardless if they're the plaintiff or the defendant, it would have been the same process. The department would have alerted us to say, hey, we've received a PRA request. It looks like it's in the scope of the litigation that's been pending, and therefore we needed to alert you and let you know that this was ongoing.
Yeah, so just to clarify, for example, any request for any communication, for example, from Mohammed Nuru, regardless of the search terms, is on litigation hold.
Mr. Nuru is on litigation hold for
anything. So if I asked for every email that he had that said sunset.
We have so many pending litigations happening in the city, so it might not be directly that my department is handling this litigation hold. He could be on litigation hold from some other case that some other department is handling.
So not just these keywords, I'm saying, for literally anything.
I don't know the capacity of every single person that's on litigation hold. I just know that these individuals are already on litigation hold.
So I can tell. I can tell you what I would do. As I said, I've received litigation hold letters, and so this I read you just the one part of it again from an April 2018 letter. It says, it's imperative that you notify this office immediately if you become aware of any related requests for public records, and that's based on what this lawsuit is. So my understanding would be, based on what the search terms were, which included synergy. I would have done it. I go through Mohammed Nuru's emails every day and go through and redact things and send things. The only times I would ask the city attorney is if I had reason to believe that they were related to something that we got a litigation hold on. So for example, the seawall, the navigation center that is the city's being sued to stop it. The city attorney, a different part of the city attorney's office has reviewed all of the
Right.
records I get about that because that was the subject of another litigation hold.
Right. I think to Member Hood's point, though, let's pretend that we were to piecemeal this out, and I were to just send a request for any email from Mohammed Nuru that had the word hate, just that. Would I get that any faster? I mean, would that sounds like that would...
that wouldn't, to me, it wouldn't flag anything that came off of.
Right. So conceivably, if these were
necessarily.
sent in different pieces, someone could perhaps receive them more quickly.
Well, I can tell you, if you ask for anything that the director got that has the word hate in it, it's going to take an awful long time
I'm sure,
to go
I'm sure.
through it.
Right. I'm sure,
That's been
yeah.
part of the problem. But if it...
That's
it-
H-A-I-G-H-T.
Yes, exactly,
yes,
yeah. As opposed to the one where I got anything related to human feces
Right.
or needles on the street or homelessness.
Or even PG&E for that matter.
That was a fun one.
Yeah.
But yeah, PG&E might have set off my spidey senses, but I don't know that it would have. Again, the letter from the city attorney's office is, here's the subject. This is the suit against the city. Here's the subject of the litigation. If you get a records request that's related to
So
this,
it's the combination
flag us.
of all these search terms together, but potentially
or
had they been submitted
subsets of them.
separately,
Yes.
maybe not.
Again, yeah, depending what they were. If they were just asking for PG&E or just hate, probably not.
Member LaHood.
Once documents have been reviewed, do they ever get stamped as like cleared for disclosure so you don't have to go through this process again and again every time somebody makes a request? Or is each request treated like a new thing?
Maybe.
Well, I think
the way I say that because we use Next Request, I get requests all the time for things that have previously been asked for, and I refer them. I send them a link because we published all of our requests to everyone, public can see them. I'll send them a link to that and say this is a duplicate of a previous request. Here you can take a look. Or in many cases, it is a portion of your request covered these items for this period. Please see this other request for that period, and here are the additional documents that cover the full span of what you're looking for, so that we don't have to go through this over and over and over.
And Ms. Crane mentioned earlier that if they feel like there's a need to have it reviewed, then they'll trigger the city attorney's office.
Yeah, there've only been. I'm trying to think of this more than two. This one and the seawall, the navigation center, I think are the only two that I can recall that had lit holds that I've had to confer with the city attorneys and had them review everything. There have been other cases where I've asked them to review certain things based on my own questions about whether certain things are relevant or should be released, or whatever.
And I just want to say one thing in terms of the question of relevance, because it seems to be coming up in terms of our involvement. We're not reviewing documents for relevance. All we're looking at is attorney-client privilege. So if there is a document that exists in this litigation that was talked about between the city attorney and the Department of Public Works that is attorney-client privilege, that is all we are looking at. I'm not looking at the content. I am not looking at what the words are. That is not our involvement. That is not our role. Our role is simply to look for attorney-client privilege and make sure that those documents are not being released, because we do have pending litigation. And they are being released. Just want to clarify one point. And Mr. Mercedes has received numerous documents in litigation. We have received discovery. So we are producing documents simultaneously in the federal litigation, in discovery. So it's not to say that only PRA documents are being produced. We're doing a simultaneous production of federal litigation, discovery, and PRA, and a lot of the PRA requests that are being asked of DPW are duplicative to what's in the federal discovery itself.
I get that.
Yeah, so.
But a lot of people do this because in preparation,
Absolutely.
and they want to make sure that if something gets overlooked in one, it's not in the other, or, they get a full record. I get that.
Yeah.
So, Mr. Steinberg, let me just ask you, aren't you qualified enough to determine whether a communication is of attorney-client privilege?
No. I do.
A message that's sent from Mohammed Nuru to Dennis Herrera?
In some cases,
you wouldn't flag that automatically?
I might pull. What I've done in the past is anything that goes from the city attorney's office to one of our folks, I put it aside and then I look at it a little closer. Where in cases where someone is just CC'd for informational purposes, I send them through. On cases where it looks like they're giving advice, I will either withhold them or I will ask a different city attorney, someone I work with, to review them and give me advice on whether. And in cases he said that's not they were just CC. That was an FYI. You don't need to worry about that. And so I will consult. But that's one of the things that I routinely look for is basically the tag that says CAT, which shows us from that office.
Right. So that's why I'm thinking about expediency here. I mean, how does the entire file have to be sent to the city attorney's office to look for attorney-client privilege, or on first blush you can separate out the ones that are questionable? There's these others that are pretty obvious, but then there's these another pile that are questionable that are much smaller.
I mean, I think she can probably answer that better, but I would say again, I got a letter that has that has the word immediately in all capital letters from the city attorney's office saying, "You notify us." So that's why I did.
I hear you.
So we, DPW had over 20,000 records that did not hit on a quote-unquote attorney-client privilege term. The issue that we have also is there's a high turnover rate in DCA's district in the office, and so someone who's coming in who's maybe only worked in the office for a year might not necessarily know district attorney, was there 12 years ago. And unfortunately, with the way that electronic data is stored, not all the metadata tells you that this is a city attorney or this is someone, that there potentially could be attorney-client privilege. So we withheld 11,000 documents, gave everything back to DPW, and that's all we looked at. So we didn't stall the process of them doing this rule of reason, rolling out documents that had nothing to do with attorney-client privilege. We were just reviewing for that. So I just want to... There's an expediency factor, I understand, and I understand that Mr. Mercedes is frustrated at the process and how slow it's been, but he has received over 45,000 pages at this point, and I understand that some of it is not what he deems relevant to what he wants, but if it hits on a term, that's what Mr. Steinberg and DPW...
That's many people's experience here anyway. They're going to get the full gamut of what they asked for, and it may be just one document that really is applicable. So it happens.
I mean, like I said, I would not feel comfortable trying to make any sort of substantive call on whether it's relevant. If it has the term, I give it to them. And to the amount of time we're spending, we try to go 30 minutes a day. As of the first hearing that we had, we were averaging, before the committee, we were averaging more than 40 minutes a day. At the May hearing, when we came back to compliance, we were averaging 31 and a half minutes a day. And as of yesterday, we're averaging 38.6 minutes a day. So we're actually doing more than the 30 minutes that we've committed to. Just FYI.
Member Kate, did you have something? No? Anybody else?
Would you consider this, I know you take a lot of pride in the process and the record, would this be an outlier as far as...
The amount of time it's taking, or not as much as it used to be. Okay. As I said, I now have 5 rule of reason ones because unfortunately sometimes if someone asks for every email related to this type of thing, his was actually easier because he listed specific search terms. That's much easier to do. It may be a lot, but if someone says, I want to know everything about curb ramps in the Sunset District, it's harder to have an IT search that I'm confident will get everything that they're looking for, but not be so broad that I have 40,000 emails to read, and may only give them 12 that they're actually looking for.
The only reason I ask is I think, or mention is because I think before you were citing this to say like, there's a 2.4 day turnaround or something like this, and this is not that.
No. And that's why Next Request has this cool little function where it gives you both the average and the mean. And so, as I said, our mean time to turn around this year is still 1 day, even though we have a number of requests that have been going on for a really long time, and our average is up a little bit to 4.8.
Anything else? Maybe later.
Okay.
I'd like to ask Mr. Mercedes. Mr. Mercedes, can you come back up?
Yes, sir.
So what right now do you want, you're here, what do you want to happen? What's the issue at this point? You've heard from them. I mean, what else?
Yes.
right? What do you want? What do you want?
First of all, the way I see the documents coming, I would have everything by year 2022. So come faster. Number two, I don't want gibberish. 1,000 pages of this and another 1,000 pages, they are about half a word per line. And this is one letter per line. And there are, for example, on one document I presented to you last time, we have 5 copies of traffic control specification for 622 pages. And the other one on really is important to me is to know the documents that have been redacted, by city attorney. I want a list of that. And in addition to that, the document that they think they're not relevant, I want a list of that. And I have a couple more items to bring to your attention if you want me to do it right now or come back.
Well, I think the other question I would have is so you're under the impression that, we've discussed this before, where they're supposed to produce the document even if it is just a blacked out page. So you think they haven't produced those to you?
I don't know. I have received a lot of documents. There are some redaction and there are some documents that are blank.
Because I think one of the tough parts is that, you're going to get a lot and it's not all going to be pretty and curated, but it shouldn't be a complete mess either.
I am okay with receiving a bunch of documents, which I have, and they are not relevant. As I said, 5 copies of traffic in 1,300 page, 622. It's okay. That's all right. I can deal with that. I'm glad that these are not in print, and I can go over it very quickly. That's okay. But, the important issue is to release it as soon as possible. And the other one is if it's being redacted or eliminated or anything by city attorney, I want a list of it.
Yeah, Member Lloyd.
We heard both from the city attorney's office and DPW that they are not searching for relevance. So it sounds like no documents have kept out because they were irrelevant, that you're getting everything that has the search terms except things that are being withheld for attorney-client privilege. I guess the question is because it's attorney-client privilege, is it possible to give Mr. Mercedes a list of those documents, or is he not allowed to get a list because of attorney-client privilege?
I don't know. I mean, Member Kate might know, but there might be a privilege log or something.
I mean, my recollection from the committee, and I think we've heard other people say this in the context of public records requests, that in records requests, the city, I think the city's across the board view maybe, is that privilege logs, which identify each document, the to and from, the subject matter, the basis for it being withheld. That's a litigation thing. That's going to come out for the request and litigation, but that in terms of records requests, that the interpretation is that that's not required at the city level in response to a records request.
And the relevance issue is tough, Mr. Mercedes, because they're going to produce everything that has your search terms in it, and you're going to have to decide whether it's relevant.
I have no problem with that. Even if it's 300,000 pages, I have no problem. They are doing a good job. That's fine. That's no problem. How many pages there are, how they are, that's fine. I have no problem with it. But, as the gentleman put the privilege log and redaction log, that's something I need. And another thing is that the gentleman just said there were 23 people originally on that list, and I was told that about 6-7 of them are not the employee, and another people are not current employees, so we don't have, like Fuad Swiss. Mr. Swiss was the city engineer, and they haven't produced Mr. Swiss's communication to me. And he was the city engineer for, 5, 6, 10 years. And other people, they just told me these weren't available to us. And I don't know why Mr. Swiss's, which was the city engineer, right after Nuru, his communication is not available. And the reason that there were 4 requests was that originally there was only 1, but then I was told these are too broad. Can you narrow it down? So I copied the same thing for 3 important people, and I submitted to them with shorter period. So request number 2, 3, and 4 are the same as request 1. However, prioritize hoping that I get those as they had suggested. And I shorted, I think, the duration trying to get those, but that did not happen. What happened was they provided just small portion of those 3 and they closed it. And they said we produced the rest of it as part of the original one. So the reason there are 4, that was the reason.
Okay, thank you. Thank you. Sure.
So to that point, the 3 additional ones that he submitted, they were identical to the broad ones, except he added each one was for a specific person, and he added 2 additional terms that weren't in the original request. So we ran a search for those 2 terms for emails that didn't contain all the other terms that were in the original one, because those were already being reviewed by the city attorney and us. So we were able to turn those around very quickly. So we gave them that subset, and so we were able to deliver them basically the same day that we got it from the city attorney's office. And to the point of the privilege log, yeah, your understanding of what we've been told is accurate. We've been advised by the city attorney's office that no privilege log is required, and we should not create one because Mr. Mercedes already requested many of the same documents through federal discovery. He will receive a privilege log through that process. My understanding is that the 2 sides are supposed to exchange the logs, and the city has created it and is ready to give it to him, but his attorneys have so far failed to produce theirs. So when that happens, he will get a privilege log based on the federal discovery.
Okay, thanks. And then I know you want to say something.
Yes, I was going to say on the privilege log, we're not asking for a privilege log. We're asking for justification withholding under sections 67.27. They have not said whether any documents have been withheld, which they're required to do if they're withheld. And on the subject of the privilege log, no, I have not received the privilege log. They have engaged in.
Okay, well, that's your federal.
Yes, I know, that's something different. We only recently requested this information as duplicative. They could have so the whole excuse only came up about a month ago about whether we had that. On the corrupted documents, the gibberish, that probably occurred through the conversion process that the city attorney's office requested, which was for their convenience, not for the convenience of Mr. Mercedes or the public. It was already in a usable format, PDF or the original format of the email, and the city attorney, for their own litigation purposes, converted it. So I just want to bring that up for that.
Okay, thank you.
And then, even if documents withheld for privilege, we would like a page saying it's withheld for privilege. In our other discovery, they've already done that.
So you're saying they did provide a list of withheld?
No.
No. At the federal, you mean
No.
for the case?
Yeah, I think
In federal document, in other discovery that was done many months ago that was not duplicative of this.
Can we not
Yeah,
conflate
right.
we are
Right.
not here to discuss what's happening in
understand
that venue, only in this venue.
Yes. And the attorney-client privilege part puzzles me because these documents were requested years before any litigation was enacted, and they shouldn't have had any reference to any attorney, and it should have been easy enough. If you manage databases, you can just search for the city attorney's address, and that would probably pull up any privileged documents that may have existed. And for example, they bring up all the pages. The contract.
Well, that's not necessarily true because there are so many different city attorneys, and in previous years before the city attorney had his own domain name, everybody is sfgov.org, so you wouldn't really know who's city attorney, who's not city attorney.
Okay, well, and then, for example, on the number of pages they brought up, some of them were like the original contract between Gelati and the city, which is 400 pages.
Yeah.
That was produced multiple times, and I bring that up only to show that you could have produced 4,000 of those pages in several minutes of just looking, because it's the attachment to the email, and you can tell that it's the same document. It's not going to be different. You don't have to look at every single page.
It's the only thing and maybe Mr. Steinberg will say this or not, I don't know, but if you had, for each request, for each person in there,
right,
if they were CC'd.
Oh, no,
or
no,
anything
that's
like
fine.
that?
I'm not saying it's relevant
Okay.
or what that, I'm just
Got it.
saying for purposes of producing thousands of pages, you could do that fairly easily.
Yeah.
And it would require very little time to check, is that attorney-client privilege? No, I'm just bringing up the timeliness.
I got you.
Not on relevance. They're bringing up relevance. We did not bring up relevance today at all. They brought it up. So that's why I addressed it now, only to counterpoint to them that we're not complaining about relevance. We're ready to accept as many documents as they produce.
Okay, thank you.
Thanks.
Mr. Steinberg, you're shaking your head.
Just one clarification. The city attorney didn't ask us to convert the files. What they asked us for were the original Outlook PST files. So the files that we gave them are the ones we don't generally use them. The stuff that we started to look at, which caused problems, our IT department converted them to PDFs. That's what we normally review. But for this one, it didn't work with their program to search for relevant terms, so they wanted the original PSTs. So anything that was gibberish, that's the way it was in Outlook.
Got all the metadata.
Yeah, and again, they know far more about this than we do. We don't generally deal with those sorts of things. I just have someone convert it, and I look at the information.
Yeah.
So
I can understand that. Microsoft does not make it easy.
No.
Yeah. All right. Is everybody satisfied with the questions? Yeah.
Sorry, I meant to mention this. Ultimately, you want to know how soon is he going to get the stuff. He wants to know how soon he's going to get the stuff. It wouldn't be till 2022. So we looked at.
Will it be by the federal case ending? I mean, by the time the judge.
I have no
issues
idea
an
when
order?
that's going to happen.
Or will the judge offer a continuance until you finish completing?
So we looked at it. We spent.
Because it's got to be the same amount of time as for discovery.
I would think.
Right.
Starting from when we started counting and when we started getting the information, we spent 44 and a half hours on it, documents produced, blah, blah, blah. Okay. Until I asked for the new IT search with those other names that you flagged earlier, if you eliminate those, we're looking at a total of 11,920 documents, however many pages, that should take about 39 hours to complete. That would be 15.6 weeks at 2.5 hours a week. If we find more because we add in those additional names, we might get a few more.
3.5 months?
End of the year.
Yeah. I mean, believe me, as I'm sure you know, if
Yeah.
he was showing you, there's only a few things. It's because it gets copied back and forth and it moves across the page. I have no great love of looking at those either, but again, we're looking for phone numbers and stuff like that. But yeah, if given the last dump that we're supposed to be getting from the city attorney tomorrow, it should take about 15 and a half weeks.
And to the question of withholding, are there any documents that you're withholding? Besides the attorney-client privilege? Well, you're redacting those.
We have redacted, sorry.
Or
Just to clarify really quickly, City Attorney's Office hasn't redacted any documents.
Oh,
We're
okay.
we're not responsible for redactions. All we've done is pull out documents that are attorney-client privileged.
Okay,
Those are the
so-
only documents that haven't gone back to DPW.
Okay, so is there a log of that? So that
Of what's
Mr.
been pulled?
Yeah.
I mean, we know what we've pulled, yes.
Yeah, but has Mr.
We
Has
are,
the requester been provided? You need to provide him what you have withheld.
we're not required to provide a privilege log, and that would be a privilege log. Because anything that we've pulled is
It's their-
attorney-client
Yeah,
privilege.
but that's in your domain. That's not in our domain. In our domain, it's public records that are being withheld. There must be.
Correct. I mean, we haven't now because we're still producing things, but we will include information that documents have been withheld on the basis of attorney-client privilege. Or
Yeah, but
attorney-client
it's
product.
not just a statement. It is what documents.
Maybe
are-
we're out of the room. The city attorney's office has told us that no privilege log is required, and we should not create one. And so
Yeah.
we don't.
I'm
and-
sorry, we don't. That we have never operated under the guise of a privilege log because all documents are considered public documents. So either they are redacted or they're withheld. And if they're withheld, the rules under Sunshine is that a log must be created for that. So if you're going to declare that the log is privileged, well, that's a different story. You know,
I mean, indirectly, the log is privileged because all the information that's being withheld is for privilege. I understand what you're saying, but what I've been instructed and what I've been told is that the city attorney's office is not required, nor is any PRA response required to produce a log of documents that have been withheld.
well, it's our ordinance. I haven't looked at CPRA, but our ordinance is pretty specific with regards to, I believe, with items that are withheld.
And
it would be under.
In terms of things that have been redacted, as I said, we have told.
Hold on a second.
No, just I think if there were, and I don't recall seeing a privilege log requirement where it identifies each document. I think it would live in 6727 if there were, on the justification of withholding part of the ordinance. Setting aside whether or not I think a privilege log-like thing would be good. I don't know that the ordinance necessarily requires it, especially when you've got where, and this is, it can create problems, I get it, but where we're withholding a universe of documents based on attorney-client privilege, as allowed by the state code and, actually the city charter as well, based on some of the cases that we've seen and discussed here before. Whether or not it's 1,000 documents or one document, if it's one document that you've requested and the city says we're withholding it due to attorney-client privilege, that could in effect be kind of sort of like I hate to say privilege log because a privilege log has so much more information, but it's a justification that specifically identifies the statutory and ordinance basis for withholding. Whereas if you have 1,000, are you supposed to say it? You're not supposed. You don't have to say it 1,000 times. Is I think the way. I assume that's the way that they're getting advised by the city attorney's office, and I think that the ordinance, arguably supports that. Because I don't see in 6727 a requirement that a privilege log gets be or something like it for each document be created. But that's my read. Yeah, Member LaHood.
Point of information, 6724 B2. Just to be, and I'd like to ask about this, says a record previously received or created by a department in the ordinary course of business that was not attorney-client privilege when it was previously received or created must be disclosed. Can we have verification that there's not any privileging of information that was previously not, that was
6724
6724 B, which is litigation material, and then
number 2.
B2.
Unless otherwise privileged under California law when litigation is finally adjudicated?
B12.
Oh, B12. Got it. Sorry.
Can we have verification that documents that were previously not attorney-client privilege have not been caught up in the attorney-client privilege material? That's a question for you.
That's correct. Okay. Anything that never hit on an attorney-client privilege term, and we ran all of the DCAs that have ever worked on anything related to from anything, has not been withheld. So.
Okay, thank you.
Yep.
That's helpful.
Okay, anything else? One moment.
You're looking to the chair. 6726, kind of in the middle of the paragraph, also kind of gets close, where it talks to information that is exempt from disclosure shall be masked, deleted, or otherwise segregated.
A footnote.
Released and keyed by footnote or other clear reference to the appropriate justification for withholding. I mean, in a sense, though, if there's a privilege log that's been produced in the litigation, and I know you don't want to necessarily overlap, and there's probably a lot of different things at issue in the request and litigation, but if there's a privilege log that relates to the complainant's request that is before us, that has been produced, that is a public record, and in that situation, I mean,
that's different.
That is
it
different.
Exists for a different reason.
It exists for a different reason, but it is. Okay.
You're going to have to speak in the microphone so it's on the record, please.
The privilege logs have not been exchanged because we're basing it on a mutual exchange of privilege logs between counsel, and that hasn't taken place yet. So it's not a public record because ours hasn't actually been produced to the plaintiff at this point.
Until it's exchanged, it's attorney work product.
Exactly.
Right.
So.
And that's protected. Okay, yes.
Yeah, I was going to say, so even though it's already been created and it wouldn't require extra work, I would say that it's already been created, it wouldn't do it. If it immediately becomes a public record, say tomorrow, when I call the city attorney's office and say, let's exchange privilege logs, are you saying now that it would then be immediately produced to Mr. Mercedes? What? Well, what I'm saying is they're saying, oh, it's work product, we can't disclose this. It's already been produced, so it should already be a public record because privilege logs, as far as I know, aren't privileged.
Hold on a second.
Or work product.
Being work product and being produced doesn't necessarily relieve it of its status as work product until it's approved by whoever the power may be or who is authorized to say that it can now be released.
I understand what you're saying, but I'm showing you that with that distinction, if I ask for it tomorrow and agree to the mutual exchange tomorrow, does it immediately become available to Mr. Mercedes?
Well, if you have it, then you have the document, then it's become,
Well, I'm just saying
unless the court says that you're not, it still remain privileged for some reason.
There are some other, so the trial date for the federal litigation is in January, and they're going to say it's going to take another 4 months. But I'm going back to the.
Is there a discovery order setting out the schedule of?
Yeah, the discovery closed July 1st.
And the parties are under an agreement right now on a date for mutual exchange of the privilege log?
No, because we have other discovery issues related that have not been resolved yet, and we are writing letters to the judge to resolve those issues. And that's what's pending before us because discovery closed on July 1st. So what I'm saying is the rule requires them, if they already have created this log, if they don't want to release all the information on a privilege log, they can at least release the number of documents that they've withheld pursuant to privilege.
You're talking about the city attorney or DPW?
City attorney or DPW, whoever.
Well, the city attorney said they haven't withheld any documents. Well, they kind of said they pulled the attorney-client privilege ones.
Yes.
Yeah.
And I just want a number.
That may not be possible.
Well, I mean, they have all the other information. I mean, wouldn't that be at least a basic issue of fairness, whether they're withholding 100 pages versus 50,000 pages? I mean, I think the rule makes it, that's at the heart of the rule, is to let you know. They just can't say, oh, we're withholding documents and we're not going to tell you how many, whether it's 10,000 or 1. I mean, it matters to the person requesting it. I'm just asking for fairness, that we should at least know the number of documents and pages. That's all I'm asking for. And they've already created a list, so they already know.
The privilege log that we're talking about in the federal litigation is not the same as all of the documents that were requested in the PRA. So what Mr. Nadler is referring to is a privilege log that he thinks is inclusive of everything under the sun under the PRA. We have not done a privilege log for the PRA. We have done a privilege log for litigation.
Right.
The documents might be the same. There might be an overlap. There also might be more in one and less in the other. I can't tell you that exact number because they're not created in the same way for the same purpose. So I just want to be clear about that because to say we can turn over a privilege log in exchange, mutual exchange tomorrow doesn't necessarily mean it captures everything from the PRA. It also doesn't mean it captures everything in the litigation.
That's why I'm trying to say not to conflate the two, because what happens under PRA isn't the same rubric as it is in court procedure.
Well, then why bring up privilege log at all? If it's so totally different, all I'm asking for is the number.
Into the
Yeah, but
microphone.
All I'm asking for is the number of pages and the number of documents they withheld.
I know, but under the PRA, under the sunshine, there's no requirement for that.
I think the rule would.
Show me. I mean,
I think it says
I mean,
it has to identify the reason.
Yeah, identify the reason, but
Yes.
doesn't, you're asking for, wait a second, are you asking for how many, or are you asking for the reason?
I'm asking for each reason, how many documents were withheld. So
there's supposed to be a footnote for each document that has been withheld.
no, I'm not saying I need to know. I'm not saying they have to say, oh, here's.
You know, I'm not going to bend
Okay.
what the law says, okay? The law, we operate under a rule of procedure, okay? If we have to follow whatever the procedure that's laid out by the ordinance. If the ordinance says that a document that is being withheld or redacted must cite a footnote as to how or why or some other citation of law, then that's what you get.
Well, then what you're saying is we just need to file another complaint when they come up with a reason saying they withheld this document.
No, that's not what we're saying. I don't think that's what we're saying at all. I think what Member Kate was, and correct me if I'm wrong, is pointing out. I was saying that I thought that there was needed to be some sort of a list of items that were withheld. I'm pretty sure that there's something in there that does say that, but there are, with regards to 6726, is it 26 or 27? 27. No, 26.
Then we're in agreement. I
It's
agree with you.
again, I'll just read it. It says, information that is exempt from disclosure shall be masked, deleted, or otherwise segregated in order that the non-exempt portion of a requested record may be released and keyed by footnote or other clear reference to an appropriate justification for withholding required required by section 6727 of this article.
I just want to clarify. I'm agreeing with you. Sorry, I misunderstood what you were saying before.
Okay.
So I'm agreeing with
Okay.
that. So I apologize.
Okay.
So okay.
All right.
I'm sorry.
Member Kate.
Another
Go ahead.
question of Ms. Crane. On the PRA side of the review process, has there been a hit report generated on the terms you're searching for whenever you're searching for?
Yeah,
there has been a hit report specifically to the open records request.
Yes.
Has that been provided?
The hit report of total that we've withheld for AC? No.
And so this document would reflect emails and communications or whatever that are otherwise responsive to the open records request. It's just that they've been pinged for possible privilege.
So when the initial cull was done of all the PST files, right? We'll start from the beginning.
Which are coming to you because they're
Directly.
responsive to the search terms?
The search terms, right. So DPW has run all of the search terms that Mr. Mercedes requested in his PRA request. Then those PST files came to our office, we loaded them into our database, and all we did was ran all of those PST files with all of the attorney-client potential search terms that we could possibly think of. We came up with a list. Anything that hit on that, we kept, we looked at, made sure that if there was, in fact, AC, we held it. If there wasn't, we gave it back. Everything that was segregated out of that, which was the first 20,000 documents that went back to DPW, we didn't look at.
Right.
We're not interested in. It has nothing. We're not involved in the process outside of that.
I guess, and I think maybe I'll just ask. I mean, the hit report of all the potentially privileged terms and the number of times they appear in this universe of otherwise potentially relevant documents, is that a public record?
No. It's an internal working product. And to be fair, a lot of the terms that hit on AC stuff could be anything that says confidential. That isn't necessarily a privileged document. That's going to be turned back over to Mr. Mercedes in response to this PRA anyways. So it goes to the level of it's also our work product because we're looking for things that are potentially work product and attorney-client privilege.
Just wanted to explore that. I mean, I think I agree with you. I mean, I'm blissfully in the middle of this too. And you know, I recognize, I get that. I was kind of getting there on the work product side of the HIT report. But I'm just trying to find a way, I mean, obviously I feel like there ought to be some kind of public record in there somewhere that would identify what's...
What I don't
but maybe there's
understand,
not.
so let me just try to brainstorm this with you for a second. Under 6726, there's a requirement that it be keyed by a footnote, okay? If the HIT report is basically saying this one is out, this one's out, this one's out, this one's out, isn't that what that is?
Well, the HIT report's not saying that this is out or this is in. The HIT report is saying here's the universe of things we're going to look at to see if it's privileged.
I see. So
it could be there'll be a lot of false positives or over inclusivity, and also there's going to be a lot of overlap because you're going to have maybe 5 lawyers and somebody on one email.
Right. So
and it's going to ping
I get
5
that,
times.
but the absolute result of that, when they finally say, okay, we're going to withhold these documents from that HIT list, can't they produce a report on that as compliant with 6726?
So the issue with that is what you're asking for is basically us to redact a privileged work product to then turn over what we've withheld for AC.
It's not privileged work product. It's a requirement under the Sunshine Ordinance to produce it.
What I can tell you what our practice is in terms of that. So the section we were reading, so we have to segregate them and push them aside and give them everything else. Whenever we release documents where we've redacted someone's phone number or attorney-client privilege, it's in our template response. It says, you know, we've identified documents. We're releasing them to you now. Some records have been redacted on the basis of personal privacy and cites a portion of the Constitution.
Do you notate which ones those are? And then footnote or key those particular ones? Because this is not necessarily the city attorney's job.
Right. No,
it says that the work needs to be done by the attorney.
Right. For the redaction purposes, the way Next Request works, anything that I redact, it has a little thing and it says privacy, and there's a little footnote at the bottom. It says this is being done on blah, blah, blah. So anything that I redact for privacy, it does that. If there were to be, not in this situation, but in another one where I had an email that I redacted a page and a half of it because that was a conversation between the city attorney and our staff, but the stuff below it, this is like, how do we deal with this? I redacted that for attorney-client, and the stuff below it, which was a conversation with an outside person, which I can't withhold, it had the exact same thing, where it has, this is being done for attorney-client, and it has the footnote. In terms of, if they're not giving me a stack of 2 documents or 100 documents or 50 documents, I have nothing to footnote other than to say we have withheld records on the basis of attorney-client privilege or work product, because there's nothing to attach it to. There's not a blank page.
Create one.
Honestly, I don't know what they are. I don't get them.
Yeah,
but
I hear you.
Yeah.
All right.
And personally, again, my practice is, if I have a case like this where I'm releasing documents every day or every week or every 3 days or whenever I'm doing them, each time I send the note, I include the withholding or redacting note with each message as I release them to people. And I think, honestly, the reason I don't believe we've done that to Mr. Mercedes on attorney-client, mostly because we're still producing. We will. I mean, he knows that we've withheld for attorney-client, but I don't know that we've told him that specifically yet, because we're still going through all the stuff.
All right. Thank you, Mr. Steinberg. We spent considerable amount of time on this now. I'm just wondering, can we move on with the process here? Is there anything? Okay, Mr. Mercedes.
One issue I brought that was
Microphone, please. Microphone.
Mr. Swiss and few others. Mr. Steinberg
So-
says we do not have those emails.
Uh-huh.
Mr.
Do you have any?
Swiss,
Do you think that they do?
I do not know. Mr. Swiss was the city engineer for a number of years, and I requested.
He was the chief engineer.
He was the city engineer. He's the chief engineer.
Yeah,
He is
okay.
number 2 after Mohammed Nuru
Got it.
in DPW.
Okay.
And his email hasn't been produced because they don't have it.
Okay, let's do one at a time. So, Mr. Steinberg, what's your response to that?
I have not a very satisfactory response, I'll tell you, which is when we got the litigation hold letter and when our IT department was informed, anyone on that list, their emails would have been frozen.
Mm-hmm.
So if the department had Fuad's email account at the time, it would have been frozen. It wouldn't have been deleted. And in fact, when I do other requests and I get a list of email addresses, it'll be john.smith at whatever, and other ones will come across as DPW lit hold _name, and that's of someone who has left the department. I discussed email with our IT people. I got what I freely admit is a very unsatisfactory answer, which is what happens to email accounts when people leave the department? No, it's not a short answer. The answer was, it depends. They don't have a consistent policy, or it has not been applied consistently. It's supposed to be that if someone is leaving to another city department, the old department is given 30 days to say whether or not they want to capture those emails. Otherwise, after 30 days, they go away. Some other ones get transferred to the new department that they go to. Again, I've been told it has not ever been consistently really applied.
I get 2 questions for you.
Sure.
What's your retention policy? And what's your backup policy? Archiving.
I would have to find out what our backup policy is because I've asked that question before and I've, again, gotten somewhat different answers. I don't have my retention policy here, but I know it.
With regard, because, for the type of work that you're doing, you may be required under federal law to hold certain information for a certain period of time.
Yeah.
Or under state law or some other regulatory thing outside of the city. So.
We revised, and I was in charge of this, revising our record retention policy. It was approved by the Ethics Commission and the Mayor and the Controller's Office and the Retirement Board, and I'm missing one, City Attorney's Office. March of last year. It is agnostic in terms of, it doesn't specifically cite email because email is a device, just like if it's a record that you have to maintain on this piece of paper, you have to maintain it. If it's an email that has a record.
Mr. Steinberg, I do this for a living, okay? I have backups of our entire server going back 2 months, and then it rolls
I can
over.
find out the answer. I don't know that, but specifically on the record retention, what part do you want to know?
Well, the question I have is when somebody says, well, the emails will disappear after a certain period of time, they don't really disappear because there's a backup somewhere. We've had cases before us where the order was to produce the emails and those backups were those archives were mined.
Our record retention policy says if something is, it doesn't speak to what you're supposed to do with emails, other than if it's a record, you have to take it out of Outlook, and you can't rely on Outlook to hold it. What it does say is if it's not a record, if it's a convenience copy, if it's transitory, if it's a draft, if it's not anything that's a record, you should delete it as soon as it no longer serves a business purpose. So we encourage people to delete their inbox and their sent box because we're running into problems where over a certain size it gets corrupt. People can't search it. We'll probably get to a point where we want to auto delete things in the sent and the inbox and telling people if there's something that you need to keep because it's a record or it serves a business purpose, you put it somewhere else.
So in the sent folder, you're going to set up auto delete for the sent folder.
We're looking to IT to do it with the understanding
that
that
you would be deleting original product.
It
wouldn't be duplicative.
With the understanding that if it's something that you are supposed to maintain, you need to take it out of Outlook, take it out of the sent folder, put it into another folder or put it into another system. It is the responsibility of the employee to take if you are supposed
That could
to
be everything. Just saying, they could just clear out their entire system within your retention policy, and no records would be retained.
Well, they'd be violating our retention policy. If it's something that they're supposed to maintain, then they'd be violating our policy. If it's
How do you
something
know
that's-
once it's deleted?
Well, because in this case, if he gets a privilege log that shows that there was an email because it went to 15 people.
Wait a second, but we're not talking
Okay.
about privilege log in federal court. We're talking about PRA here. There's no privilege log.
Something gets copied to 12 different people, 3 of them in a different department. You submit a request to 3 people.
Okay, that's one scenario.
Yeah.
The other scenario is it's one-on-one.
Right.
And that person then retires, and then his email gets deleted, those records. There's no archiving. There's no ability to track anything going back in time. That becomes problematic, when creating case files, to not have all the communications relating to the case in there. I don't know an attorney that would do that. Everything.
Actually, I've told the city attorney's office and the mayor's office. The guidance is to their employees that they should, on a regular basis, delete non-record emails that
are not applicable. I get it.
And that's all we would be telling the people as well. Anything that's a record, you need to save it, and you can't just leave it in Outlook and expect us to capture it in Outlook.
Yeah.
You need to put it somewhere else.
Okay, fair enough. Okay, have we heard enough?
Yeah. Oh, yeah.
I had 2 items.
Yeah. Okay.
Mr. Ford, in addition
So
to
we didn't get. So okay, go ahead. So we were talking about Mr. Swice, and what's the other one?
Swiss, there are other people also that I was just told we don't have their communications.
Okay, which are those other people?
I do not remember. They just, originally there were 23 people, and they told me, and I don't know, I have received about 6 of them or 7 of them, I don't know, but a lot of them, I received an email that we do not simply have those emails. And one of them that I just remember, he is Mr. Swiss, because he's a very high-level guy in DPW.
Right. So his response. So Mr. Steinberg just explained that if there was a litigation hold on those emails, that they're not producible.
Mr. Swiss is just like Mr. Neuro or Mr.
I know,
Keegan.
but if they have a litigation hold
on the entire
on those
That's
particular
not
on that
what-
particular subject, because it would have to then, what the idea is to protect. You're protecting information with regard, and correct me, lawyers, if you're protecting information that would be involved in litigation, and through discovery, that information then comes out.
That wasn't I was told. I was told we just simply, these people are no longer with DPW,
Okay.
and we do not have them.
Okay.
And the last item I wanted to say,
Yeah.
I have worked with public sector many times. Caltrans, Los Angeles, Nashville, Tennessee. One thing I learned, never use I don't have time or resources as an excuse. As public servant, we got to do our job, Mr. Steinberg. It has taken 6 months. I don't have time. Outsource it. Hire someone. Hire people. This is not an excuse, and I thank you.
Thank you, Mr. Mercedes. Okay. All right, folks. Anything else for the good of cause? Should we call for rebuttals? We've heard a lot of rebuttals already, but we finish our process by calling for rebuttal. The respondent gets 3 minutes for rebuttal. Then the petitioner gets 3 minutes for rebuttal, and then we'll go into deliberation for a motion.
Thank you. I really don't have much else to add other than to say, as I said, we as soon as we've gotten the records back from the city attorney's office, we're producing them as fast as we can. Again, for the shortened requests, we gave them back the same day. In terms of what we told Mr. Mercedes was we didn't have access to some people's accounts. Like I don't have access to London Breed's account or Valid Brown's account. I'm going to do another search and potentially pull up more records based on to and from those people. So otherwise, again, we estimate it would take about 15 weeks to produce the records that we have left to go through, and we'll get them to them, as fast as we can. Again, the person who's doing this is in a different job. It's not even his job anymore, but he's gotten stuck with it. In terms of getting new help, additional resources, that would be great. I would love to have additional resources. I think I said it at the committee meeting. Because I lost Jeremy to do this, I'm essentially doing them on my own. If the Board of Supervisors passes the budget and the mayor signs it, there's supposed to be a hire in the director's office. I can't tell you how long that is going to take, other than longer than it should. And that person, a chunk of their job is to help me with records requests, because I do basically all the redacting, all the complicated ones, and I do only have so much time in a day, and but I would love to get help, and with any luck, there will be someone who will be on board to help to a degree. That's all I got.
Thank you.
Thanks.
Mr. Mercedes, you have the last word.
It'll be short.
Okay.
So basically what Mr. Mercedes wants is all the documents as soon as possible. If they doubled their time to an hour, we could have it by the early September, 7.5 weeks. I agree with Mr. Wolf about the footnote on the withheld documents, and on the gibberish, they could actually point us to either who has it or let us see the original electronic document, which is, I think, under the rules. We can see it. We can arrange a time to view that. And that's basically it. And thank you for your time.
Thank you. I just have one clarifying question for Mr. Steinberg. With regards to those documents that were printed, were those printed from the PST file, or were those printed from the PDFs? The ones that had the quote-unquote gibberish in them? Or
those all came from the PST files. There were only one set that came from PDFs, and that was the first group of 11,000 documents.
Why were they printed from the PST file?
Because that's the format that the city attorney was able to use for...
You're providing the... Not them. The request is to you, not to them, to provide the...
Right, but I'm saying they weren't converted into a PDF. With the originals, which are PST, were so that they could do them, and then they gave them to us. And
in that format, in the PST format.
No, we can't release them
because the thing is,
So
generally when people are doing printouts of email, it's coming print from Outlook. In this case here, so you're not doing it that way.
So we received the PST files. We converted them back. The way that DPW produces documents is in OCR PDF format.
Oh.
Yeah. So that's the process of how PRAs are done.
So that's problematic. Why? Because OCRs are not foolproof. That's not the original document.
This is the matter in which they produce. I'm just telling you.
Again, this is not the city attorney's issue, and so you should not be. You must provide the original document.
But
so
we can't. My understanding is the TST file is not accessible either through any of the systems we use, unless
you reopen it in Outlook. That's how the PST file is created by Outlook. It's Outlook-specific file format. You then can open up that file in Outlook.
But the only way to get it to someone is to convert it into a PDF, because they don't have access I've given
Right,
message
print it,
files to people,
print.
and they can't open it because they don't have Outlook. So our IT people convert them into PDFs,
Yeah, but
which are viewable.
Yeah, but if you're using OCR, OCR is translating what it thinks it sees on a screen into words, and it's not foolproof. You are creating a brand new document that's not the original document. And that's problematic, because at the same time we're losing all the metadata. So if you print out an email, it'll have all the headers that are in the metadata, okay, in a format that's readable. If you're taking a PST file and then it's running it through an optical character reader, that's interpreting what it sees on the page, and it could spit out something that is incorrect or missing. Now I understand what he's saying about gibberish, because that's probably OCR not able to read something because of the quality of what it's reading from, because it's essentially reading it from an image. It's not reading it from the actual file, not reading the actual code. It's reading it from an image. Like, that's what we used to do with faxes in order to create an editable file, right?
Which were horrible.
Right. Well, this is the same process. So now I'm a little more concerned that he's not getting the original file. One of the key things that this task force did for the city way back when scanning first started was that they were not scanning things in as text. They were scanning them in as images, unsearchable, no metadata, not allowed anymore, because you're not getting the original, the full information of the document and the original document. So I'm a little concerned now about, what is being produced, and whether what he is reading on you may be producing the correct document, but what he's reading on the page may not be what is on the original document anymore, because it now has gone through the laundry. So I'm a little concerned about that.
I mean, I can check with our IT people. That's how I don't have the ability to do.
I understand, because generally what would happen is you get a list of the result from the city attorney. You go back to the Outlook and then print PDF or export to PDF in Outlook, because then you've got the original, you go back to the original email, and then you're printing from the original.
Outputting is what you're saying is outputting it as.
You can output it as PDF, or you could output it as and print it on paper and send it to them.
Isn't what's being done? Is that the PDF, the PST file, the Outlook message is being output as a PDF?
Yeah, but so forgive me, when you get the PST file, do you import it back into Outlook? No. See, that's the point. They're putting it into like a spreadsheet, right? It goes into a database format. That's what I can imagine. If it's not going back into Outlook, then you're not you're not looking at the actual formatted image anymore. In fact, what would probably be helpful for Mr. Mercedes is to give him the PST file, so he can see, even in a spreadsheet, he could actually see the real words and all the metadata that's in there.
I'm just no, I understand. I'm just thinking of the interactions I've had with other people. If I gave them a PST file, they would have no ability to.
Exactly.
They wouldn't know how to deal with it.
Right. So that's why, in order for you to produce the document appropriately, is it has to be back. That PST file has to go back into the program, the application that created it, so that it could render proper the way it's supposed to. So if I were to ask you for an email that I sent you on a particular day, and it's just one email, how would you produce that for me? You wouldn't, and it may be, and somebody else requested that, and maybe it had something to do with attorney-client privilege in it. You sent it over to the city attorney. You know, they said, oh, this is okay, you can release it. Are you going to, you know, get their PST file and get it converted and
this
all
is
that
the,
and print it out? Or
these are the only
going to go back
yeah,
to...
these are the only two times that I've sent
Okay.
PSTs. Generally, again,
Okay.
if I give our IT team the search terms, they pull up the PST files, and if there are too many, we try to winnow it down. Otherwise, we tell them to convert them, and they convert them all into PDF. So each email account is a PDF portfolio, and I move them all over, and I look, and I redact, and I release them.
How do you redact a PDF?
Depends. I can do it two ways. I can use it out of Adobe.
Adobe Acrobat?
Yeah.
Okay. Right.
Or NextRequest has a redaction formula, so I can drag the PDF into there, go in, identify what is, and it says for privacy, and it has the footnote and all that sort of stuff.
Okay. All right.
It kind of depends how big they are, and if if it has 40 replies, then I can do them faster in Adobe.
All right. I didn't mean to belabor the issue, but we're dealing with technology now. It's, you know, we want to make sure we have the right process in order to produce the right records. So
yeah, I mean, in that case, if the process that they're turning them into PDFs is not,
I mean,
saving the information the right way. I mean, what we probably would want to do then is basically, if they gave us the PST files back, minus the stuff that they pulled for attorney-client review, I would then give them back to my ID department, and they would convert those
imported back into Outlook, and
where
then,
they would then
that's
convert to
appropriate.
PDFs.
Right.
Again, as I said, there have only been 2 cases in the 2 years I've been doing this that
Okay.
we've sent the PST files over. So it wasn't something we came up
Yeah,
across
no,
before.
I get it. I get it. We were talking about preserving the original documents. That's all. That's,
understood.
That's the whole thing. Okay. All right. Thank you. All right. So we've gotten through rebuttals. Is there a motion? Yeah. Yes. We are here now.
2 hours.
I at the complaint committee, and you all here probably maybe remember, I expressed a little bit of concern about and not Mr. Steinberg's fault, but the 30 minutes a day aspect of this. And I don't think ultimately that it rises up to a level of violation on DPW's part that in certain massive requests, only so much amount of time can be devoted. But it does kind of inform me kind of about how some of the larger departments in the city may be understaffed in terms of dealing with or the city in general may be understaffed in terms of having complying with, you know, kind of more timely, you know, responses to records requests. You know, what is reasonable? I mean, under the circumstances, I think that we've heard today what Mr. Steinberg's doing. He's got things to do in addition to responding to the ones they can turn around in a day, the ones that may take 4 days, the ones that may take 8 months. So, I mean, I think probably that in this situation, I think the response has been reasonable under the circumstances in terms of the production timing, which I understand to be the key issue. I don't see any issues with withholding the documents. I wish there were a way that the city could explain to the requester, here's how many documents we have withheld. I think that's just a good practice. I don't know that I find it to be a violation personally. All of which is the long-winded way of saying I think I will make a motion to find no violation, but to refer it to the Compliance and Amendments Committee. Sorry, for a period to be followed up on at the call of the chair of the Compliance Amendments Committee or the chair of the task force. I don't really know how we do this, but I do think we should pay attention to this down the road.
Yeah, I think that if it comes to compliance and amendments, one of the biggest issues that I see are the emails where he didn't do the to and from, which eliminated a lot of the people. And that's only going to add more information and take longer. So, it's the give and take of this.
I would kind of overlook the 2 hours we spent, because if we took each one separately, we would have probably been spending almost the same amount of time anyway, if not longer, actually. Because usually give about 40 minutes per case. So I want to just focus back on the complaint, okay? Because that's where this all begins, okay? And so I want to make sure that we don't lose sight of Mr. Mercedes' original complaint, and because we've gone pretty out there in a lot of areas, and we want to make sure that we keep that focus. So as you think about what motion would be.
Well, just if I can, I'm inclined to agree with Member Cade, but I want to talk to to speak to you, Mr. Mercedes. You don't need to stand up; you can sit down. But I have empathy. It's frustrating. You're going through this process. You're trying to obtain these documents, and it's a lot of documents. Number one, right? And then you've got the added friction or layer of doc review from the city attorney's office. And both those, I think this, by the time we spent on this, I hope you recognize we think it's important. And, we empathize. We want you to get what you can get. But, they've, in ways, and it's easy to feel like they're against you, but they've been participating and they're trying to figure it out, it sounds like. And, this body isn't going to be able to give you everything you want, but hopefully it can provide some clarity. And it's tough. I just want to let you know that I feel that way anyway. But I'm inclined to agree with Member Cade that I don't see a particular provision to hammer them on currently.
Yeah, Member Yankee.
Yeah, I would just echo that as well. I mean, if anything, I think it just highlights the need for a broader understanding in city government that to have such a expansive sunshine ordinance and to get people what they want, that takes money, it takes resources. I think that's, to me, the message that comes out of here. But I think under the constraints that Public Works has to work under, I think they've been doing the best they could. So I don't really, or at least good enough to fulfill the requirements. I don't particularly see a violation. Although I echo what Member Martin said, that obviously we empathize, and I do think it's worth continuing to monitor this to make sure it continues along the path that it is, and nothing's left out by completion.
I mean, I really think I would feel the same way you do. It's like, well, they're not. Why isn't this being produced? Well, I got something, but it looks like gibberish, and well, they haven't responded to this. It's easy to feel that way. I get it.
Well, I have two concerns. One is there are people that Mr. Mercedes had requested to see communications from that it's not clear to me that he was told that these were not releasable for these certain reasons. We don't have necessarily the requirement of a privilege log, but we do have a requirement for items that are segregated to have a footnote as to why they were segregated, which means they have to be identifiable in some way, or by date, emails on this date to and from the client to the attorney have been withheld because of attorney-client privilege. I don't think that that's revealing too much information as far as a PRA, but in discovery, they can then ask for it in discovery. It's a completely different venue with different set of rules and requirements. But I think for the purposes of the interest of the public, I think that's important. I am concerned about these other folks that, and because of some of the suggestions that were brought up that Mr. Steinberg said he's going to be doing some additional work on as far as searches, I think that should definitely be monitored, but it has to be specific, okay? Because then a recommendation, if you're going to do it this way, then and you want to have it monitored, you have to be specific. Otherwise, it's just going to be an ongoing thing in Frank's committee.
Right. It'll be the
and there'll
same
be
as
no
this.
end to it, okay? Because, or until it doesn't matter if the federal court case ends or not. We have nothing to do with that. This is still a requirement under Sunshine. So I want to make sure that there's some parameters, time frame. Mr. Mercedes can be a little more specific. That could be taken up at the committee level to determine, what exactly. I don't want to take up more time here because they're going to kick us out soon. But, at least what exactly is still missing from the original that he still needed. So that way it kind of narrows things down because there can't be much more.
But I agree there need to be some parameters if it comes to compliance amendments, but how does he know what's missing? You know what I'm saying? Except for the people. If we get these extra documents from the people that aren't included in this one.
Well, I mean, you could start with that. I would say that's where your conversation begins, is creating a set of parameters, that works for the committee and that and does justice for the for the request and the process. That's all. I don't think there's enough time for us to figure what that out is here. I think it demands a little more deliberation between the parties. I don't think the city attorney's involvement is necessary at this point. I think it really comes down to Mr. Mercedes could say, well, this document that looks all gibberish. Well, I really need the original document, Well, what's the date on it? Mr. Steinberg can go back and look for that specific one, print it out properly, because there may have been something important that through the plaintiff's, their discovery and investigation, that there's something important about that particular document. Okay, you have that, okay? You take it on a case-by-case basis. But it shouldn't be like come back to compliance and amendments for each and every single item. It needs to be a full set of parameters that covers a gamut. And then time, will happen. Mr. Mercedes will request a hearing, or Mr. Steinberg will request a hearing, and then you can discuss a full gamut of things and not waste everybody's time. Does that sound reasonable? Does that sound reasonable? Okay. All right. So still need a motion. Yeah, we should.
In order for it to go to committee, do we have to find violation?
No, you can defer an order of defer a determination until a later time that the completion of the work is. I mean, we can do it that way.
I guess
the idea is to get Mr. Mercedes the information that he's requesting. Whether or not there's a violation, it's really a matter of facilitating.
Right, and I guess the thing I'm thinking about, and I'll go ahead and just withdraw my motion while we, is that the complaints are either ripe or they're not, right? I mean, and if we look at the complaint as saying, are they doing enough to satisfy their obligations under the ordinance to be working toward complying with it. If we look at it that way, then I think these complaints are ready for determination. But obviously, there's a production still ongoing. I mean, and so another way we could do it is not make a decision at all. But I mean, I think, what was it, 15 and a half weeks? I mean, we could try to come back to either the task force or a committee in 2 months if the complainant so desires. I mean, I just don't know. Not really sure what it is we want to do, because I think there's not a violation, or there's not a violation yet, and personally, and I don't know if we did a vote on finding no violation and it passed, then that's the end of the complaint. That's not with any kind of prejudice toward a follow-up complaint based on the final completion, whenever that may occur.
Well, that's the point of 6721, is to provide a completion. And if it's not complete, and we have heard some testimony here that there may be more,
right?
And they're only spending a certain amount of time, so there's an incremental rolling process that's still happening. The question is also based on that. I mean, what's a reasonable time for a request of this magnitude? For it to be completed? When do you then finally say that there's a violation or not? I mean,
I think the complainant has said that there's a violation now, based on the filing of the complaint, and there is either a violation now or there's not.
Well, that's what I'm asking. Is there or isn't there, based upon the information, the testimony that we've heard?
I make a motion to find no violation.
Okay. So there's a motion for no violation. Is there a second? I second. So moved by Member Kate, second by Member Martin. Does this include the monitoring? Doesn't include the monitoring. Okay. All right. Any debate on this motion? Member LaHood.
Forgive me, and we've been here a long time, so maybe I missed something. So if we find no violation, there is no mechanism for any ongoing oversight. So the motion is saying, let's just close it for now, and we'll hear back if there's an issue.
No, it means the matter's closed before us. The only recourse that one or the other parties have, if they are not satisfied with the outcome, is to file for a reconsideration within 60 days. And then we go through our process for reconsideration. Or they could file a new complaint. Yeah. Okay. The problem is we've had discussions around double jeopardy. Because if we've already ruled that there's no violation based upon all the entire gamut of all this, you can't then come back and file a complaint on the same thing again.
I mean, we're in a window of time. We've got a complaint that was filed in March, and maybe all of them were March, I'm not sure. But there's a window of time that says, as of this date, the city agency has violated the public records ordinance by failing to completely or in a reasonable manner timely comply with these complaints.
And why close the case if it's still going to be active? That doesn't make sense to me. If you're still concerned as to whether Mr. Mercedes is going to get all his records or not, then leave the case open, let it be monitored by the committee, and then if the committee, we do this all the time, if the committee finds that there's no compliance, then they report back and say, hey, the department is dragging its heels on this. Or they're not providing the correct or right documents, or it's not coming timely enough, or what have you. Not saying that is the case. It's just being conceptual, theoretical here.
I mean, that's a way to do it. Another way is to just take the complaints that are in front of us, say this is or isn't a violation based on the date of the hearing and all the information that's come to us. And if there is, I mean, the records request is still outstanding. That doesn't mean the records request procedure is over. It means the complaint is adjudicated. And so if at a later date there is another reason to file a complaint for failure to complete or timely complete the records request.
So then you have to be a little more specific as to finding no violation of what? Because then...
I find motion for no violation of section 6721.
So then if on these particular issues, if we're finding no violation, then he can't come back and then say that there is an additional violation for the same thing.
Why not?
It's double jeopardy.
But that's...
How's it not double jeopardy?
Because we're saying as of today, and maybe we don't want to say this, and that's fine, and we can vote down the motion, and that's fine. But if there's not a violation as of today's hearing on the complaint, then there's no violation as of today's hearing on the complaint. If there's a violation that arises from on and after July 16th, that's a new set of facts. But that's just my thought.
Okay. Member LaHood.
I have a question because I know there have been other situations where, there's a good faith effort that is happening and we have moved things to compliance amendments for monitoring. Has there always been a violation before that happens? Or if not, then how have we handled those before?
We continued it. I think
So
we
we've
handled it by
continued it,
continuing
okay.
at the call of the chair and have it sent to compliance and amendments for a period of time to monitor it. My concern here is that the complainant's already upset about the amount of the 15 and a half additional weeks. You're looking to cut that in half, and if we add these other new things in, what is a reasonable period? And we haven't been able to come up, and that's the issue that's causing the no violation, because it's a determination of, is the department doing enough in the time they've had it? And that's a tough one to pinpoint. So by sending it to compliance and amendments, I agree with Chair Wolf that there has to be really strict guidelines as to what is expected.
Right, and what I'm suggesting is that compliance and amendments works with the parties to create some solid parameters, and then it can live there for however long it needs to. I mean, we have done this before, where we now find that these documents need to be produced. Somebody withholds them, we find they needs produced. There's agreement among the parties to do that. We either find a violation or we don't find, we hold it open, we give it to compliance amendments, they come back, they say they failed, we recommend a violation now, or they didn't fail, we still recommend the violation, but they've complied, or no violation, they've complied, or whatever.
Just a quick question, I guess, procedure. It's a majority of the attending or a majority of the task force for a motion to carry?
Six.
I withdraw my motion.
Okay.
Yeah.
I haven't
Okay.
eaten today, so I'm getting a little testy.
All right.
If somebody wants to make a motion.
Okay. Yeah.
All gone.
Yeah.
Okay, I'll move that we continue this at the call of the chair, send it to compliance and amendments to come up with procedures to move this forward so that the complainant gets the information they're looking for.
Second.
I got it. You were going to say something else?
That's fine.
All right, so moved by Member Kanata, second by Member Hinsey. Okay, any further debate?
No.
Any public comment? Not parties, public. There's no
here.
public. Okay, great. Please call the roll.
Member Kanata?
Aye.
Member Kanata, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Yankee?
Aye.
Member Yankee? Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf, absent. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Kate? Aye. Member Kate, aye. Member Highland, absent. Chair Wolf?
Aye.
1, 2, 3.
Okay, thank you, folks, for your indulgence and patience.
Thank you very much. Thank you for your hard work too, sorry. And I apologize again for misunderstanding what we were doing earlier. So.
Okay.
Do we have quorum anymore? Yeah, I guess we still
All right,
do.
let's see if we can run through the rest of this real quick. Let's call next item 13.
Item 13, file number 19070, hearing to consider amendments to the Sunshine Task Force bylaws and complaint procedures. I just wanted to show online that we had posted them. They require a 14-day posting. I sent them to the library. They posted them like 10 minutes later. It's been up for 14 days, more than 14 days.
Great.
So that was the purpose of that.
Great, thank you. Member Hinsey? Lead this discussion?
Sure. In fact, hopefully Member King can help me because I don't have the materials in front of me. But I think
It's for the attendance
we
policy.
met a while ago and we created an attendance policy, which I thought we had gone over at our last meeting, but I guess we didn't. Do you want to refresh my memory here, Member K? You probably have it in front of you.
I have them in front of me if you want to. I'll read it out. So Section 2, Article 2, Section 2, under attendance, members of the task force shall notify the task force administrator and strike and this SOTF chair.
Oh, right.
Okay. And then continuing, if and add a member, then strike he/she. And then continuing, is unable to attend a regular meeting of the task force. Then add the chair or vice chair, acting in the absence of the chair, close parenth, will determine if the absence shall be deemed an, quote, excused absence, unquote, period. The task force, end of addition, continuing, administrator shall notify any member who misses 2 regular meetings in any 12-month period of time, add that were not excused, period. Continuing, if a third or subsequent add unexcused, continuing, absence from a regular meeting occurs, add in that same 12 months, continuing, the chair, add, or continuing, vice chair of the task force shall notify the Board of Supervisors of the member's lack of attendance. Is there any? It's kind of hard saying it like that to then read it.
So basically, the administrator is going to, members will notify the administrator and then.
Right. Instead of notifying the administrator and the chair, it'll just be the administrator first.
And then the administrator will notify the chair.
Will notify the chair. And then now we've added in excused absence. Question I have is, we don't really have a set of criteria for what is excused. And that's been the kind of a, do you have to produce a doctor's note, a plane ticket,
Yeah, we talked about a little bit of that in the Rules Committee and trying to come up with a list, and we were concerned that if we tried to come up with a list, we would overlook something if we said medical, and then all of a sudden there's a hurricane, or if it's weather, does that include an earthquake? I mean, there's a whole bunch of, so we decided, you know what, we voted in a chair and vice chair, presumably they would make a reasonable judgment. It's,
I mean, we've had this conversation several times in the past few years, and we've arrived at pretty much the same outcome every time, where like we try to define what is an excused absence, and then we just get to the discretion of the chair because we're afraid that we don't want to define what an excused absence is in the bylaws, in writing.
So one of the things that if we drop it down to parliamentary procedure, if the chair, makes an order or a rule from the chair or a decision as the chair, and the rest of the members don't agree with it, there's a motion that could be made called a petition to decision of the chair.
And we discussed that, actually.
Okay.
Right, that if we were, we think the chair is just going,
Right.
off by themselves, right, that there's a procedure that we can address it as a group then.
Right. I mean, it could be that, they don't consider the excuse to be real, and then the person who gets excused says, well, wait a minute, I've got a, parking stub over here, or I've got an emergency room receipt here or something like that. I would say that maybe there should be something in there that says that, something about an appeal process.
And
Yeah.
so this is why I don't think we should have to have anybody make that decision. I think people serve on this board. They try to get on this board. They want to serve on this board. I just think there should be a hard number. No decision by anybody.
That's the way it has been.
That's what I've been saying about this, since we started discussing it. It doesn't seem to be a popular point of view, but pick a hard number, 2, 3, whatever. If you miss 3 in a 12-month period, should you be serving on this? I don't, to take away any thought of somebody making a decision, and you don't know who the chair is going to be down the road. Why is the decision being made? Is it being applied fairly to everybody?
Yeah, we serve 12 days a year.
Yeah.
Well, that's not.
I hear you.
Not true. That's
I hear you,
many
but
meetings
Right.
and,
But
Yeah, but it only
but it
applies
only
to this,
applies to
this
the main
meeting.
to the
but
main.
sometimes things, work things, and
I
other
understand.
things
No, I
do
understand.
come
that.
up.
I mean,
So
I think it's fine the way you've written it. Only because how often, well, you guys know, this is my first time. How often does someone miss 4 in a year?
Well,
I've heard it used to be a big deal.
For many years, it was people would abuse
Yeah.
the attendance, and then there would be, people didn't want to act on it, So, excused absences, but the question is, we meet so few times.
I think the safeguard in there, I think it's in there that essentially 3 it's being reported,
and then it's up to the board of supervisors,
yeah.
right?
So,
I would
3.
I would say, it says,
it's 3. If you miss 3, it's reported.
yeah, I think there should be a number of how many excused absences people get. You already can miss 2. You can already miss 2, and they don't have to be consecutive. It's any 2 in the course of a 12-month period. 12-month period, not calendar year.
A rolling 12. So from the
A
first
rolling-
one you miss.
From the point of your appointment.
that's not what it says.
This is 2 regular in any 12-month
12-month
period.
So it would start
on a rolling.
on your first one.
Right.
It starts in your first one.
Yeah.
Yeah.
So,
Which really
but then
makes
you can,
it more stringent.
But then if you're going to add in excused absences without a number, people can ask for as many excused absences, and they doesn't apply to that too.
Right.
So I would say 1 excused absence if you're going to do that.
So then if they have 2 excused absences, you report them. Right?
If they
miss 2,
only one counts. The other one, it would be declared as a regular absence,
And then you would report it.
and then you report it.
So that's 3. So you would get 3.
You get 3.
Right.
So why don't you just make the number 3? This is what I'm saying.
Yeah.
Just really quick, I think that's what it currently is. I'm just curious, I'm not asking for names or anything like that, but I'm just curious, are we currently following that? Because I thought the issue was, there already is an attendance policy. I think it is 3. If
I thought it was
That's-
2 right now.
I
It's
think-
2 now.
Was it 2 and then
I thought
reporting
it
on the
was-
3rd?
2 plus.
It's,
I thought it was 2 plus 1.
the task force administrator shall
Excused.
notify any member who misses 2 regular meetings in any 12-month period of time. The original language, period. If a third or subsequent absence from a regular meeting occurs, the chair or vice chair of the task force will notify the Board of Supervisors for the member's lack of attendance. It does say here if there's a third or subsequent unexcused absence. Right, so unexcused.
I mean, this takes the existing requirement and creates an excused absence exemption.
Right. But how many?
As many as the chair or vice chair
Allows.
allow, is the way it's written. And
then that can create contention.
I have a question. So I've never met the person who is in seat 4, and yet they continue to be listed, and I've been coming for many months in a row. So what's the deal?
We have that has been like that for I don't
As long
know,
as I've
5,
been-
6
as
years.
long as I've been here.
A long time. The reason why is because it's not declared as being a vacant seat
And I don't understand why.
because we're not the Board of Supervisors. The
So
Board of
we can
Supervisors has
report the absences to the Board of Supervisors, but until they remove that person, they're in that seat.
Right. It's
that-
considered
is
named.
it-
I get it. I hear you. I agree with
So
you.
is that person, if they were getting health care through the city for this position, still getting health care through the city for this position?
That's a good question.
That is a very good. So,
Right.
all right. So here, okay. This is a different issue.
Yeah, right.
I will take this up. Okay, I get it. But let's get back to this. Okay. Do we want to? But I thank you, Member LaHood, for highlighting that. I appreciate it. Go ahead, Member Yankee.
I was just saying, so I'm just pulled up with what we currently have right now in the bylaws, and it says all the stuff, and then the last sentence says, if a third or subsequent absence from a regular meeting occurs, the chair of the task force shall notify the Board of Supervisors of the member's lack of attendance. That's what we currently have. So, I mean,
So you get 3 before you report
right.
it.
So, I mean, I don't know why it got referred to rules. That was my first rules committee that we considered it, but presumably it got referred to rules because this was in some way inadequate. So,
No,
I
people
guess-
wanted an excused absence.
So they wanted so I guess the question is what's written good enough? I mean, do we?
Well, no,
think
I
so.
think to Member Kanata's point, he's saying why bother even creating subjectivity over what's
Right.
excused, what's not excused. Just make it a hard number. If you want it to be 3, then just say it's 3.
Well, that's what it currently says. So
No, it says
Yeah.
2.
no. I mean, no, it says 3. It says if a third or subsequent absence from a regular meeting occurs, the chair of the
Yeah,
task force
at the third. Yeah, the third.
On the 3rd.
on the
yeah.
3rd it gets reported.
Let's report on the 4th.
Right.
Oh, okay, adding an additional one. Is
Yeah,
that,
if you're going to
If
add.
we're going to have an excused absence,
Oh, I see what you're
just
saying.
add an additional one.
Okay,
If,
so-
if you miss 4, that's a third of the year,
right.
right? Should you be doing this? If
Maybe it's not a good
you're
time,
not,
right.
If you're not showing up a third of the time.
So maybe we just keep the current language, which is, and just change, the part says the administrator shall notify any task force member who misses 2 regular meetings, change that 2 to 3, and then
Right.
if a third, make that a 4th.
Yeah,
I
exactly.
mean, and that just adds one additional, and that get rid of all
This is
subjectivity.
not meant as to add more complexity, but I think it may make things a little, if people feel a little uneasy about that, possibly say 3 consecutive and 4 in any 12-month period. Because if somebody's not going to show up for 3 meetings straight, don't belong, they need to go. That's, just plain Jane.
That's a 3-month vacation.
That has happened. It's happened with when we've had folks who've had illnesses, long-term disability illnesses that just can't, that kind of thing. We've had some elders where they were starting to not be able to make it in time. So, there are extenuating circumstances for some folks, but that's when it's possibly time to rethink your service, so.
Three consecutive, definitely, I agree
Yeah.
with that. And then add a fourth?
Yeah, and then just fourth in
Yeah.
any four in, and then, but three consecutive. I mean, then it gives, it lets you have a little more latitude, and people feel like they, then you don't have to involve any subjectivity, memberhood.
Are we, there were some other changes here, switching he, she just for member, which I thought was a good change. And then the question of the task force administrator versus the chair, or maybe that's not relevant if we go back to the original language, because it seems like there were other changes in here, and which of those were necessary or not necessary.
Right. So because if the last sentence is the actual authority of who makes the report, I kind of like the idea that I'm also contacted, the chair's contacted by the person in addition to the administrator, in case one or the other misses the email or the phone call, or there's always a backup in that kind of way. I just think it's appropriate. And so that the idea would be here is to put back in the first sentence and the SOTF chair, leave a member and remove he, she, strike the next sentence to the period. You can leave the task force administrator. Strike the whole second sentence until the period. Leave the task force administrator. Shall notify any member who misses, and then add 3, replace 2 to 3. In any 12-month period.
3 consecutive you were going to put, right?
Yeah, three consecutive regular meetings in any 12-month period of time, or an add, or 4.
Actually, 3 consecutive doesn't need in any 12-month period, because 3 consecutive happens in a 3-month period.
Right. Yeah.
So,
Right.
yeah.
Yeah, okay. So who misses 3 consecutive regular meetings or 4 regular meetings in any 12-month period?
Yep.
Yes.
Period. Remove that were not excused. If the fourth, so replace third with the fourth, fourth or subsequent absence from a regular meeting occurs. Yes, anything having to do with excused or unexcused gets deleted. We're not doing that. So if a fourth or subsequent absence from a regular meeting occurs.
Or you got to put in there if 3 consecutive occur, or a.
Oh,
or,
right.
Right?
If
Yeah.
a.
If 3 consecutive absences.
Well, we just said 3 consecutive absences. I think we want to say 2 consecutive in the prior sentence, because stage 1 is the task force administrator notifying the member. Stage 2 would be the actual referral.
Right.
So it's actually so the prior sentence should be 2 consecutive meetings or a third, and then the second sentence should be 3 consecutive and the fourth. Does that make sense?
Yes.
Okay.
So if a third or subsequent, fourth, a
Third consecutive or fourth.
or fourth in any 12-month period.
Yeah.
You with us, Cheryl? Okay.
Yeah, these minutes are going to be good.
Or for member Yankee will keep us straight with that. Or fourth subsequent absence in a 12 from a regular meeting occurs in that same 12 months. Is that okay?
Yeah.
Okay. The chair or vice chair of the task force shall notify the Board of Supervisors of the member's lack of attendance. I think we should add after vice chair what was in the above sentence, acting in the absence of the chair.
That sounds good.
All right, so that sound okay, amenable. This is about being fair, okay.
Yeah.
All right. No, we're gonna, is that substantive enough that we would have to repost them?
I think so.
It is very different, okay, then, yeah, we'll have to do that, okay. So, August. Okay. Okay, great. Okay, so let's get a motion on that to approve that language.
Motion to approve.
Moved by Member Martin.
Yeah, second.
Moved second by Member Kanata. Any public comment? Seeing no public, please call the roll.
Isn't it procedural?
It's substantive.
Yeah.
Bylaws.
If we're
All right.
Yeah.
if we're considering it substantive enough to post it in the library, we should take
All
a
right.
vote on it.
Yeah, and it affects people's service, their tenure.
Pen, okay.
Better safe than sorry.
Rodman, did you make the motion?
I did.
Frank, second.
We were going so well, too, with the first bunch of cases.
Member
I
Martin?
know, right?
Member Martin?
Yay, yes.
Member Martin, aye. Member Kanata?
Aye.
Member Kanata, aye. Member Yankee?
Aye.
Member Yankee,
That's
aye.
two.
Member Wolf, member testify not absent. Member LaHood?
Aye.
Member LaHood, aye. Member Kate? Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland absent. Chair Wolf?
Aye.
Motion passes.
Okay, call next item.
Okay, item number 14, reports from Sunshine Task Force committees.
Okay, complaints, anything to report?
Nothing too much. They've been going fine. I think we're switching dates, so we're meeting next Tuesday, I think on the 23rd.
We will meet on the 24th, and then in August, we will meet the third Tuesday of the month, so I will send you guys reminder notices, because this is new.
Yeah.
24th?
I don't know what
I
date
think it's
it
the
is.
I think it's 23rd. Is it Tuesday?
Next Tuesday.
Yeah, Tuesday.
Yeah, next Tuesday.
At
Complaints is
5:30. So,
missing.
and I know, and I know there was an issue of as far as consolidating, potentially at the committee level, how that we should not do that. Correct.
I thought you had said that to me.
What?
With
Consolidating.
Combining.
Mercedes
So
matter.
it should be a recommendation to the task force to combine, but you should hear each one separately to determine whether that should be in that way, because, sometimes members of the public get upset.
Okay.
Do you mean to do
They
that?
kind of wanted it this way.
I understand that. If they
In this
want it,
case.
if
Yeah.
there is overall agreement for everybody that they want to do that, that's fine, but make sure it's compelling enough for you.
Okay.
For the members, because you may not feel that, maybe that there may be something in there that you see that they don't.
Right.
That kind of thing. So I'll leave it up to your discretion.
Not that I want to waste more time, but I thought that we weren't going to hear more than two on any given night with the same.
These cases were so similar in nature that, there were different issues.
Right.
But they
It was a
were
guarantee
similar.
that they would be combined.
Okay.
Yeah.
All right.
So the thing is if you make the recommendation that they be combined, then when I put it on the agenda, it won't be that way.
Okay.
Oh, okay.
It'll be combined, because we're only going to have one hearing process.
So it'll be combined at committee if it.
No, you'll be making the recommendation to
so
the
it'll-
task force that
So
should
it'll
be
still
combined.
have 4 items on the agenda like it
Yeah,
did tonight. Okay.
right. And if you have this extraordinary circumstance where it's obviously 4 of them together, they're so
Right.
similar, you can do the extraordinary.
So if the committee makes the recommendation to combine, and there's 4 of them like there were tonight, and at the meeting tonight, the parties didn't want them combined, would we only hear 2?
I believe our process is that think our process is that would happen at the committee level. They would, if they, you want to make a recommendation to task force to combine, they would then have the opportunity
Objecting at
to
committee
object
level.
at
Okay.
committee level, and then you work it out there.
Okay.
You know, so that way we don't spend a lot of time here.
All right.
Yeah, try to get all those sticky wickets done in the committee level as much as possible.
Okay, so just so
Yeah.
that I know, are you going to be attending next week's complaint committee meeting?
I believe I can.
I think I emailed you about it, but I didn't hear. Just so that everybody knows, Chair Wolf and Vice Chair Wolf will be alternating
Right.
attendance on the complaint committee for a
That's
while.
the 23rd. Yes, I will attend. Yes, I have it in here. Attend this meeting in caps. Yes, I will be there. Okay, complaints and amendments?
Nah, nothing.
Okay. EOT? Anybody from EOT?
I don't think EOT has met since April, or May
Okay.
21st.
We got to give them
May
some
21st.
work to do.
Rules.
Who said that? Oh,
Rules.
rules.
Did you want me to mention the code of conduct?
Sure.
So the Ethics Commission sent us a sample code of conduct, and they asked us if we would like to adopt such a similar code of conduct. We had a discussion at the Rules Committee meeting. Member Kanata, and I believe Member Yankee were with me, and after the discussion, we decided that we didn't really feel like we needed a code of conduct at our meetings, as we were already sort of, none of the issues that are addressed in this sample code of conduct really come up on a regular basis at our meetings.
If I remember, a lot of it seemed to just restrict the person's right to speak.
Right, it was saying things like profanity and so forth, and we didn't think that that's really an area we wanted to get into, defining profanity.
It's not a
and-
violation of moral turpitude. So the thing about this kind of letter has some gravity to it. Why? Because there's so many signatures on it. So I don't think we should summarily dismiss it. I think it needs to be addressed, and also those folks want to appear before us to discuss it.
Didn't we discuss that, saying if they wanted to come to talk,
Yeah,
why not? I thought we
Yeah.
discussed that a bit.
Have to reach out, or I think we said that we're not going to make a formal proposal, but to refer it back to the chair to reach out or something
Yeah,
like that.
to reach out to them, see if they
Oh.
wanted to come and
Yeah,
talk.
to have this-
Right,
to have
so
further discussion.
So I invited them to come and speak in public comment. What I wanted to have here was a discussion of how to dispense with it. How should we process this request? Okay, that's really what I'm interested in knowing. I mean, now I'm hearing from you folks from rules folks, that you feel that it's not necessary. City staff has concerns. I mean, we have staff not showing up. And if that staff has, Ms. Tricky will not show
For what reason?
anymore because she feels attacked by every complainant that brings a complaint against her to hear. The whole thing around some of those other complainants that are have regularly have been disparaging and whatnot. They don't.
Sorry, I mean, I think that can be a real crisis if people aren't participating and buying into this process. That's a problem. And if they have concerns about the conduct in here, or when they're being heard, or if they're getting a fair shake, that's an issue because they're not participating.
I will tell you what we will hear next from is from their unions.
Right. So I would think if they want to present here or talk, I'm willing to listen to them. I mean,
Yeah.
that's half the, if we're not letting them come in and present, then we're just reinforcing the bias they already have.
I get that. I maybe some of you new folks have not experienced a real conflict in action in the room, where it's not physical but very verbal, and it's like, making either rude remarks against somebody else directly, and you can try to correct people and keep them in line and all that, but people don't want to be subject to that over and over and over again. Or there's fabrication, and then we end up having very long meetings because somebody feels like they need to be vindicated, and now we're dealing with that issue and not the issue at hand. And we really try to bring it back, and it just makes things not good. So there should be a level of decorum in some way. I mean, if you were in a courtroom, you could say, a lawyer can be, very hostile, to a witness or something, and it may be very uncomfortable for people in the room. But there is a level of decorum that needs to be maintained. It's not easy in this kind of environment. It's easier in a courtroom unless I need to start making certain statements at the beginning of every case stating this is what we'll stand for and this is what we won't stand for. We try to inform everybody to please make your testimony to the point of your complaint.
I think the only thing I've seen, and this is what I've been here since June of 2016, are when, and it's both sides, it's complaining, it's responding.
Yeah.
Start to bring in personal issues with the other person instead of talking about the case.
Right.
And I mean,
but I don't want to go down the road of limiting what people can say.
I hear you.
So it's
That's the balancing act here.
It's a balancing act. I don't know if any code of conduct will handle that. The chair. It's definitely the chair is. You can make a statement of let's stick to the facts. Let's not get personal about it.
Mm-hmm.
But I don't know. Other than that, I don't know what you can do. I definitely, if the people who signed this letter want to send people to come and talk to us, that's fine.
yeah, and I mean, one of the things we brought up was the chair's sort of the arbiter of, all things good conduct and decorum at our meetings. So we sort of discussed that the chair was sort of responsible for.
I get that, but not all chairs are, maybe familiar or experienced enough to be able to handle conflict in a public arena,
Right.
especially on. And you see, that's what we're trying to avoid. We believe in as much free speech as possible. We don't want to inhibit that kind of thing, especially since half our task force here are journalists that believe in free speech. We want to make sure that people have the right to be able to say what they say, and in fact, the ordinance does allow for public testimony to be pointed to specific employees almost at a whistleblower level. So, the question is when does it go? Where's the line? And I think there needs to be at least some guidelines. Doesn't have to be a policy, but I think there should be some guidelines created for a chair or for anybody else who feels like, okay, this has crossed the line. And then there be like the meeting stops, there's a recess or something like there'd be some process. So that way, as new people come on board, they feel like they have at least some roadmap on what to do.
I mean, I'm open to having these people come and talk to us and then having Rules Committee potentially take this up again. Once,
do you want
once we hear what these people have to say.
So do you want to return this to Rules Committee? We'll have those. You can have discussion there, and you can have like a little more casual, discussion.
We can.
I don't know. I'm thinking it would be helpful maybe for the whole task force to hear from the individuals and to maybe get for Rules Committee to get some type of guidance from the task force as a whole after we hear from them, and we can flesh out the details. But I think some direction on where the whole group feels we should go would be helpful.
That's what I'm suggesting. Is that they come and talk to us as a whole meeting, us.
Okay.
And then we go back. Yeah.
So we can have, there are two ways. We can have it, all of us, as the task force, or we can do as a committee as a whole, the Rules Committee, but as committees as a whole. We kind of convene as the Rules Committee.
That would mean everybody would have to go to an extra meeting.
No, it means just the Rules Committee actual members would have an extra meeting, but it means that will not be, it doesn't matter.
Would it happen on the day of our regular meeting?
Yeah.
Oh, okay.
Sure.
Yeah, I don't think it really matters.
Yeah, no, it happens. It's just that it's
Who
within the
chairs it?
rubric of the Rules Committee.
Yeah. So we
that kind
need
of
the
thing.
rules. Yeah.
You will chair it.
Yeah.
At that point. Everybody will be
Yes.
present.
Sure. Yeah.
Okay.
That sounds great.
That sounds good.
Okay. That's an appropriate use of committee of the whole. Okay. All right. So we will do that for the next meeting, and then
Okay.
send out invitations.
For the next meeting in August.
August.
Okay.
Okay. Nothing to report on. The only thing I'll report on information technology is that I heard back from Exegy, and they declined.
Oh, too bad.
And I don't know why they declined. I think the CEO was on vacation when they were having this discussion with me, and he deferred to their decision, so not to take it up. So we need an answer from the clerk's office on when they plan on hiring, on what their decision's going to be for either that, or we've got to now start using Legistar, if that's the system that we're going to be using. I think it's a little unfair to us, trying to keep track of everything's getting much more complicated. We need some way to search and create a taxonomy of our current orders of determination, so we're not, contradicting ourselves. And at the same time, we're not going down, reinventing the wheel. We don't need to do that. And I've tried to ask our legal counsel to try and do some of that. They will try the best they can to include in the memorandum if we've already have made decisions on similar cases, or to at least refer if they seem similar enough. But in order for us to do our own, we need to have it for our own, and it helps the public too. Public can see, if I bring this complaint forward, what's the possible outcome going to be? I think it's appropriate. It's very hard. I mean, there are services out there that will search PDFs. I know that between Member Yankee, Member Wolf, and I, we could probably, whip up some code and or find a platform that works. But if worse comes to worse, we'll do that. And then we'll have to wait for the city to tell us we can't do it. Or something like that. All right. Let's call next item.
Item 15, Sunshine Ordinance Task Force Chair's Report.
Okay, so-
This was about Privacy First Ordinance.
Right. So in last November, Prop B was the Privacy First Ordinance. There basically was that little clause at the end of that said that the Board of Supervisors can amend the Sunshine Ordinance as long as it doesn't interfere with the intent of the findings and purposes, quote unquote intent. we have no idea what that means. Nobody's explained it to us. The author hasn't explained it to us. So we really don't know what it is. There was a requirement that the city administrator produce policies in July that are supposed to be approved. The Rules Committee of the Board of Supervisors is terribly behind and backlogged. So I didn't get a response yet to find out. I didn't even listen to the meeting, what happened on the 11th. But supposedly they were going to just schedule it on the 11th because they've got ballot initiatives on deadline that they have to consider.
You're right.
So this is not a very high priority right now for them. Privacy First is specifically for a collection of data on by city contractors, that they can only collect the data that is within the contract and they cannot share it. That's what the meat of the law is about. The reason why they there are two potential reasons. Nobody will really say why that they put it in there. One is that if there is information that needs to be withheld, that the ordinance, it wouldn't be, if there was some conflict with the ordinance, that they could possibly amend the ordinance to put those exceptions in there based upon Privacy First, because it was a charter amendment. So that would, trump the ordinance. The other one was to provide us with some expediency if we wanted some change in the ordinance, like dealing with the vacant seat that, that doesn't show up, that we could do that. Advocates are resisting it completely. They absolutely will not agree, and they will show up here in force if we decide to exercise for the purposes of circumventing the voter-approved process to amend the ordinance, and want us to continue to support the amendments as what started here, essentially. So that's what I've got to report. I've asked for a meeting with Rules Chair Ronan and or her staff before this comes up, so we can review if there is any changes. I want to hear it, and want them to know at the chair level, and they'll invite the city attorney or the administrator or a representative on that. So I'll let you know when that meeting will start to happen. And then what I'll do also is on this issue with the vacant seat, I will finalize the report, the annual report, or the tri-annual report now, to the Board of Supervisors, and I will make that recommendation. I think that, it's needed at this point. If there's anything else that you feel are anomalies like that, that you want me to ask one of the things I am going to ask them for is a more fun budget. Yeah.
One other thing, and that came up today, this whole idea of new policies being developed where people just delete emails. So we heard about that today. That was very troubling. I understand that, they're trying to streamline their operations, but that goes counter to everything we are here for. We've heard this. What do we need to do to preempt policies like that being put in place?
I know when I left the city attorney's office, that's what they did to me.
Yeah, so first you have to start with state law, and you have to look at the retention policies or requirements. There are certain documents that have time frames on it. They can't be deleted for 6 years, or some can't be deleted for 2 years, or that kind of thing. That has to be researched. The question is which committee should do this work. This is a project for a committee. This is not the first time we've been down this road on retention. There are some orders of termination regarding this, but they were very specific to certain things. I remember when Sean Ellsburn, who's now the chief of staff for the mayor, when he was supervisor, he would be deleting his emails every 2 weeks, because that's a retention policy. But Board of Supervisors sometimes has different rules than everybody else in the city. So they're the legislative branch versus the executive branch, which is actually the business of the city. So it kind of has to be reviewed and researched, so there's a informed and well-constructed ask or request. So if anybody is, or committee is interested in, I would rather somebody take it up for their committee. Maybe every committee discuss it, but I think, because otherwise if nobody's going to do it, it's going to fall on me to do it. And I've got enough on my plate. So, one of the other things is, what was that issue that we were talking about before at the beginning of the meeting? One was the police records. I imagine at some point that's going to be coming down the pike. I wasn't sure if that was going to be in this case or not, so I took the chance to find out where everything was at in case they brought it up. Because once I saw the ACLU and Advancing Justice and all those folks in the police department, I figured, here we go. There's going to be something. So, but I imagine that's it, depending on what happens in the appellate court. That's going to be a thing for us. They're going to come hot and fast. We're going to start seeing a lot of it because there's resistance for that. The other thing was, what was it? This one. One second. This is the Hart's case. So I had asked, Ray Hart's had a complaint with us 2 years ago with the library. It involved the Friends of the Library making donations to the library. And under the ordinance, if there's any outside funding being being received by the city, and it's over $100, they have to report who the donors are and all that. So the Friends are very resistant to doing that. And so there was a very extensive advice letter from DCA Rusi about this. And at that meeting that we had, that former legal counsel for us, DCA Nicola, we had asked him what his opinion was on this, because we didn't see anything in a written document or memorandum from him on it, and he just said he agreed with DCA Rusi. The task force was not satisfied with that. We decided at the time that we were going to hold a special meeting on this and call in a third party. At that time, it was going to be the First Amendment Coalition's executive director, Dave Snyder, who used to be in Member Kate's seat. And he was unable to do it for several meetings, and then it kind of fell by the wayside. We got busy with other things. So I kind of lost track of it. But had since asked, tried to get our legal counsel to do an interpretation in respect to us, not necessarily within respect to, or to challenge or to respond to DCA Rusi's letter? Just on the face of it, what would your advice to the task force be? So I've been going back and forth with DCA Price Wolf and Thorine on this, and I'd spent about 2 hours having to kind of drill this down to the points at hand. And so I'm happy to forward that to you if you want to read it through, but I put this on the August agenda because it has to be closed. I'm trying to close every outstanding case that we have that goes back 6 months or more and trying to push those up into our agenda as much as possible because we really need to kind of clear those cobwebs out. And this is one of them. So you'll read what I have. We can include it into the agenda for the record, so that way it's, not ex parte or anything like that. But I think it's important, and I speak specifically to certain points in DCA Rusi's advice letter that I think are a conflation. So you'll see what that's all about. All right, that's all I have. Do you have any questions for me? Anything you want me to do or anything? Okay. All right, let's call the next item.
Item number 16, staff report, complaints and communications. So on Monday morning, I received a communication from Ms. Trabeau regarding the Clark Brothers matter, and she wanted it included in today's meeting, but it is outside communication, so Chair Wolf suggested that I include it with my staff report, so I'm going to pass this down.
It came after the deadline.
Yeah, it's Monday, so when I post everything on Thursday.
She used the name Anne Trabeau in this communication?
Yes.
She did.
Okay.
Yes, Anne Trabeau exists. I should also note that Anne Trabeau had filed a IDR with us regarding her cases.
I have a list.
Their second page.
And
I didn't know this. It's a couple of pages long. It's not.
Oh,
just,
it is a couple of pages long.
Yeah.
oh,
Hang on.
sorry. That's why it had such a big pile. I've been
like
working
it's
with.
It's all one
It's
page.
all on one
Yeah,
page.
it's all first page.
It's all first page.
It's all first.
You got multiple pages?
I got multiple pages.
I don't know how it was broken down. They were just looking.
Complaints against her is my last sentence.
Yeah, I've got, it's all numbered, at the bottom of the page is page 1.
No, I've got 1, 2, and 3 here. He has 1, 2, and
Well,
3.
you
Side of
guys,
the
you
table.
took,
I don't
you
need
took,
them. I only
all
have
of you
one.
took all the pages 2 and 3. That's
We've
fine.
got page 1.
We will,
Just
we
tell us
will,
if
we
it's
will
just-
trust your representation.
Yeah. All right, so Cheryl and I are working on a response regarding that.
Sorry, guys.
That's all right. And you'll see that shortly, once we finish it. But I responded to her by the day I got it, and then that a response will be forthcoming. So, all right. What else do you have, Cheryl?
Well, just looking at the report, tentative schedule hearings. I have EOT is meeting September 17th, their next meeting, but depending on what happens to compliance and amendments, I may ask them to hear some cases. We've, as you can see, in item number 2, petitions, complaints submitted, we have quite a few.
When is the next CAC meeting?
August 20th.
August 20th. Okay.
Cheryl, if I'm on EOTC on the 17th, I will actually
August
be.
27th. I thought you moved us to the 4th.
No, that's complaint committee.
No.
See.
Okay. You have to.
Sorry, you're right. I apologize.
That's all right.
Oh, so you flip-flopped us with complaint committee, it sounds like. Okay. And we're not meeting every month we're not meeting every month anymore.
We don't know yet.
Okay. We're meeting in August.
We're meeting in August. Yeah. But not if it takes this long.
Petitions and complaints submitted, hearing files created.
Cheryl, real fast, when was the next EOTC then? Is it
September 17.
third Tuesday or fourth? I thought it was
It'd be
alternate.
the fourth Tuesday.
So would it be
Yeah,
the
I did this
24th?
wrong.
Right, okay.
I did this wrong.
Okay, that's what I thought.
I apologize. So compliance and amendments should meet October 22nd, and complaints would be October 15. Any other questions?
Nope.
Just note for those committees that
I'll send
items
out-
have been referred to, read through number 4 in her report. Or I would say chairs of committee, read those.
Okay. And we'll figure out a date to schedule the rules meeting, either in August
All right,
or
we can talk about
August,
that
yeah.
in a few minutes. Pending petitions, Ms. Chabot has filed 2 new complaints, and she has several that are aliases, very much so. Pending petitions referred from,
Wait, let me just ask, did we approve the rule on aliases?
I believe we did.
Okay.
pending issues. Communications, we received a lot. I think I included that with the report.
Yeah, that, and under pending issues, that's 16117 will be on the August agenda. Okay, anything else for Cheryl?
Thank you.
No?
Thank you.
Yeah,
Thank you.
Thank you.
Thank you. Thank you. Thank you.
Any other further announcements or comments? Anything? Nothing? Okay, is there a motion to
Yeah,
adjourn?
Let's go home.
Motion, second.
Second.
That second
We're
couldn't come
adjourned
quick
by a
enough. I don't
rising
even
vote
know.
at
God.
10:10.
I think that
Oh,
Like 7 hours.
oh my.
Who made the motion to adjourn?
Me.
Frank, always.
Seconded simultaneously by everyone else.
Actually, it was member Key who said it first, but that's all right.
do you, Cheryl,
Hang on.
Thanks for your indulgence, folks, and
I
staying late.
think we'll probably put it in October. Because we're gonna do the committee of a whole in August.
Okay.
So I don't wanna,
Duplicate.
make them come twice. So we'll probably do October. Well, I'm on CAC, so,
It'll be on. Whoa. What happened? You okay?
Do you need some help pulling it back?
turn it on. Thank you.
Watch the dog.
That's right.
Okay. I was off.
No, you weren't.
There we go.
Oh, it's out. Good night. Bye, see ya. Bruce, I'll send an amended schedule out for all the committees.
Okay.
I'll do that tomorrow.
Let's go. This way? Yes.
I'm burnt. I can't.
No, you weren't.
See you later, Fiona.
See you later. So we'll put it in October.
Okay.
Just reading at those kind of philosophical, those kind of long discussions like that, but they're necessary at times. It's kind of, that's kind of where I really turn off. Can you turn the mics off?